Where they did does
I
not
post it
disclose-
along with the office objection.
Please,
2:30 ಹಾಕಿ.
please.
Yes, madam.
Tomorrow.
Why tomorrow?
ಪೊಲೀಸ್ ಅವರು ಮನೆ ಹತ್ರ ಬಂದು ತುಂಬಾ ಟಾರ್ಚರ್ ಮಾಡ್ತಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಪೊಲೀಸರು ಮನೆ ಹತ್ರ ಬಂದಿದ್ದಾರಾ? ಅವರು that is
ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ ಮೈ ಲಾರ್ಡ್. ಇದರಲ್ಲಿ ಯಾವುದೇ ರೀತಿ ಅವ್ರದ್ದು ಇದ್ರಲ್ಲಿ ಎಫ್ಐಆರ್
that's a usual scene. I mean a common scene.
ಮೈ ಲಾರ್ಡ್ ಕೈಂಡ್ಲಿ ಪ್ಲೀಸ್ ಅದು ಆಲ್ರೆಡಿ ಸ್ಕ್ರೂಟಿನಿ ಇಸ್ ಡನ್ ಮೈ ಲಾರ್ಡ್. ಪ್ಲೀಸ್ ಟುಮಾರೋ.
ನಾಳೆ ಆಗ್ತವೆ.
Matter Saturday, the 15th of practicing an advocate.
Saturday?
Saturday trial court ಅಲ್ಲಿ matter fix ಆಯ್ತು sir.
Monday, Tuesday ಬರ್ಲಿ.
Fresh matter.
Tuesday fresh matter.
Practice.
That's already
Jurist-
given matter.
Ah.
Yesterday. Given matter for yesterday. Having the representation of People's Act, section 139, having charged against, pending matters for tomorrow.
Why? What's the hurry?
Because he's practicing advocate at Supreme Court. The reason,
Supreme Court is closed anyway now. Don't worry. On Tuesday, yes. Give it on Tuesday. Fresh. It's a fresh matter, right? Fresh matter will come on Tuesday. Yes.
Jurisdiction,
Wait,
jurisdiction.
you can't come back this side. Yes. Or wait. Yes. Huh?
ಸೌದಿ ಅರೇಬಿಯಾದಲ್ಲಿ ಜಾಬ್ ಆಗಿದೆ
ಆಯ್ತು.
ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಪೆಂಡಿಂಗ್ ಇರೋದ್ರಿಂದ ಅವ್ರಿಗೆ
ಯಾವ ವರ್ಷದ್ದು ಮೇಡಮ್?
2016 ಮೈ ಲಾರ್ಡ್ಸ್ ನಾವು
16 ಇಲ್ಲಿ ಬರಲ್ಲ ಮೇಡಮ್.
2023 ಮೈ ಲಾರ್ಡ್ಸ್
23. That's all right. ಕೊಡಿ. Tomorrow ಕೊಡಿ.
Victim has been denied interim compensation in a POCSO trial, my lord, she's suffering from Trudeau.
Give it tomorrow.
376 offense, my lords. Notice has been issued, my lords, for the settlement, my lord. Now they have not come for settlement.
When do you want settlement?
My lords,
376 between whom?
my lords, she is 45 years old.
45-year-old. ಅದ್ರಲ್ಲಿ settlement ಹೆಂಗಾಗುತ್ತೆ?
ಅಲ್ಲ, my lords, consensual relationship.
Injustice.
Consensual relationship.
ಎಷ್ಟು ವರ್ಷ?
7 years.
11 years ಕೊಡಿ. ಅಂತದೆಲ್ಲ ಕೊಡಿ. Why tomorrow day after?
Because, my lords, Monday is my lords for the charge.
ಅದು Friday ಹಾಕಿ ಮೇಡಮ್.
Please.
Well, it's a fresh matter, so have you
Tuesday.
posted- Tuesday.
Fresh matter Tuesday.
Application seeking release of passport is rejected. He's traveling,
Why is it come here?
it's 482, I have challenged the order minutes.
ಆಯ್ತು ಕೊಡಿ. ಅದು Friday ಹಾಕಿ.
End of the list, Your Honor.
End of the list.
Yes,
Why, sir?
because 498, a petitioner was
So what?
80 years old.
So what?
ಹಂಗಾಗಿ
ಅರೆಸ್ಟ್ ಮಾಡಿದಾರ?
ಅರೆಸ್ಟ್ ಇಲ್ಲ, ಬಟ್ ಆದ್ರೆ ಕೋರ್ಟ್ಗೆ ಬರಕ್ ಆಗ್ತಿಲ್ಲ.
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಯಾವಾಗ ಸರ್?
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಗಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ.
ಆಗಸ್ಟ್ ಅಲ್ಲಿ ಇದೆಯಾ? ಟ್ಯೂಸ್ಡೇ ಕೊಡಿ. ಸುಮ್ನೆ ಅರ್ಜೆನ್ಸಿ ಪ್ರೊಜೆಕ್ಟ್
Urgency
ಮಾಡಬೇಡಿ. ನಿಜವಾದ ಅರ್ಜೆನ್ಸಿಗೂ ತಗೊಳಲ್ಲ ಆಮೇಲೆ. ಡೋಂಟ್ ಪ್ರೊಜೆಕ್ಟ್ ಸೂಡೋ ಅರ್ಜೆನ್ಸಿ.
Ethinawale matter, my lord, your lordship.
ಪ್ರಾಜೆಕ್ಟ್
It has been given 2 years back.
ಹಾ.
I filed application for vacation.
22 ನಾ ಅದು?
22, my lord. 22.
ನೆಕ್ಸ್ಟ್
Posted.
ವೆಡ್ನೆಸ್ಡೇ ಬರುತ್ತೆ.
Yes.
ಕೊಡಿ. ತಗೊಳ್ಳಿ.
After notice, my lord, next week.
ಯಾವ ವರ್ಷದ್ದು?
22 and 23.
Please give the memos. Don't stand to make a mention on pending matters. I know where complainant is not examined. Give it. Yes.
My lord, the petition has been convicted and matter has been pending since 2009, so
2009. Which ಯಾವ ವರ್ಷದ್ದು?
2022 is my lord.
22. Next Wednesday. Give it.
Not 23 pending.
Thursday. Yes. Yes.
Your Lordship, we have to withdraw the petition, my lord,
Wait.
because of.
Yes. Adjournment. Wait, sir.
Lordship, we have to.
ಬರ್ತಾ ಇದ್ದೀನಿ ತಾನೆ? Am I not hearing everyone? Yes.
We have to withdraw the petition, my lord, because of.
Withdrawal.
Charge sheet has
Thank
been
you,
filed,
sir.
now the
Kodi.
charge sheet has
Yes.
been filed, madam.
ಕೊಡಿ. ಯಾವ serial number ಅದು?
Serial number,
List 230 list ಮಾಡಿಸಿ ಮೇಡಮ್.
Reserved matter, my lords, jurisdiction under 482 for DV Act, my lords, proceedings.
The appeal remedy,
Oh,
29.
please,
What
please.
happened?
My lords, there are several other judgments. In fact, the Bombay High Court presently
Don't worry.
has referred to 5 judge bench.
Yes.
I wanted to make
You have not given anything. I have done my research. The judgment is ready. It will be pronounced. Don't worry.
compilation, in that even I'll file it.
Don't
this
worry
evening.
about it.
I'll file it this
You
evening.
did not give me anything. I have done my own research. Yes.
In fact, presently the Mumbai High
Now
Court
you are telling, sir, it's too late in the day.
coming up on the 18th. my
No
lords,
problem.
the Bombay High Court.
No problem.
Tomorrow, if I could kindly.
I have seen the Bombay High Court judgment also.
I'll anyway file my compilation by this evening or
No, sir. You can't do that. No permission denied. Yes.
kindly for this. I was not,
Permission denied, sir.
please.
Yes. No, you
I'll
can't.
ju-
One ವಾರ ಆದ್ಮೇಲೆ you can't do research and come and give it
Well, it
whenever
will be
you want.
only on
You should
Saturday.
be ready the day the matter is listed and reserved. After that, I will not take except written arguments or synopsis. If I have myself asked, I did not ask you to submit any judgments. So
Okay.
don't worry. we'll
If
do
I,
it.
in fact, will just this.
No, sir, you can't do that. That practice is wrong.
Please,
ಅವತ್ತಿನ ದಿನ ready ಇರ್ಬೇಕು with all the research. Either leave it to me. If you have judgments, give it or take my judgment.
I'll only submit the judgments.
Not necessary, sir. No, no, I will not. Permission denied.
Please.
Henceforth, you should, all of you should know, the day matter is reserved, you should be ready with all the research. Otherwise, I am not going to entertain.
Only the compilation was
Whatever,
not ready. We wanted to make.
It's
some
al- it's already,
submissions, that's
it's
all.
already more than 10 days, sir.
Last Tuesday it was listed.
With today's what?
Saturday,
1
we got
week.
this judgment of the Bombay High Court.
1
having
week,
referred
sir.
For 5
It's
judgments.
1 week, sir.
In academic industry.
No
we barely
problem.
permit.
No worries, sir. Not necessary.
Please.
I have seen that also.
My lord, the memo
My lord.
I just moved 2023.
One niche, I'll get back to you.
My lord, the offense is 406 and 420 with respect to shares, my lord.
So what?
The charge sheet, it's been more than a year, charge sheet has not been
Which year
filed.
matter is?
23, my lord.
Give it. Why are you waiting to make a mention?
Yes.
I will not take it tomorrow or at 2:30. Give it. Yes.
My lord, petitioners are falsely.
Which year, sir?
22. sir.
Give it. Yes. Don't wait for old matters. Memo, urgency idre matra kodi. Fresh Tuesday. Yes.
Urgency because the
ಏನ್ urgency? Arrest ಮಾಡ್ತೇವೆ.
respondent counter complaint has been stayed.
ಅದಕ್ಕೆ urgency-ನಾ?
Police are harassing that.
No problem, sir. Give it Tuesday.
My lord,
ಬೇರೆ ಏನಾರು ಗ್ರೌಂಡ್ ಇದ್ರೆ ಹೇಳಿ police
my
harassment.
lord, it's a Lokayukta matter. It came up once a notice was issued. After that, it's not come up, my lords.
No problem, sir. It will not come up for another 4 weeks. Yes. Next.
Filings-
Submission.
Don't give a memo, sir. It won't come up.
So
Yes.
it, I
ಏನ್
filed
urgency ಏನು?
in December, I filed.
Your Honor, this
So what?
petition number
Yes.
4 and 5, the practicing doctors, Your Honor,
Hmm.
498 case, Your Honor.
Why doctors should not be arraigned 490 days?
Not that they are practicing, the doctors.
So,
Your Lordship here, the police is unnecessarily they are harassing Your
ಅದು
Lordship.
ಯಾವ್ದು ground, fresh matter is it?
23 matter, Your Honor.
Give it next week, yes.
Please, Your Honor.
It will come on seniority.
Please, Your Honor.
Yes, yes.
My lord,
Now tell me what
my
is
lord,
it?
there is an interim order in favor of the petitioner. I've moved an IA for vacating that stay. The urgency is that petitioner will be relieved from her services in the next 2 months, my lord.
We'll see. We'll post it next week sometime. Yes.
Date matter is not listed.
Who gave the dates? Memo ಅಲ್ಲಿ ಕೊಟ್ಟಿರೋ date ಆದ್ರೆ that is not date. If I have given a date and not listed, please tell me. ಆ court date ಯಾವ್ದು ಕೊಡಿ? ಕೊಡಿ ಅದು ಯಾವ್ದು?
My lords, appealing for petitioner, my lords, petitioner has lost the complaint for kidnap, assault and attempt to murder.
Fresh matter.
Yes, my lords.
Tuesday. Yes. Enough now. Second list karbiಡಿ.
Much obliged.
Council submission. Bayaz, not there. Accepting, oh, ನೀವಿದ್ದೀರಾ. ಇದೊಂದು common order ತರ ಮಾಡಿ. Accepting the submission made by the learned counsel of the petitioner, office objections overruled, post the matter on 18th in the fresh matters list. ಇದು ಸೇಮ್ ಅಂತಂದ್ರೆ ಅದೇ ತರ ಮಾಡಿ, ಡಿಫ್ರೆಂಟ್ ಇದೆ ಹೇಳಿ.
Petition number. Office objection number 464 filed my FIR alliದೆ, charge sheet ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ, charge sheet ಅಲ್ಲೇ delete ಮಾಡೋರು.
ಏಳಿದೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್,
Only for office objection.
ಏಳಿದೆ.
ಅದೆಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರು, only for submission. 460 for FIR ಅಲ್ಲಿದೆ, charge sheet ಅಲ್ಲಿ 464.
Learned counsel for the petitioner
Only-
submits all the office objections are complied with except the one at serial number 5. The one at serial number 5. Accepting the submission serial number 5, the office objections are overruled. In the event all the other office objections are complied with, list the matter for fresh matters list on 18th. Yes. Yes, Latif.
Doesn't survive. Doesn't survive.
ಯಾಕೆ?
B report has been filed again.
The learned additional SPP on instructions would submit that a B report has been filed by the prosecution before the concerned court. In that light, the present petition in the form that it is pending would become infructuous, reserving liberty to the petitioner to avail of such remedy as is available in law.
First list. Sorry.
Sorry, madam. And second list ಅಲ್ಲ, first list ಅಂತೆ. ಇದು ಲತೀಫ್.
But the name of the petitioner is wrongly mentioned.
Same. Madam, same. Yes. Next.
In this case, I am for the petition. The address of the petitioner is fully
Accept, same.
18.
18th,
Please.
all 18th, yes.
Please.
I'm the prosecute counsel in this matter. Kindly have it next week, ma'am. Some inconvenience to on record counsel.
Same.
Please.
Overruled, posted on 18th, yes, next.
Public.
Godaatala madam, same under, yes. Same. That's serial number 1.
Corrected your office objection has complied with.
Fathers were correctly mentioned in the affidavit.
7. Sorry, I am extremely sorry. Now, 8.
ನಿಮ್ದೆ ಲೀಲಾಧರ್.
ಹೌದು. ಇದ್ರಲ್ಲಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಎಲ್ಲ ಕರೆಕ್ಷನ್ ಮಾಡಿದ್ರು.
ನಿಮ್ ತಂದೆ ಹೆಸರು ಗೊತ್ತಿಲ್ವಾ ನಿಮ್ಗೆ?
ಬರ್ದು ಕರೆಕ್ಟ್ ಆಗಿ ಬರ್ದು ಮೆನ್ಷನ್ ಮಾಡಿ ಬಂದಿರ್ಲಿಲ್ಲ.
ಆನ್ ದಿ ಬೇಸಿಸ್ ಆಫ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂದ್ರೆ?
ಎಸ್ ಅವ್ರು
ಮಿಸ್ಟೇಕ್ ಅಂತ ಮಾಡಿದ್ರು, ಕರೆಕ್ಷನ್ ಮಾಡಿದ್ರು.
ಅದು ಕರೆಕ್ಷನ್ ಮಾಡಿ.
ಬೇರೆಯವ್ರ ಫಾದರ್ ಹೆಸರು ಹಾಕಿದ್ರ?
ಅದ್ರಲ್ಲಿ ಫಾದರ್ ಹೆಸರು ಇರ್ಲಿಲ್ಲ.
ಆಧಾರ್ ಕಾರ್ಡ್ ಅಲ್ಲಿ ಸಪರೇಟ್ ಇದೆ.
ಅದಕ್ಕೋಸ್ಕರ.
ಸೇಮ್. Same.
498.
ಅದಕ್ಕೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಮಾಡಬಾರ್ದು ಅಂತಿದೆ.
ಇಲ್ಲ, what he has she is present before the court complaint. She is ready to withdraw the allegations against the accused number 2 in this matter, my lord.
File a joint memo.
Is ready. She is
Not now, sir. Where is the husband?
She is there. Husband is now. No allegation taking back to the accused number 1.
ಏನ್ 498 ಅಲ್ಲಿ ಯಾರ ಮೇಲೆ?
He is a sister husband ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ.
ಸಿಸ್ಟರ್ ಹಸ್ಬೆಂಡ್ ಮೇಲೆ 498 ಏನ?
ಹೌದು ಸ್ವಾಮಿ. ಅದಕ್ಕೆ she is ready to withdraw the allegation today itself. She is filing the affidavit before this court, please. She is
File.
present, my lord.
Password.
Please.
Yes.
Petitioner, my lord. One
2 and 5.
I appear,
for 3
I
days.
represent for
Complainant.
R2, Your Honor.
Ah.
Yes, Your Honor, complainant. Today morning I have filed wakalat.
The learned
counter.
counsel so and so submits that is entered appearance for the second respondent. Registry to print the name of so and so is appearing for the second respondent. Accepting the submission Monday, same madam, Tuesday.
I'll
18.
file objection, you know, kindly.
No,
direct
sir.
to serve the copy.
Copy serve ಮಾಡಿ. Counsel for the petition to serve set of papers upon the counsel for the second respondent. Next.
It has been filed, my lords.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರ?
ಹಾಕಿದ್ದಾರೆ.
ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
ಹೌದು ಸರ್.
ಎಲ್ಲಿದೆ?
It's
Idena?
petition. Charges for offenses for 392, 427 and
Entire
440.
proceedings filed since petition. Entire order sheet ಎಲ್ಲಿದೆ?
ಇದೆ sir. I'll
ಹಾಕಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
ಮಾಡ್ತೀನಿ sir.
The learned counsel of the petitioner seeks 2 days' time to comply with the office objections. In the event office objections are complied with, list the matter on Tuesday in the fresh matters list.
There is only one office objection, my lords, at serial number 2, my lords.
Same Monday, Tuesday, fresh matters.
18/6, my lord. Great.
Overruled.
ಈ ಫಸ್ಟ್ ಅಬ್ಜೆಕ್ಷನ್ ರೋಲ್ಡ್ ಮರಡದಲ್ಲಿ FIR ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸೆಕೆಂಡ್ ಪಿಟಿಷನ್
Same.
ಬ್ರದರ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಅದೊಂದು ಓವರ್ ರೂಲ್ ಮಾಡಿ
ಮಾಡಿ Monday, Tuesday listed, sir, ordered. Next.
Only one office objection, my lord.
Huh?
Office objection ಒಂದೇ ಒಂದು.
ಒಂದೇ ಒಂದಾ?
ಎಂಟೈರ್ ಆರ್ಡರ್ ಶೀಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅಂತ.
Uncompliable?
ಅಲ್ಲ ಕಂಪ್ಲೈ ಆಗಿದೆ. ಅದು ಒಂದ್ ಡೇಟ್ ಇಂದ ಆರ್ಡರ್ ಶೀಟ್ ಆಗಿಲ್ಲ. ಪ್ರೊಡ್ಯೂಸ್ ಆರ್ಡರ್ ಶೀಟ್.
ಅರ್ಜೆನ್ಸಿಗೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಮಾಡಲ್ಲ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ. ಏನ್ ಬರ್ಕೊಟ್ರದ್ ನೀವು? Matter is urgent, so I will not comply.
ಅದು ಒಂದ್ ಡೇಟ್ ಇಂದ.
Counsel for the petitioner seeks 2 days' time to comply with the office objections. In the event the stand complied, list the matter on Tuesday in the fresh matters list. Next. Same.
Objection is my lord.
Entire charge sheet.
Serial number 15.
Entire charge sheet you have to. 15 ಅಲ್ಲ, ಇದು ಯಾವ್ದು ಮೇಡಮ್ ಇದು? 16. A week's time is granted to comply with the office objections. Yes.
Petitioner. The address of the petitioner I've already submitted, the permanent resident address.
Same. Dubai, frequently found in Saudi Arabia and Dubai, hence
I will show
residing
her.
at,
She
ಎಲ್ಲಿ
traveled-
ಓಡಾಡ್ತಾ ಇದ್ದೀರಾ ನೀವು?
ಅಲ್ಲ, her son is residing there. I will
Ah,
leave
so?
I will delete that address.
What address are you going to put?
The permanent address of Chikmagalur.
Between Dubai and Saudi Arabia, Sharjah. Then
Chikmagalur, I have already submitted.
Chikkamagaluru ಅಲ್ಲಿ Dubai
ಅಲ್ಲ,
ಅಲ್ಲಿ Saudi
she
Arabia.
keeps traveling ಅಂತ ಅಷ್ಟೇ, just to show that she is there.
1 week to comply with the office objections. Same. Same. Same.
My lords, number 19 and 20, we complied the all the office objections, my lords. ಅದು trial court ಅಲ್ಲಿ ನಮ್ಗೆ availability ಇಲ್ಲ.
It will come on Tuesday, madam. Madam, ಇದೆಲ್ಲ ಇವ್ರದ್ದು. Axis Bank, all the cases you have filed till now, ask Unni Krishnan to give a list. All. I am posting them all on Friday. Otherwise, I'll dismiss everything if you don't give the list. Yes, tell Unni Krishnan.
My lord. If they give in advance, I see that the Karnataka.
Yes. ಅದು madams, ಅಲ್ಲಿ ನೀವಲ್ಲ, ಇಬ್ರು ಇದಾರಲ್ಲ ಅದಕ್ಕೆ. Give an advance copy to the additional SPP in all the list,
Okay, my lords.
copy of the list. Huh? Both of you.
Yes.
Yes.
My lord, the respondent is Udaya Savarda Cooperative Society, my lord.
So,
They have mentioned limited, as a limited in complaint.
Ah.
I have mentioned a society ಅಷ್ಟೇ.
mentioning limited, office objections unlimited, ತುಂಬಾ ಇದೆ ಇಲ್ಲಿ. Yes,
ಅಲ್ವಾ?
same
I have given submission.
Tuesday, madam. Yes.
My request, my lord.
Request
un-
accepted Tuesday ಬರುತ್ತೆ ಬಿಡಿ sir.
Connected matter ಇದೆ.
ಯಾವತ್ತು?
50 to 34, my lord. ಅದ್ರಲ್ಲಿ objection ಇಲ್ಲ.
15 to
50 to 34. Criminal petition 50 to 34.
ನಂಬರ್ ಹೇಳ್ತಿರೋದು ನೀವು 15 to 34 ಅಂತ ನೋಡ್ತಾ ಇದ್ದೀನಿ ನಾನು ಇಲ್ಲಿ.
50
Yes, ಬರ್ಕೊಳ್ಳಿ.
50 to
Tag
34.
along with so and so.
Tuesday, my lord.
Hmm.
Please.
Huh? ಮಾಡಿದ್ದೀರಾ? Counsel for the petitioner submits office objections have been complied with, office to verify. List the matter on Tuesday in the fresh matters list.
Office ಅವರಿಗೆ already ಹೇಳಿದೀವಿ, but however office has not accepted, this is not entire charge sheet.
ಹಾಗಾದ್ರೆ ಸೇಮ್ ಅಂತ ಮಾಡ್ಬಿಡಿ ಮೇಡಮ್. Yes.
Please.
Next. 18th, next date is 18th. Yes.
Respondent number 2 in this matter. That's
ನೀವು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ನಾ
2. Yes.
ನೋಟಿಸ್ ಆಗಕ್ಕೆ ಮುಂಚೆ ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ?
ಹೌದು.
ಅಷ್ಟೊಂದು ಏನಿದೆ ಈ ಕೇಸಲ್ಲಿ? 498 ಏನಾ?
ಹೌದು.
ಎಸ್.
No, not 498.
Then ಆಯ್ತು, ಇರ್ಲಿ ಬಿಡಿ, ಸೇಮ್ ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ.
Lord, office objection is with respect to production of the entire order sheet, my lord. I have produced the online case status.
ಮಂಡೇ ಸೇಮ್ ಟ್ಯೂಸ್ಡೇ. ಎಸ್. Two weeks to comply with the office objections. Next.
My lords, we have complied all the office objections, my lord.
ಇದು ಆಕ್ಸಿಸ್ ಬ್ಯಾಂಕಾ?
No, my lord. ಇದು writ petition.
ಮೇಂಟೈನಬಿಲಿಟಿ ಆಫ್ WP.
ಹಾಕಿದೀವಿ ನಾವು ಸೆಕ್ಷನ್ ಮೆನ್ಷನ್ ಮಾಡಿದೀವಿ, my lord. ಮತ್ತೆ ಇದರಲ್ಲಿ
Post the matter on 18th
Yes.
along with the office objections.
ಮತ್ತೆ
Maintainability. Yes, next.
same, my lord.
Same, next 27, same. Two weeks to comply with the office objections.
2 days time will be granted.
Counsel of the petitioner seeks 2 days' time to comply with the office objections. In the event the stand complied, same Tuesday. Yes.
2 office objections which are to be overruled, my lords. One is in the prayer, I mentioned the annexures, my lords, which is at page 67.
Same.
Please.
And for the petition.
And this was a,
Oh.
ಇದು covered ಅಂತ ಮಾಡಿದ್ದು, appears to be a wrong order. We'll recall this order and hear it.
Yeah, it was
On-
already heard, my lord. that the-
Already heard for what?
Uh,
Have you filed your objections?
This, they had sought.
Surrogacy ಇದಲ್ವಾ?
Surrogacy ಅಲ್ಲ.
ಹಾ.
They've sought for IVF minutes under the Assisted Reproductive Technology Act.
Your objections would be necessary?
Not really minutes, already.
Then we'll fix the date, you make your submissions, I'll pass the order. When do you want?
Tomorrow.
Tomorrow? Yes. Tomorrow? ನಾಳೆ ಆಗತ್ತಾ? Let's tomorrow. This court in terms, already order ಮಾಡಿದ್ದೀನಿ. This court in terms of its order date 8th February 2024 had disposed the matter on the score that it stands covered by writ petition 15824 of 2023. The memo is moved for being spoken to on the score that they said writ petition does not cover the issue as the issue in the list is entirely different. Therefore, the said order is recalled. List the matter for further hearing at 2:30 PM on Friday? On Friday, yes.
Commission, I appeal for the petitioner's counsel.
No, there is one problem in this.
Please.
The learned AGA had submitted. I will have to redo the order with regard to the submission. That's it.
But can I just make one
No,
submission?
because, all guns pointed at her, I don't want.
No, I'm not saying.
Yes.
All I'm pointing out is, would your lordships be kind enough to see what it is that was submitted, paragraph 6 of the order that your lordships
Yes.
passed? Learned AGA
Submit
would
that
further
if the
submit.
validity is appropriately modified and a fresh FDR is submitted, there will be no impediment.
Yes.
That is what is causing the impediment. I will answer it on merits, no problem. But not as a concession from the hands of the AGA. So you may not.
But the difficulty is this.
For you, it may not be anything.
No, my lord,
For the
I quite see.
petitioner,
I quite see.
you know how it functions.
I quite see, but in fact, the difficulty is the way it functions. I want
That's
to
the
say-
problem. But the functioning, way it functions, to wash off their hands, they may pass the buck on anybody else.
What I'm not saying anything about that. All I'm saying is, here is a situation where I haven't been in substantial complaints. Please notice that also.
That's okay. I'll answer everything on merit.
But there
We'll
is
answer
one
it
more
on
thing I
merit.
just wanted to point out.
No, you
Right.
want to say something?
Can I?
No, my
One
lords,
minute.
if your lordships is answering this on merit, I will have only 2 submissions to make.
Yes, do it. No problem.
Very well. Do I do it now, my lords?
Not now. When do you want, sir? Tomorrow, when
Lord,
you
there
get
is a-
free from the other
Short
court.
submission, my lords, there's nothing to it.
Can I then just make one request?
Yes.
But I'll just place this memo. What this shows is that the only reason I've been refused is, my lord, that if
I will answer it on merits. Why on concession?
Well,
That's all right.
Lord, in which case, any short date, my lord, I'll just,
Tomorrow, day after, when do you want, madam?
Anytime.
day after tomorrow.
Day after tomorrow? Will have it. When do you get free from the other court?
My lords, anytime. my lord.
4 o'clock I'll take?
Yes,
Yes, we'll take it at 4 PM.
4 PM.
day after,
Yes.
my lords.
Day after. ನಿಮಗೆ ಆಗ್ಬೋದಾ?
ತೊಂದ್ರೆ ಇಲ್ಲ.
4
Very well.
PM ಆಗತ್ತಾ? Yes.
Great.
See, because of the orders passed by the court, no counsel should suffer
No, I quite.
at
see.
the hands of the client. I will answer it on merits, no problem. Yes.
Please.
That's the matter. ಇದು ಒಂದು ನಿಮಿಷ sounds. Shall I recall this order and post it?
ಅವತ್ತೇ ಬರ್ಲಿ, I'll leave it to your lords.
I'll 4 PM ಗೆ ಬರ್ಲಿ.
Please.
At the same, list at 4, list on day of tomorrow, madam, at 4 PM in the same stage.
Please, please,
Avat, you finish off your submissions, I'll answer it on merit.
please.
The B report. This is a B report.
Huh?
B report has been filed.
Correct. ಇವ್ರಿಗೆ ಏನಿದೆ ಅಂತ ಆಗ್ತದೆ. The learned,
No instructions, my lord, where
don't
unable
worry,
to
sir,
contact
we'll
the
protect all your instructions. Other instructions I can't protect,
No.
only the learned additional SPP, the ಹಿಂಗ್ ಮಾಡಿ madam. The petitioner is accused number 7 is before this court calling in question the proceedings in crime number 38 of 2022 registered for offenses punishable prior lirutte. So and so. The learned additional SPP on instructions would submit that ಎಲ್ಲಾರ್ ಮೇಲೆ ಹಾಕಿದ್ರೆ ಇವ್ರ ಮೇಲೆ.
Except husband.
The additional SPP on instructions would submit that except the husband against all other accused, the police have filed a B report before the concerned court. In the light of the B report being filed by the investigating officer, by the respondent state, the petition in the form that it is pending is rendered infructuous, reserving liberty to the petitioner to avail of the remedy available in law. In the event any order would be passed by the concerned court against him, the petition stands disposed. ಹೇಳ್ಬಿಡಿ sir. ಈ ದಿನ ಕಡೆ ಆಟ. ಮತ್ತೆ ಒತ್ತಾಯದ ಮೇರೆಗೆ ನಾಳೆಗೆ ಹಾಕೋದೇ ಇಲ್ಲ.
ಇಲ್ಲ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. Lord, the 17A permission is given by the state government on 11/4/2023.
Correct.
May I request my lords to kindly see my lord's order
Yes, sir.
dated 17th April 2023.
Yes, sir, I am holding it.
Yes,
Yes.
my lord, page 18 of that order. Now, at the time when the hearing was on, the learned additional government advocate passes an order dated 11/4/2023 by which the state government has accorded approval as obtained under section 17A of the Act 1988 for investigation. Lord, the much prior to that, Lord, the FIR is registered. May I request my lords to kindly take, my lord, page 28. Lord, the permission is given on 11/4/2023. FIR is registered on 18/2/2022. Which is much prior to, my lord, approval,
ಆಮೇಲೆ
which is contrary to, my lord, section 17A itself. Therefore, my lord, the present FIR may go, liberty may be reserved, my lord.
Reserve for what, sir? Liberty for what? ಇನ್ನೊಂದು FIR ಮಾಡಕ್ಕೆ.
To take steps, my lord, in accordance with.
Will answer it. ಆಮೇಲೆ.
And my lord, the contention of, my lord, other side, that within a period of, my lord, 3 days, everything happened and.
Not everything happened. Work worth 5 crores has happened from 27th March to 31st March of 2020, when the entire nation was under lockdown. What work did you do?
ಇಲ್ಲ ಹಂಗಾಗಿ
ಹೇಗಾಗಿದೆ sir? ಹಾಗೆ ಆಗಿದೆ.
Lord, my lords have called out the dates and events in the order.
Government came in defense. ನಿಮ್ defense government ಅದ್ರಲ್ಲಿ ಬಂದಿದ್ದು. They said he was working from home. Because COVID ಇರೋದ್ರಿಂದ we had asked all engineers to work from home. I don't know how walls can be constructed from working from home. And 5 crores is released before 30th. ಯಾವತ್ತಾಗಿದೆ sir?
ರಿಲೀಸ್ ಆಗಿಲ್ಲ.
ಬಿಲ್ ಕೊಟ್ಟಿದ್ದ ಅವತ್ತು. ಬಿಲ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರಾ?
ರಿಜೆಕ್ಟ್ ಮಾಡಿ
ಮಾಡಿದಾರೆ ತಾನೆ ಬಿಲ್.
But it is not paid to the contractor.
ಮತ್ತೆ ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ ಕಾಂಟ್ರಾಕ್ಟರ್ಗೆ?
ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಡ್ಬೇಕಾಗಿತ್ತಲ್ಲ.
May I request my lord?
He will suffer sir, otherwise he has done work in COVID.
ಇಲ್ಲ ನಾನು I am an engineer.
ಗೊತ್ತಾಯ್ತು. ಅವ್ರ ಕಾಂಟ್ರಾಕ್ಟರ್.
I am a public sir.
3/12/2019 itself, the contract was the contract.
Yeah, the OC.
It is
Lord,
quite evident from the.
Lord, kindly take for a moment. I'll make an attempt, my lord, and leave to the, Lord, page 1. Lord, the entire incident.
Dates and events call out ಮಾಡಿದಿನಲ್ಲ. Comment ಹಾಕಿದ್ದು.
13/11/2019, page 1.
Madam,
how it starts?
1 minute. Madam, ಏನಾಯ್ತು? Get the papers in ಈ judgment papers ಕೊಡಿ. ತರ್ಸಿ. Yes.
These are undisputed facts.
Absolutely. Undisputed facts.
In the light of, my lord, these facts, Lord, the contention that, my lord, it is completed within a period of 3 days.
No, I'm not saying it's completed within 3 days illa.
It is there.
I'm not on that.
Lord, kindly come to page 14. Similar complaint was made to the Lokayukta.
Close ಆಯ್ತಾ ಅದು?
It is closed on the ground. Kindly take, my lord.
On the ground?
Page 21. Exemption is given under the
4G.
KTP.
That also I have referred to. See, what was alleged before the Lokayukta was KTTP Act contrary ಮಾಡಿದ್ದಾರೆ ಅಂತ. Lokayukta observes 4G exemption is taken, so no offense.
Embezzlement of fund is also. Page 21 for a moment.
ಆಯ್ತು ಸರಿ.
The report of investigating officer prima facie show that the respondents have executed the works as per section 4A of the KTPP Act. During October 2019, there was heavy rain in KRPet Taluk, Hemavati left bank canal jurisdiction. Therefore, the tanks, roads and bridges were damaged. in order to avoid further damage to the tanks, roads, bridges and lands of the farmers. The respondents had taken up the work immediately. Though these works are urgent, it may not be possible to complete within a fixed period. The respondents had to prevent the further damage immediately and have to proceed further to complete the work. There is no time limit fixed in the order dated 28/1/2020. Therefore, it cannot be expected that the work should be completed within 15 or 30 days. As stated by the complainant himself, while government order dated so and so, government has passed an order under section 4A of the act. There was no time for the respondent to put up the work to tender, to wait for months together and then to execute the work. Due to heavy rain, all the respondents had to see that the damage to the tanks, roads, bridges and lands of farmers and adjacent villages is stopped. I find no reasons to disbelieve the report of the investigating officer. Therefore, I hold that allegations made by the complainant are not substantiated. Hence, if approved, this complaint may be closed under section 9(5)(b) of the act. My lord, what is the complaint is, my lord, is at page 15. Misappropriation of fund and my lord, the complaint is otherwise. Lord, we did not carry out the work within a time frame. The complaint here, my lord, says that, my lord, hurriedly we have executed the work. Page 15.
Come to page 6 and 8.
Yes, 6, please. 6 is the, my lord, letter by the managing director.
ಅನುಮತಿ ಕೋರಿ ಯಾವತ್ ಸಲ್ಲಿಸಿರೋದ್ ನೀವು ಅಂದ್ರೆ on 23/3/2020 to complete the work to the tune of 6.2 crore, 6.2 crores. 3 ಕಾಮಗಾರಿಗಳನ್ನು ತುರ್ತಾಗಿ ನೋಂದಾಯಿತ ಗುತ್ತಿಗೆದಾರರಿಂದ ನಿರ್ವಹಿಸಲು ಅನುಮೋದನೆ ನೀಡಲು ಕೋರಿ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಲ್ಲಿಸಿದ್ದು. ಸದರಿ ಪ್ರಸ್ತಾವನೆಯಂತೆ ಕಾಮಗಾರಿಗಳ ವಿವರಗಳು ಕೆಳಕಂಡಿರುತ್ತದೆ. ತುರ್ತು ದುರಸ್ತಿ so and so 2.7 6.2 crores ಈ ತರ ನೀವು ಕೊಟ್ರು 3. ಇದಕ್ಕೆ 31st ಏನ್ ಬಿಲ್ ಕೊಟ್ರಿ ನೀವು? ಇದು 27/3 ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದು. Work order was issued to for these 3 on 27. 27/3/2020.
Yes.
ಹೌದಾ? ಆಮೇಲೆ 31st ಗೆ you have submitted your bill. Where is that? Yes. Where is that?
I need to seek instruction regarding that bill, your lordship. Don't have.
This
There
is-
is a
this
clear
is incorrect.
dereliction of duty, your lordship.
Seriously? I'm asking you, where is that sanction?
We'll seek.
What seek? That is not a dereliction of duty? What, sir? I get those papers. I have seen that bill in the other case. It is cleared on 31st March. 5.9 crores. It is recommended to be cleared. ನಿಮಗೆ ಅದು ಬಂದಿರೋದು ಅಕ್ಟೋಬರ್ಲಿ. Money has come in October, but it is cleared on 31st March. Who inspected, who gave you the completion certificate or partial completion certificate?
At any rate, my lord,
What shocks the court's conscience is 27th, nobody was on the streets anywhere in the country.
globe.
First lockdown was a very strict lockdown. And you have completed the work in those 4, or begun the work in those 4 days. And government releases funds. What work can you do in COVID, sir, when everything was there? And I have recorded the dates and events that
Yes,
have
my
happened in
lord,
the
have
earlier
recorded.
petition.
Idರಲ್ಲಿ,
If criminal proceedings should not be initiated, tell me in which case it should be initiated.
on
33, I've recorded.
Yes, my lord.
33, 3 work orders are issued between 24/10/2019 to 33/2020. ಅಲ್ಲಿ ನೀವು ಕೊಟ್ಟಿರೋದೇನು ಅಂದ್ರೆ 100% ಕಂಪ್ಲೀಟ್ ಒಂದು ವರ್ಕ್, 50% ಕಂಪ್ಲೀಟ್ ಇನ್ನೊಂದು ವರ್ಕ್, 60% ಕಂಪ್ಲೀಟ್. ಸೊ ಆಮೇಲೆ 2.57 crores, 43.12 lakhs, 1.5 crores. It is released.
ಅದು ಜುಲೈ 2020.
ರೆಕಮೆಂಡ್ ಮಾಡಿ ರಿಲೀಸ್ ಮಾಡಿದ್ ಬಿಕಾಸ್ ವರ್ಕ್ ಕಂಪ್ಲೀಟ್ ಮಾಡಿದೆ ಅಂತ. 100% completion ತೋರಿಸ್ತಾರೆ. Who visited the spot during COVID?
Not the completion is July 2020.
ಹೌದು sir, fund released only in the month of July, past vouchers.
Yes,
Completion report is given on 38/2020
yes,
and it covers the period, entire period of COVID.
yes, that,
Ah,
that is,
so perhaps the only engineer who has, loved his work so much that you worked during the lockdown.
not the
And
permission.
contractor ಅವರು, yes sir, ನೀವು ಕೆಲಸ ಮಾಡಿದ್ರ ಅವಾಗ?
4th December 2019 minute.
ಶುರು ಮಾಡಿದ್ರಿ?
ಅಲ್ಲಲ್ಲ,
ಇಲ್ಲ, ಶುರು ಮಾಡಕ್ಕ.
ಶುರು ಮಾಡಿದ ಮೊದಲೇ 22/10.
ಹ್ಮ್. Anyway, these are matters which have to be investigated into. Whether there is criminal intent or it was just a dereliction of duty simpliciter will have to be decided.
Lordship.
My lordship, with my lordship's kind leave, this
Kudi.
is the attendance register for the month of March 2020.
ಅದು ಕೊಡಿ ಮೇಡಮ್.
Lords, ಅದರಲ್ಲಿ serial number 27, my lords, that is the petitioner in the first petition, my lords.
27.
27, my lords, K. Srinivas.
Ah.
My lords, for the entire month of March, he is absent. my lords.
Obviously, in lockdown ಯಾರಿದ್ರು? He is work from home. That is his swan song. Work from home. Perhaps taking cue from the IT sector.
And in the bottom of that page, my lords, there is a clear ಸೂಚನೆ. ಸರ್ಕಾರದ ಸುತ್ತೋಲೆ ಸಭೆ ಸೋನ್ಸೋ ಅನ್ವಯ ಸಾಂಕ್ರಾಮಿಕ ಕಾಯಿಲೆ ಪ್ರಯುಕ್ತ ಕಚೇರಿಯಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುವ ಗ್ರೂಪ್ ಬಿ, ಸಿ ಮತ್ತು ಡಿ ಅಧಿಕಾರಿಗಳಿಗೆ ದಿನಾಂಕ 24/3/20 31/3/20 ಕಚೇರಿಗೆ ಹಾಜರಾಗುವುದರ ವಿನಾಯಿತಿ ನೀಡಲಾಗಿದೆ. To pass a bill or to pass a work order, my lords, we should have the help of.
From home, sir.
Admittedly, work is executed. There is no, these are the photographs, work. Not on the.
ಇವಾಗಿನ photographs ನಂಬದೇ ಕಷ್ಟ.
But on the count that.
ಎಲ್ಲ ಇವಾಗ photographs ಎಲ್ಲ Photoshop.
But the official communications made between the, it shows that work was already in progress and they have given that superintendent.
No, I am not much on you, but on the engineer. It's a public servant, sir. ನಿಮಗೆ ದುಡ್ಡು ಬಂದಿಲ್ಲಲ್ಲ? ದುಡ್ಡು ಬಂದಿಲ್ವಾ ಇನ್ನು?
ಸರಿಯಾಗಿ specific instruction.
ಫೈಲ್ ಪುಟ್ ಅಪ್ ಮಾಡಿಸಿ. Heard reserved.
Blood.
Yes, sir.
On the, blood.
Legally, I will answer all your contents.
Permission is later, my lord.
That I will answer. Why permission? Why FIR?
My lords, if I may add to that, my lords. My lords, the guidelines for granting a sanction under section 17 is CBI versus Ashok Kumar case, my lords. In the para 8A, my lords, it clearly says FIR is the document that has to be forwarded along with the other documents.
This is Sanjay Gowda ಅವ್ರದ್ದು.
No, my lords, CBI versus Ashok Kumar.
Ashok Kumar Agarwal.
Please. Para 8A, my lords.
No, that is at the time when 17A was not yet in the statute. That is 2014 judgment, sir.
Please.
17A is introduced on 27/6/2018.
Whether FIR is one of the documents.
That's all right.
Please.
After 17A, you cannot make that submission.
Please.
That FIR should be registered and then that is investigation. This is approval.
Lord, for a moment, my lord, kindly take page 24. The order sheet shows that, my lord, it was adjourned for want of sanction.
Approval.
The Lord, trial court refers
I have
that
seen.
sanction.
I have seen.
Lord, it is.
That there's a confusion with the trial court. That is.
Lord,
What
the-
is sanction? What is approval? They have not yet got into the group.
For a moment, my lord, page
What is it?
24. They say, my lord, the trial court says that complainant has sought time to produce the seeking for sanction.
Sanction comes only at the time of cognizance. It's approval prior to that. Yes.
What they say is, my lord, the proposal sent on 26/11/2021 is treated as approval and trial court takes cognizance.
No. By then I had passed an order here. Why approval is not granted? Immediately FIR is registered.
ಅದಾದ್ಮೇಲೂ
But ಆಮೇಲೆ ಅಪ್ರೂವಲ್ ಇಲ್ಲಿ ಕೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದು.
ಅಪ್ರೂವಲ್ ಆಮೇಲೆ ಕೊಟ್ಟಿದ್ದಾರೆ. They could have registered only after
They have followed my order. I'll answer.
even then, my lord, approval is necessary.
Necessary, definitely necessary.
They cannot put the clock back and say, we have registered, now we are giving.
Clock back a cart before the horse. We will see. Yes. Next. Data. Reserved. Sorry, yes. Huh? Both matters reserved. ಅದನ್ನ file ಪ್ರಶ್ನೆ. Yes, Latif.
Please
Split, huh?
No, my lord. This
ಏನಿದೆ?
Custody matter, my lord. Last 2 years, 10 months is in
Oh,
judicial.
that bail.
Bail, my lord. One of the ground, my lord.
The medical ground ಏನೋ ಅಂತ ಇದೆ.
The lordship has passed a detailed order. I leave
I
it
have
to.
passed a detailed order.
Yes.
Now he is saying medical ground.
Please.
I leave it to your lordship.
They themselves issued certificate.
I've
Jayalalitha.
seen the certificate. I leave it to your lordship.
And secondly, the pendency of the trial from the last 2 years, 10 months, my lord. I placed the judgment of the
judgment.
last date I had given.
Early. I'll pass orders tomorrow morning. Yes. I thought the split charge sheet ಅನ್ಕೊಂಬಿಟ್ಟೆ. Yes.
Judgments.
You are either split or page number. ಅದಕ್ಕೆ ಇದು ಕೊಡಿ
There are
ಕೊಟ್ಟು
five judgments.
ಕೊಡಿ ಅದಲ್ಲ. I will permit him. Yes. ಎಲ್ಲಿ ಆರ್ ಬಿ ದೇಶಪಾಂಡೆ ನಿಮ್ದೇ ಸರ್ ಫೈಲ್ ಕರೆಕ್ಟ್ ಫೈಲ್ ಇಲ್ವಾ?
Correct ಇದೆ for him.
ಹಾ
So far as the connected matter is concerned, my
ಗೊತ್ತು
lord.
ಕೊಡಿ ಅದಕ್ಕೆ ಕೇಳಿದ್ದೆ ಎಲ್ಲಿ ಅಟ್ರಾಸಿಟಿ ಮಾತ್ರ ಸ್ಟೇ ಮಾಡಿದ್ದೀನಿ ಅದರಲ್ಲಿ.
ಅಲ್ಲಲ್ಲ. They filed atrocity against me, my lord. They belong to SC/ST caste, my lord. Seems I am belonging to other community, my lord.
The
Yes,
learned
yes.
counsel for the petitioner submits that the court qua other accused in criminal petition 10317 of 2023.
Other accused, not other accused, my lord. Counter case accused.
Counter case.
Counter case.
The coordinate bench of the court in the counter case in criminal petition 10317 of 2023 has granted an interim order of stay. The said order reads as follows. Justice Hemanthandan Gaur. In the light of the interim order subsisting in the counter case, there shall be an interim order of stay in the case at hand as well. List both these matters on 11th July for admission. 1 HCGP, 2 emergent notice. ಅಲ್ಲ ಅದರಲ್ಲಿ ಯಾರಿದ್ದಾರೆ ಕೌಂಟರ್ ಕೇಸಲ್ಲಿ?
Counter case ಅಲ್ಲಿ they
ಅವ್ರಿಗೆ
are the accused, my lord.
The
Complainant
petitioner
also there.
shall serve on the counsels who represent the respondents in the aforesaid criminal petition. Yes.
The parties are present.
Filing work for the R2
Wait. Yes, sir.
The folks are my compromise.
Compromise.
Please. Folks.
ಏನ್ ಮದುವೆ ಆಗಿದ್ದಾರಾ?
Please. ಜೊತೆಲಿದ್ದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಹಾ?
ಜೊತೆಲಿದ್ದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ.
No, no.
ಆಗಿದೆ my lord. They'll get married my lord. The accusation JC from 16 to 2023 my lord. Conceive ಆಗಿ ಮಗು ಆಗಿದೆ my lord. One ಮಗು. Child is 1 year is old my lord. Please my lord.
Yes. Additional.
64 statement.
Good.
ಏನು ಏಜ್? ಯಾವಾಗ? ಮಗು ಯಾವಾಗ ಆಗಿದೆ? Lords, they are ready to marry my lords. Having 1 year old child, my lords. Parties are present before this court, my lords. They are willing to get married, my lords. ಮಗುನ್ ನೋಡ್ಕೊಳಕ್ಕಾಗಲ್ಲ ಅವರು ಚಿಕ್ಕ ವಯಸ್ಸು ಅಂತ ಹೇಳಿ 1 year old.
No, don't sing the swan song. Wait. Yes, government. This is of course horrendous,
Yes.
but she says she was 8 months pregnant when the statement was given. Now the husband is in custody.
Presumption, my lord, let him seek bail, my lord, but the presumption.
No, but if they are getting married now, somebody should take care of the child.
That's correct, but the
ಇಲ್ಲ,
presumption. my lord,
ನಿಮ್ಮ satisfaction, state satisfaction is only to get the conviction done.
Oh.
But that's not the issue. You should also go to the ground realities. Now, what will she do to rear the child?
That issue, my lord, that
Now, what will she do? Tell me.
no, the accused has to bear because he being the responsible for pregnancy.
All responsibility ಆಯ್ತು. In spur of the moment, what has happened is happened. Now the child and the mother are left in the lurch. They will have to go to dubious methods then to bring up the child. Then,
Legislator, there's no scope in the law.
no scope in the law. We'll see, we'll let him out on interim bail.
ಆಗ್ಬೋದು.
Let them get married. And we'll get the DNA tested of the child. Then if it is correct, then we'll pass some order. ಯಾಕಂದ್ರೆ ಇವರು ಆಚೆ ಬರಕ್ಕೆ they'll say they'll get married. ಆಮೇಲೆ they'll vanish.
That's correct.
And I will also add a rider that if he gives up the child and the mother, he will go back to the gallows. In the sense, go up behind bars.
In fact, it has happened.
Back to POCSO case will be revived and he will go back.
One of the appeal which we have filed, the consent was given, turned hostile, then the person disappeared after releasing from.
No, that's what. If that is the case, then these proceedings will revive and you will have to. That's the only way some thing can be done. Let's see. ಏನು
ಮಾಡ್ಬೋದು.
ಏನ್ ಮಾಡ್ಬೋದು?
Interim bail may be granted.
I'll list it tomorrow. We'll get some judgments and then do it. I'll grant interim bail first. And you get the DNA of all the three tested? Yes.
Grateful.
List tomorrow.
Grateful.
Petitioner. Millards, the case is registered prior to amendment. Millards, they continued till the 10 days earlier to the amendment, the final report was prepared. Submitted to the
It was
sanction.
filed after the amendment.
Millards, submitted to the sanctioning authority. Plus the sanctioning authority, because as on that day he was in still service, the sanction was required. Sanctioning authority accords the sanction at the beginning. Subsequently, for some reason, it withdraw the sanction. Then 2 years, the prosecution, my lords, waits for his retirement. Then after his retirement, my lords, files a new final report. It is not even the old final report. They file a fresh final report in the absence of the sanction. In the absence of the sanction.
That's the government. ಯಾರ್ ಫೈಲ್ ಮಾಡಿದ್ ಲೋಕಾಯುಕ್ತನ?
But it's Lokaयुಕ್ತ.
State is a party. Yes, the learned additional SPP is directed to accept notice for the second respondent. Counsel Shri Latif B is directed to accept notice for the first respondent Lokaयुಕ್ತ. Petitioner to serve set of papers on the aforesaid counsel. List the matter on Wednesday. Next Wednesday, please. Get the records. The state or the Lokaयुಕ್ta are directed to produce the original records that led to grant of sanction for prosecution against the petitioner.
Please.
Number 2, your lordships. Is the owner of building 405 apartment. Now the complaint is filed against the builder and this accused. And in fact, your lordship.
Learned additional SPP is directed to accept notice for the first respondent. The emergent notice to the second respondent. Non-delivery of a flat by the new developer,
ಅಲ್ಲ, ನಾವು purchaser.
by the developer.
A1.
Accused number 1 has led the purchaser of the said flat into the web of crime. The petitioner is accused number 2. finding alternative remedies, finding better, alternative remedies galore to the complainant for redressal of his grievance, setting the criminal law into motion on the said score is prima facie unavailable. Therefore, there shall be an interim order of stay of further investigation. So and so in crime number so and so till the next date of hearing. Next.
A3 490.
A3, where are you in the complaint? ಎಲ್ಲೂ ಇಲ್ಲ A3 ಹೆಂಗ್ ಮಾಡಿದ್ರಿ ಇವ್ರಿಗೆ? A perusal, the petitioner is accused number 3. A perusal at the complaint would clearly indicate there is not even a mention of his name in the complaint. It is ununderstandable as to how the FIR can be drawn against him, arraigning him as accused number 3, when the complaint itself does not mention the name of the petitioner. Therefore, there shall be an interim order of stay of further investigation in crime number 34 of 2024 till the disposal of the petition. 1 HCGP, 1 additional SPP, 2 emergent notice. Center for Wildlife.
14.2, personal hearing is needed. Judgment of the, my lord, in fact, Madhya Pradesh High Court also has held.
Yes, ಅದೆಲ್ಲ ಕೊಟ್ಟಿದ್ದೀರಾ ಸರ್? So ಇದೆ list of dates and synopsis.
ಒಂದಿದೆ, ಇನ್ನೊಂದು ಮಧ್ಯಪ್ರದೇಶಲ್ಲಿ under the very act, you know, it is.
I disposed it on that ground. It is his submission, appeal is not available. Yes, Madhukar.
Jesus Sales Corporation, my lord.
ಯಾವುದು?
Jesus Sales Corporation.
ಎಲ್ಲಿದೆ? ಕೊಟ್ಟಿದ್ದೀರಾ ಅದು?
I have not given.
Give it, sir.
Yes. Then Patel Engineering.
ಕೊಡಿ.
And Nirma Industries.
Paragraphs.
Yes.
Not have the citations here.
Yes.
ಒಂದು ಲಿಸ್ಟ್ ಆಫ್ ಅಥಾರಿಟೀಸ್ ಅವ್ರು ಕೊಡ್ಬೇಕಲ್ಲ?
Sorry, my lord, I should have prepared it. The Jesus Sales Corporation, my lord.
ಯಾವುದು?
First one, my lord, Jesus Sales Corporation.
ಅದು ಕೊಟ್ಟೇ ಇಲ್ಲ?
That was the first one which I had given.
Oh, sorry, sir. It's here. Yes, Jesus Sales. 96 4 SCC 69. Paragraph.
Whether the personal hearing is required to be given was the question. And that was under the Import and Export Act. The Supreme Court said that, held that, my lord, there is no need of providing a personal opportunity. That has been.
Paragraph, sir.
Yes, the paragraph, my lord. Para 4, my lord, 5.
4, 5.
Yes, ma'am. Then, my lord, the Jesus Corporation has been followed in Patel Engineering as well as in Nirma Industries. In both, my lord, para number 38.
ಯಾವ citation ಅಂತ ಹೇಳ್ತೀರಾ? Please.
Yes.
Sir, Patel Engineering is.
Tell me which.
2012 11 SCC 257.
Then, sir, 2013 8 SCC, page number 20. In both the cases, my lord, para number 32.
Para 32.
Yes.
They are following Jesus.
Yes.
I mean, corporation.
Yes, Jesus Sales Corporation.
Para 32 in both the cases.
Yes.
ಆಮೇಲೆ 14.2 of what? Act, sir. Wildlife.
ಅಲ್ಲ. This is my lord under the foreign exchange.
FRCS Act.
FRCS Act. ಕೊಡಿ. ಇದೆಯಾ? ಕೊಡಿ, ಇದೆಯಾ? ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅಲ್ಲ ಸರ ಕೊಡಿ. Yes. 14.2,
my lord. No order of cancellation of certificate under this section shall be made unless the person concerned has been given a reasonable opportunity of being heard.
For 1 minute. Rule 14, is it?
Allah, section. My lord, foreign contribution,
Of
Regulation Act.
Contribution, ಇದು foreign exchange
Oh,
regulation.
ಇಲ್ಲ.
ಮಧುಕರ್ ಕೊಡಿ ಅದು. ಇದೆಯಾ? 14(2).
Yes.
No order of cancellation unless a person concerned is given reasonable opportunity of being heard.
In fact,
Whether this would include
Madhya-
personal hearing.
Yes, Madhya Pradesh High Court has, my lord, held that under this very section. And Justice, my lord, Oak's judgment, I've kept it, my lord, along with you. Of course, that is not under the FCRA. ಎರಡನೇ judgment. ಅದರಲ್ಲಿ list of dates ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ರಲ್ಲಿ.
Samvad Society, that's Madhya Pradesh. Which is the judgment?
ಲಿಸ್ಟ್ ಆಫ್ ಡೇಟ್ಸ್ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ ಈಗ ನಾನೊಂದು ಅದರೊಳಗೆ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ ನೋಡಿ ಲಾಸ್ಟ್ ಜಡ್ಮೆಂಟ್.
Oh, Dalmia Cement. Dalmia Cement.
Correct.
Yes. Yes.
Madhya Pradesh judgment is para 5 and 6. That is under the FCRA itself.
Yes. We'll answer it. Anything else, Madhukar?
In both these decisions, both in Dalmia Cement as well as in Samvada Society Mill, the Sentence Corporation and subsequent new judgment of the Supreme Court has not been taken.
Considered. We'll answer it. Heard the learned senior counsel Uday Holda appearing for the petitioner and the counsel Madhukar Deshpande for the respondent. Reserved. Yes, Sharad, ಏನ್ ಮಾಡಿದ್ರಿ?
My lord, there is some space constraint. My lord, that godown is situated in 1 acre of land and it measures 25,000 square feet. Lord, we require, my lords, I am requesting my lords to kindly allow us to keep our seized item in the very same godown.
Yes,
My
no
lord,
problem.
it will take around 2,000 square feet, my lord.
No
And
problem.
Police will put the.
No problem. You coordinate. Yes. In furtherance of the order dated 29/5/2024 and 6/6/2024, 29/5/2024, Counsel Sharad Dodwad, representing the Election Commission, would submit that out of the 25,500 square feet of space of the warehouse in which the petitioner operates, the seized material would be only of 2,000 square feet. Therefore, the respondent is permitted to keep the said seized material in the godown, in the warehouse where the petitioner is operating, separately by cordoning it off from the other items. Subject to the aforesaid condition, the interim order granted on 29/5/2024 stands continued.
Condition, the petition should not meddle with those items.
It is made clear that the petitioner shall not meddle with the seized items that are separately kept and cordoned.
The investigation shall continue.
Investigation.
Stay
It is-
ಆಗಿದೆ sir. Investigation stay ಆಗಿದೆ.
Stay ಆಗಿದೆಯಾ? ಇಲ್ಲ.
Stay ಆಗಿದೆ sir.
It is made clear that the investigation in crime number ಏನದು? So and so shall continue. ನೋಡ್ತೀರಾ ಮೇಡಮ್? So and so shall continue. Yes.
That's in this matter.
Seizement.
That's.
ಹೇಳಿ sir.
Okay.
What happened?
The petitioner, I was thinking, Majads was saying something. Majads, the petitioner is a member of this MUT by name Pudi Shringeri Mahasamsthana.
Oh, ಇದು ಮಟ್ ಮ್ಯಾಟ್.
Yes, Majads. In this matter, what has happened is a third party having a self-styled organization by the name Shri Kudiri Shringeri Mahasamsthana Seva Samiti goes ahead and lodges a complaint, Majads, saying that Mutt has paid X amount of money to ABC
Hmm.
for different activities of the Mutt.
Hmm.
And he concludes by saying that petitioner is responsible for that money which is being paid by the Mutt.
You are KP Srinivas.
Yes, my lords, I am KP Srinivas.
Hmm.
Now, my lords, I have also placed on record
Hmm.
a copy of the memo
Hmm.
along with the bank statements
Hmm.
of all the
ಈಗ 30
transactions.
lakhs 20 lakhs ಎಲ್ಲ ಯಾಕೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ರಿ?
ಅದ ನಾವು ಮಾಡಿರೋದು, Mutt ಮಾಡಿರೋದು.
ಯಾರಿಗೆ?
Mutt has transferred it to one person named Ravi Kadam. My lords, may you have a look at the bank statement which I have.
Then
placed
why
on
is your
record.
account frozen?
My lords, my account is not frozen.
Then why are you before the court
My lords, I am
challenging
before
the
this court because I have been made as an accused here. The complaint has lodged that I have taken the money, while the money has been paid to a third party by another third party.
Yes, sir.
Have it next week, I'll secure the bank of
ಅಲ್ಲ,
course,
ಅವರೇ ಹಾಕಿದ್ದಾರೆ.
ಅದೇ ನಾನೇ ಹಾಕಿದ್ದೀನಿ.
ಅವ್ರು ಹಾಕಿದ್ದಾರೆ, but let me examine.
Verify it.
I'll verify. madam.
If he has nothing to do with it, why are you dragging him?
ಅದೇ sir.
I will verify. my lord.
The statement which I have produced is also of the Mutt. In fact, my lords, the Mutt has gone on to give a letter, which my lords have enclosed at annexure H.
You're
my
accused
lords.
number 1.
Yeah, I'm accused number 1. There's only one accused, and that is me.
Then
No,
why
two
do
accused.
you style it as 1?
I'm sorry, my lords.
Yes.
I stand corrected. And
We'll-
that's the
we'll-
Verify, but then
we'll
don't-
verify.
till that date, don't precipitate. You verify and come back.
Let him-
ಯಾವತ್ ಬೇಕು?
Next Wednesday, madam.
Wednesday ಹಾಕ್ಲಾ? Yes.
Let him cooperate with investigation, madam. Will not
That's
take
what
any
I-
coercive steps.
No, if he has nothing to do with it, unless you show that he has something to do, I will permit whole hog investigation.
yes,
ಆಗ್ಬೋದು.
Till then, don't harass him.
Yes,
Yes.
let him cooperate, madam. We will not
ಅರೆ,
arrest him till.
ನೀವು ಫಸ್ಟ್ ಅದು ಇನ್ಫಾರ್ಮೇಶನ್ ತಗೊಂಬನ್ನಿ, then I will direct him to cooperate.
ಆಗ್ಬೋದು.
Yes. It's a very happy thing ಅಲ್ಲ, police investigation. Yes. The petitioner is before this court calling in question registration of a crime in crime number 144 of 2024 for the offences punishable under prayer lidema. So and so. The learned counsel appearing for the petitioner on the strength of certain documents would demonstrate, albeit prima facie, that a transaction between a third party to a third party is the buck of transaction between a third party to a third party is saddled upon the petitioner. It is his submission that he has nothing to do with those private transactions, and no money is either sent out of the account of the petitioner nor has come into the account of the petitioner. In the light of the said submission, till the additional SPP would steer clear the controversy,
that's one small. 20 lakhs amount had come into my account.
that's your submission. We'll let him get back. There may be many skeletons in the
Yes,
cupboard.
yes. my lords.
Yes. So and so, there list the matter on Wednesday, next date haki madam. Wednesday, till such time, further investigation against the petitioner shall remain stayed. It is made clear that if the additional SPP would bring out information that he was in fact involved, further investigation would be permitted to be continued against the petitioner. ಒಂದು ವಾರ reprieve. Yes. Office objections on SOB. ನಿಮ್ದು sir. A week's time is granted to comply with the office objections complied. Learned counsel appearing for the respondent submits that the office objections have been complied with. Office to verify. In the event they are complied, list the matter on the day of the year 2022. Interim order subsisting shall continue till the next date of hearing.
Date be fixed more.
On the day of the year, he come, yes, 22.
For the petitioners in this case, my lords,
Non-compliance of office objections on list of documents.
list of documents I have filed, my lords. There are some marks, so I have made some highlighted marks in the.
Edited marks.
Highlighted the important portion.
ತೆಗೀರಿ ಅದೆಲ್ಲ.
My lords, sir.
ಇಡೀ ಜಡ್ಮೆಂಟ್ ಹೈಲೈಟ್ ಮಾಡ್ಬಿಟ್ಟಿದೆ, ಏನೋ ಪೇಪರ್ಸ್ ಎಲ್ಲ ಹೈಲೈಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ. According to you, every word is important, is it?
No, my lords. Actually, there are civil disputes are pending between the parties.
ನೀವ್ ಯಾರಿಗೆ ಪಡೆದಿದ್ರಿ ಸರ್?
But for complainant who had filed a suit, injunction obtained. They challenged it before this court. They failed, went to Supreme Court, withdrew it to file a review. Review is dismissed. Then they again go to Supreme Court, again they lose out. That's when we get the plan sanction also. When, my lords, the construction starts with the material kept there and the shed is constructed, they come and demolish the shed. That's when
That is the subject crime.
that is when I file a complaint.
Yes.
Now the police have filed the charge sheet after photos are also included in the.
I may be permitted to submit.
ಅಲ್ಲ ಇದು ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಇದೆ ಇವತ್ತು ಬೇಡ. We'll take it 22 ದಲ್ವಾ? I'll take
In
it
fact,
on.
last time your lordship, it has come
Partly.
back. Partly here again.
Heard and-
All right, list the matter for admission. The registry is directed to list the matter for admission.
And also I may be permitted.
1
to
minute,
file
sir,
some-
on Wednesday, the next, in whatever form it is.
Please.
Yes,
Date, madam.
Wednesday, next. ಅಂದ್ರೆ 18, 19.
Matter is covered by the, your lordship's judgment.
Covered.
Offense under 376. Consensual,
Habitual,
consensual,
consensual,
Promise to marry.
promise to marry.
promise to marry. How many years?
5 years.
5 years. Close ಮಾಡೋಣ.
Before on shorted.
Short?
Next week postman.
ಅವತ್ತೇ ಕ್ಲೋಸ್ ಮಾಡುದ? 5 ವರ್ಷ ಏನು? 22, same in whatever form it is, next date, previous order. Interim order subsisting shall continue till the, ಅದರ ಮೇಡಮ್ ಅದರಲ್ಲೂ interim order ಇದೆ. ಎಲ್ಲಿದೆ ನೀವು ನೋಡ್ಕೊಂಡು ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
Obliging.
Withdrawal in terms of the memo.
Offense under the PCPNDT Act and coordinate by under the PCPNDT Act, madam.
ಆಯ್ತು. Office objections can ಬಂದಿದೆಯಲ್ಲ?
Please, we'll comply it, madam.
Learned counsel seeks 2 days time to comply with the office objections. In the event they are complied, list the matter on Tuesday in the fresh
Wednesday.
matters. Wednesday ಇಲ್ಲ. 24 matter ಅಲ್ವಾ? Tuesday in the fresh matters list. One case if I deviate, then it goes haywire. Yes, next.
That's for R2, state can take notice, my lords. It is Gram Panchayat officer.
ಗ್ರಾಮ ಪಂಚಾಯತ್ ಸ್ಟೇಟ್ ಹೆಂಗ್ ತಗೊಂತಾರೆ? ತಗೊಂತೀರಾ?
Complaint is lodged by Gram Panchayat officer.
Complainant ಯಾರು?
Gram Panchayat officer.
Then you can take. That's the state only. Explosives, learned additional SPP is directed to accept accepts notice for the second respondent come as well. Registry to print the name of additional SPP as appearing for both the respondents. List the matter next on 2 weeks with date code. Interim order subsisting shall continue till the next date of hearing. Yes. Office objections. Orders.
Office objections, it looks to me, my lord, something unheard of. That is number one. Number two, it is at the stage of office objections today, not even listed for admission. How the office would accept a wakalatnama on behalf of the respondent and show his name?
ಒಕ್ಕಲತ್ತು ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಾ?
It is only for that reason these office objections are there. It assumes all the importance. Now I shall take your lordship.
I'll take it tomorrow because I would not have gone through the file.
From the rank of an additional director general of police, IG, DIG, SP, DYSPs, all are made accused. For what? Because they conducted a right, search, crime is registered, and the learned.
Who is the complainant?
A private party. And the learned judge takes cognizance of the offence.
Cognizance is taken.
Yes, for section 30 of the Prevention of Corruption Act, in spite of the circular which came to be issued by the registry of this honorable court, probably while placing reliance on any number of judgments which my lord has pronounced, that the court cannot take cognizance. I have produced the circular also. What is this that is happening, my lord? How could the office show his name?
So you have filed wakalat, is it? Who has filed?
Without even notice.
First time ಬರ್ತಾ ಇರೋದಾ?
ಹೌದು. Office objections ಗೆ ಕಂಪ್ಲೈ ಮಾಡೋದಕ್ಕೆ ನಾನು I will request your lordship that objections have got to be waived. That is a different issue. Admission ಆಗಿಲ್ಲ, notice ಆಗಿಲ್ಲ.
appears to be of some significance.
Yes, my lord, that is why, my lord, I would like to take your lordship to the office objections. Have a look at it, because office probably the registry is not.
Age of the petitioners mentioned.
They are public servants, so, Elronu,
Name of the
ADGP,
petitioners
IG,
mentioned.
DIG, SP,
Attested as
all anti-corruption bureau are made the accused.
advocates' names are to be mentioned below the signature.
Below the
of the
signature,
petition.
ಹಾಕಿದೆ, ತೋರಿಸ್ತೀನಿ ನಾನು ಬೇಕಾದ್ರೆ.
ಅದ್ ಮಾಡಿದೀರಾ?
ಮಾಡಿದೆ.
I think the filing of Wakalat, my lord, has
ಸ್ವಲ್ಪ ತಾಳಿ sir.
got
ನಮ್ಮ
nothing
ಲೋಕ
to
ಆಗ್ಲಿ.
do with
All right.
it.
I have not
ನಮ್ಮ
yet
ಲೋಕ
issued
ಆಗ್ಲಿ
notice.
first.
Wakalat is filed, senior counsel is briefed. What is?
No,
What is all this?
briefly the says.
No, 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 no.
Anyway, I need
Let
not,
the
my lord,
court
take
give,
permission
let
from
the
my
court give you the
learned
right of audience.
counsel. Let him
I-
not, I am answerable to the court.
If
So
I,
let him
if
not
I permit,
try
if I
to
permit,
dictate.
that's all right.
Yes,
But
I am
why-
answerable to the court, not to anyone else. So let
No, no,
him-
you are
let him-
interfering.
No, no,
My
I am not.
submissions. I have every right.
Anyway, let us not vitiate.
I have every right
Yes.
to oppose you because you are interfering.
Who is
No, but
stopping you?
who is the complainant?
Complainant, my lord, is a private party who is an accused in a crime that had been registered against him for offences under section 7,
No,
8,
he is
12 or
not an
18.
accused.
Arre, but, mat pune
No, no, let him
Murthy
not
sir, what is
proceed.
this?
I'm sorry.
Arre, you have, I have not yet issued notice
Please speak.
and I have not given you permission to argue. Wait, sir. Wait. ಅದಕ್ಕೆ I'll post it tomorrow ಅಂತ ಹೇಳಿದ್ದು. Let me also see the,
Please, please, my lord, I have absolutely,
I'll post it tomorrow in the fresh matters list.
please, please.
Yes.
Well, office objections may have to be
It will be overruled.
overruled or your lordship may keep it open.
No, no.
ಏನಂತಂದ್ರೆ ಇಷ್ಟೇ ಏಜ್ ಪ್ರೂಫ್ ಪಬ್ಲಿಕ್ ಸರ್ವೆಂಟ್ಸ್ ಏನ್ ಏಜ್ ಪ್ರೂಫ್ ಇವರೆಲ್ಲ ADG, IG, DIG.
ಅಲ್ಲ, that's all right. Those are all.
ಇನ್ನೊಂದೇನು ಸೆಕೆಂಡ್ ಏನು ಅಂತಂದ್ರೆ ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹಾಕಿರೋ ನೇಮ್ ಇಬ್ರದ್ದು ಡಿಫರ್ ಆಗುತ್ತೆ ಅಂತ.
You need not labor on office objections.
Please, please,
We'll go to the meat of the matter, but
Please,
tomorrow.
please. Deeply obliged.
Heard the learned senior counsel C.V. Nagesh for the petitioner. We'll tell about you tomorrow. Yes.
Please.
List tomorrow. But why? Complainant is a private party.
Yes,
Private party.
complainant is the
Wait,
sole
sir.
respondent.
One nimsh. Why senior is there? Wait. Complainant is a private party.
Complainant is a private party. A crime came to be registered by the Anti-Corruption Bureau, my lord.
Against him.
Against certain, my lord, he comes under touts of the BDA. A2. My lord, BDA, there was rampant,
Yes.
you see.
All
Then
right.
a crime came to be registered, right from against such of those officers who are attached to the Bangalore Development Authority, right from the rank of a secretary, number one. Number two, touts. Number three, middleman. Well, during the course of investigation, the investigator was able to lay his hands upon a diary that was found in the office of the deputy secretary.
What happened to the crime?
Still under investigation. But here, I don't know why he gets up every now and then.
What's your problem?
You are disturbing me.
I am not disturbing.
I am asking senior
My
something.
lord, should I
To elicit-
not get up? Did I even open my mouth?
It's all right.
And what's his problem
Lord,
if I get up?
Don't get touchy or agitated
No, no,
about
he is
submissions.
getting
Wait,
hurt.
sir.
It's very unfortunate.
Wait, sir.
The
Wait, wait.
Senior is getting
Wait,
touchy.
sir.
Should I at least not get up, my lord?
You sit and get up, not a problem.
Why is he-
No, no, you are.
All right, yes. No, no, I am asking what is the issue?
Yes,
So
I am
tomorrow it
making
will be easy
submissions
for
and he
me.
gets up like a fountain. Every now and then he gets up like a fountain.
What's your problem?
Sir, that's-
Problem is you're disturbing my attention.
That's your problem.
Murthy, sir.
My lord, I am sure.
Better we encourage restraint. It's
Yes,
not
that's
correct.
not- I'll ask you.
These repartees will send a wrong.
My lord,
Don't do that.
I would like to make
Sorry,
one submission. What is his locus standi to interrupt me?
So wait, yes.
What is his locus
Not
standi?
correct, wait, yes, yes, sir.
Your lordship.
I am asking some questions
Yes,
to
I'm
get
sitting
to know
quietly.
what is the issue, that's all, yes.
But a crime came to be registered against certain officials of the BDA, number one. Number two, against some middleman. Number three, against certain touts. Well, at a point of time when the investigation of the crime was in progress, the investigator was able to lay his hands upon a diary in the office of the deputy secretary. Well, there, an entry was found by the investigator wherein, my lord, the name of the respondent complainant was also there and his telephone number was there. But for the purpose of investigation, what we would do is the investigator would go and approach the court seeking for the issuance of a search warrant of his premises. Well, the search warrant came to be issued by the court. We will go there, the investigator will go there, but the house was vacant. Then, my lord, thereafter in exercise of the powers clothed upon him under section 165 of the CRPC, what the investigator does is he would authorize another official to go and search his premises wherever he is available. He goes and searches us and he will prepare a record and all that. But after all these happenings, but he would come up before this honorable court. The respondent informant would come up before this honorable court in a criminal petition seeking for the quashing of the first information report. Well, at this honorable court, by its order.
Allowed, is it?
Yes, but no, my lord. On 2nd of February 2023, would pass this order. May I just request your lordship to kindly turn to page 9, that is the last operative portion of the
Not
order.
my order.
Operative portion of the order. The impugned FIR and crime number so and so registered by respondent pending and the file of the letters, etc. is hereby quashed. Number 3, kindly note this, my lord. Liberty is reserved with the respondent lokaयुಕ್ತ to proceed against the petitioner in accordance with law in the event any incriminating materials are found.
All right.
It does not mean that he has been given a clean sheet.
All right.
But the investigation is still in progress. Now, my lord, in the meantime, he goes before the.
Has the ACB or the lokaयुಕ್ತ now registered another FIR?
No, my lord, same. Liberty
It
is
is reserved if any incriminating material.
How?
Now, what is incriminating found now?
I am not aware of it. Normally, it has been.
Now, what is the,
But his grievance is,
is it his case that without any rhyme or reason, you have searched the premises and caused?
That's it.
Why did you do it?
But
what did you get there?
Yes, we got it. We have brought it to property forum. We have drawn a panchanama.
So it is
It is an act done by me.
Police power.
It is an act done by me in the discharge of my duties as a public servant.
I'll take it tomorrow.
Yes.
Yes, I just wanted to know what is the outline.
In fact, may I just request your lordship to kindly, section 13 of the Prevention of Corruption Act.
The cognizance is taken already.
Cognizance is taken. That is what I have questioned before your lordship in this petition.
How would 13 spring in?
I don't know. God knows.
Disproportionate assets.
Allah, may I just request your lordship to kindly have a cursory look at this order, last operative portion of the order.
I'll go through it and
tomorrow. At 71.
We'll take it tomorrow, sir.
Cognizance of offences punishable under section so and so the APC and under section 13 of the Prevention of Corruption Act against me.
No, that's private persons are there.
No, my lord.
All are officers.
All are public. Additional Director General of Police, Superintendent of Police, deputies, entire ACB is made the accused.
Let's see tomorrow. But the learned senior counsel, Sri Nagesh, appearing for the petitioner. List tomorrow in the fresh matters list in whatever form it is. I'll hear you tomorrow. No problem.
Lord, may I request the petitioner's counsel to serve a copy?
ಎಲ್ಲ ಇರುತ್ತೆ ನಿಮ್ಮ ಹತ್ರ ನಾಳೆ ಬನ್ನಿ ಸುಮ್ಮನೆ ಅದು
No, they don't have. A
Tomorrow
formal
will-
copy can be
ಕಾಪಿ
served.
ಕೊಡಂಗಿದ್ರೆ ಕೊಡಿ. I'll permit him to make his submissions tomorrow. Yes.
Grateful.
Please.
Yes.
Serial number 21.
It's to be served.
My interim order.
Yes, not that. The R4 is served, not the.
Who is R4 served?
Yes, it is served.
Second time. When is it served? Nodi, madam.
Please, kindly.
R4 is the complainant?
Yes. But I am producing the postal track, which shows that, my lord, he has been served on 8/11/2023.
Kodi. The postal track sheet is indicative of the fact that the complainant, respondent number 4, has been served on 8/11/2023. It depicts that it is delivered to the addressee. Therefore, registry to print the name of the complainant and show him as served. Post the matter for admission on next Wednesday. Yes. Interim order subsisting shall continue till the next date of hearing. Yes.
Next Tuesday.
But Tuesday,
2022.
Monday is a holiday, sir.
Yes.
So that's why days are.
Yes.
And Saturday is a working day, next Saturday.
Next. May be listed in the fresh matter.
Admissions. How fresh matter?
Is
ಎಲ್ಲ ಅದಕ್ಕೂ
covered.
fresh matter. So what? Hearing. Writ petition ಅಂದ್ರೆ preliminary hearing. Criminal petition ಅಂದ್ರೆ admission. ಅದ್ ನೋಡ್ಕೊಂಬಿಡಿ.
Need 2 months.
This is a matter wherein the accused in the domestic violence case has come up before this honorable court seeking quashing.
498 na?
Domestic violence case.
The DV Act da?
Please, DV Act. And they went before the vacation bench and sought for interim protection, which was granted. So it's the first time it's coming up
Before
after
me.
vacation. Please.
Oh, yeah, the 695 is the order.
Please, my lords. 9-5 and interim.
Why,
order
what was the hurry in a DV case to go before the vacation?
My lords, the next date of hearing was 12 and the court was, the trial court was inclined to dispose of the matter, my lords.
Dispose of the matter.
50 days they were.
Who are you?
I am the petitioner, my lords. I'm the
Husband.
husband.
Huh.
My lords, my case is that a divorce has been taken place 3 years ago. Let the other side file their reply and a date may be fixed. We'll address submissions, my lords. I'm being led by a
We'll
senior.
close it, directing closure of the case. 3 ವರ್ಷ ಅವ್ರಿಗೆ ಇನ್ನೇನ್ pending ಇರ್ಬೇಕು?
Your Lordship, they've not, in fact, even now, he is asking her, let us give me a divorce, and there's all communication. I have all of that
My
right
lords,
now.
now,
let them file their reply.
They have misled this honorable court by stating they have been separated long ago. There was a mutual consent filed. None of this was done. Now what they're doing, Your Lordship, even after filing the matter before this honorable court, now they're seeking withdrawal of their existing case that they have filed seeking a divorce, stating that permit me to withdraw that. I will file under specific performance so that my order that I got, please, that is what they have done. That's
My lord,
as absurd as that, Your Lordship.
we'll address
Now-
submissions, my
Now
lords.
they state
But
that,
My lords may fix a
not
date
in the
next
orders.
week.
Your Lordship, it may
I'll
be
post
put
it
up.
on Friday or
May have it in the coming week, my lords. anytime.
24 is it? This
Yes, my lords.
2024 da?
Yes, my lords, 2024.
List the matter on Friday.
Your
My
Lordship,
lords, may have it in the coming
Why,
week.
sir? You have an interim order ಅದಕ್ಕೆ.
Being led by senior counsel, my lords.
Yes, sir. Ask the senior counsel to be
Please,
present.
please, I'm in this court stand.
Huh?
I'm in this court stand.
Oh, yes.
Interim order may be
List
extended.
the matter on Friday in the fresh matters list.
Your Lordship, the council's name may be recorded
1
since it
minute.
was
What
only
is
the
1 minute, madam? ಯಾವ್ದಿದು 20?
24.
22,
22,
Your
my
Lordship.
lords.
Who is the respondent?
Your
Learned
Lordship,
counsel so and so undertakes to, you've already filed wakalat?
they have filed wakalat.
Submits that he has entered appearance for the respondent, wife, registry to print the name of so and so is appearing for the respondent. Heard the learned counsel appearing for the petitioner and the learned senior counsel Srimati Lakshmi Iyengar representing the respondent. List the matter on Monday in the, Friday in the fresh matters list.
Please.
Interim order may be
Interim
extended.
order subsisting will continue to the next.
Grateful.
Correspondence in this matter.
498 A.
My lord, apologies, my lords, I mistook it as.
420, Mala.
Oh, 420. sorry.
420.
465.
This is that, is my order.
Like, yes, ma'am.
Yes,
Interim order is mine. Yes, so it is detailed. Yes, sir.
some date may be fixed, my lord.
Please, sir, objection ಆಗ್ತಾ ಇದೆ.
ಹಾಕ್ತೀನಿ sir.
Copy ಕೊಡಿ ಅವ್ರಿಗೆ.
Court, I'll serve.
The learned counsel appearing for the second
I think, my
respondent.
lords, yesterday's development is that the parties are
Settled,
settled. They're going to settle and
There's
file
no
a compromise
information.
petition before the trial court.
ಇದೆಲ್ಲ
respect to-
ಆಗದೆ ಅದು. Yes.
Specific
both the-
performance suit is pending, my lords.
Both the counsel appearing for the petitioner and the respondent would in unison submit that the parties are on talks of settlement and would report such settlement before the concerned court where the suit is pending and report the said order to this court on the next date of hearing. List the matter on 28th June. Interim order subsisting. Badwa.
ಅಲ್ಲ ಇದರಲ್ಲಿ land is belongs to government. Tahsildar report saying that the land is not granted to.
We'll see. What is it?
Fabricated the documents.
that
Grant
order-
I
certificate
guess
has
the
been
court will
fabricated.
also look into it.
Lords, the grant certificate has been fabricated and I have entered into an agreement of sale stating that this is their property. There is
Fabricated
no
by
original
whom?
grant certificate.
Fabricated by whom, sir?
Fabricated by the petitioner hearing.
Petitioners. ಆಯ್ತು ನೀವೇನ್ ಮಾಡ್ತೀರಾ ಮಾಡಿ.
50 years old
We'll-
document, my lord, there is
we'll
an
post
already
it.
an interim order, my lord.
If you have, both of you have meddled with government property, we'll take care.
No, my lord.
Yes, let's see, list on 28th.
Much obliged.
The offense under section Lottery Regulation Act, section 7, class 3, and Karnataka Lottery and Prize Competition Control and Tax Act, section 4, class A, class C, and 4, class 1, class C, and 5, 7, and 7, class 3.
ಏನ್ ಓದ್ತಾ ಇದ್ದೀರಾ?
Offense under section, my lordship.
Offense. ಅಷ್ಟುದ್ದ ಹಾಕಿದ್ದೀರಾ?
Yes, my lordship, page number 14, my lordship, FIR.
ಕೇರಳದಲ್ಲಿ ಲಾಟ್ರಿಗಳನ್ನ ತಗೊಂಡದ್ದು ಇದನ್ನ ತಗೊಂಡು
ಕೇರಳದಲ್ಲಿ?
ಕೇರಳ ಲಾಟ್ರಿಗಳನ್ನ ಕರ್ನಾಟಕದಲ್ಲಿ ಪ್ರಾಹಿಬಿಷನ್ ಆಗಿದ್ರೆ ಸಹ
ಓ, ಅದರಲ್ಲಿ ಲಾಟ್ರಿ ಪ್ರೊಹಿಬಿಷನ್.
ಲಾಟ್ರಿ ಪ್ರಾಫಿಟ್.
Yes. Karnataka Lottery and Price Competition Control Tax Act. Yes, sir. ಹೇಳಿ.
Yes, my lordship, page number, in the complaint, the FIR registered against the petitioners as my lordship, accused number 7 to 9. And 11 to 17. And accused number 19 to 26 and 28 and 30, my lordship.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ sir.
Yes.
Page number 31, my lordship. 32, my lordship. Sorry, 31.
31.
31.
Your accused number?
7 to 9 and 11
7 to 9.
A7 to A9 and A11 to A17, A19 to A26.
ಎಲ್ಲರೂ ಇದ್ದೀರಾ ಇದರಲ್ಲಿ?
Also. A19 to A26 and A28 and A30, my lordship. My lordship, the allegation against the petitioners, my lordship, in the page number 31, ಆರೋಪಿ 7ರಿಂದ ಆರೋಪಿ 29ರವರೆಗಿನವರು ಕರ್ನಾಟಕದ ರಾಜ್ಯದಲ್ಲಿ ಲಾಟರಿ ನಿಷೇಧವಿರುವ ಬಗ್ಗೆ ತಿಳಿದಿದ್ದರೂ ಸಹ ಆರೋಪಿ 1ರವರು ಆಡಿಸುತ್ತಿದ್ದ ಲಾಟರಿಯನ್ನು ಮೊಬೈಲ್ಗಳಲ್ಲಿ ಲಾಟರಿ ಟಿಕೆಟ್ನ ನಂಬರ್ಗಳನ್ನು SMS ಮುಖಾಂತರ ಕಳಿಸಿಕೊಂಡು ಅಕ್ರಮವಾಗಿ ಲಾಟರಿ ದಂಧೆಯಲ್ಲಿ ತೊಡಗಿಸಿಕೊಂಡಿರುವುದು ತನಿಖೆಯಲ್ಲಿ ದೃಢಪಟ್ಟಿರುತ್ತದೆ. The only allegation, my lordship, all the petitioners ಆ ಲಾಟರಿನ ಆಡ್ತಾ ಇದ್ರು ಮೊಬೈಲ್ ಅಲ್ಲಿ SMS ಕಳಿಸ್ಕೊಂಡು. My lordship, initially FIR was registered against A1 to A4, my lordship.
Correct.
In the complaint, there is no allegation against the petitioners, my lordship. There is no document that shows that petitioner ಅಲ್ಲಿ ಆಡ್ತಿದ್ರು ಇಲ್ಲ ಅಲ್ಲಿ ಹೋಗ್ತಿದ್ರು ಇಲ್ಲ ಅಲ್ಲಿ all the mobile are seized in the petitioners, my lordship. There is no materials as recovery, my lordship. My lordship, the investigation officer recorded the statement of CW 6, my lordship. He is the ಏನು A1 ಲಾಟ್ರಿ ಆರಿಸ್ತಿದ್ದು ಅಂತ ಎದುರುಗಡೆ ಇರೋ ಶಾಪ್ ಹೋದ್ ಮಾಡಿಸಿ. In this shop witness also there is no allegation against the petitioners and petitioner identify ಮಾಡಲ್ಲ ಸ್ವಾಮಿ. In the page number 88, my lordship, he is also Xerox shop. ಏನ್ A1 ಅವರು ಪ್ರಿಮಿಸಿಸ್ ಅಲ್ಲಿ ಆಡಿಸ್ತಿದ್ರು ನಾವು ಪಕ್ಕು ಶಾಪ್ ಸ್ವಾಮಿ. He is also A1 ಅವ್ರು ಆಡಿಸ್ತಿದ್ರು ಅಂತಾರೆ ಬಟ್ petitioners ಅಲ್ಲಿ ಬಂದು ಆಡ್ತಿದ್ರು ಅಂತ there is no allegation, my lordship. In the entire charges, my lordship, the petitioner ಅಲ್ಲಿ ಬಂದು ಆಡ್ತಿದ್ರು ಅಂತ there is no material shows, my lordship.
ಅಷ್ಟೇನಾ?
Yes, my lordship.
Various mobile phones, my lord, have been seized from the possession of these petitioners. And the only thing is that the record discloses that the mobile phones have been seized and subjected to Caesar Mazer.
ಅಷ್ಟೇ.
ಏನಿದೆ ಇವ್ರ ಮೇಲೆ? Ideally, that mobile data should have been extracted because case is, my lord, that the lottery numbers have been obtained from Kerala. Your mobile ಅಲ್ಲಿ ಅದನ್ನ ತಗೊಂಡ್ ಬಂದು ಅದನ್ನ ಇಲ್ಲಿ ಡಿಸ್ಪ್ಲೇ ಮಾಡಿ ಆಡ್ತಾ ಇದ್ರು ಅಂತ. That should have been part of the charge sheet.
It's not a part of the charge sheet.
In fact, I've asked for an explanation of what actually happened in case if there's something is missed out, etc. Should I have it next week, my lord? I'll check if something is there. Otherwise, I may
Heard
not have
the
it.
learned counsel appearing for the petitioner and the learned additional SPP. The petitioners are alleged of offences so and so, FIR not. It is the submission of the learned counsel for the petitioner that the complaint did not name them. It was only against accused number 1 to 4. Investigation has led to filing of the charge sheet in which these petitioners accused 7 to 9, 11 to 17, A19 and A26. A19 to 26,
Yes, my lordship.
A19 to A26 are dragged into the web of crime.
A28 and 30.
They are arraigned as accused while filing the charge sheet. The learned counsel for the petitioner submits that the charge sheet, the summary of the charge sheet only makes omnibus statement against these petitioners that they were holding mobile phones in which the lottery, which had been banned in the state of Karnataka and which were imported electronically from state of Kerala, was being circulated. No such indication is prima facie found in the charge sheet as to what was the material inside the material available in the phone of these petitioners. If there is a complete blur of those facts, it is rather difficult to continue the trial against these petitioners. The learned additional SPP would, however, submit that he has called for explanation with regard or verification with regard to the data present in the phones and would make his submissions on the next date. The next date is the final order. Yes, so on.
Instant.
Interim order subsisting shall continue till the next date of hearing.
Wednesday.
22, Wednesday, next Wednesday. ಜಾಸ್ತಿ ಆಗಿದೆ ಮೇಡಮ್. ಡೇಟ್ ಏನು? ವೆಡ್ನೆಸ್ಡೇ ಡೇಟ್ ಏನು?
19.
26 ಇದೆ. ಓಕೆ. 19. ಫರ್ದರ್ ಸ್ಟೇಟ್ಮೆಂಟ್. ಏನ್ ಕೇಸ್ ಇಲ್ಲ.
Further statement, my lord. As per the case of the complainant, my lord, the other bike was caused the accident. The police filed the charge sheet.
ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳ್ತಾರೆ, ಅವತ್ತು ನಾನು ನೋಡಿರಲಿಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ. ನಾವು ಐಡೆಂಟಿಫೈ.
For a moment, kindly see the complaint.
You are the owner of the vehicle.
Yes, other vehicle, my lord, which is not involved in the accident.
It's a matter of trial.
My lord, at least you could have filed the charge sheet against both the vehicles, my lord.
ಅದು ಮಾಡ್ತಾರೆ ಬೇಕಾದ್ರೆ.
Yeah, now already filed, my lord, charge sheet only against my vehicle, my lord. The other vehicle is
ಏನ್
left
ಮತ್ತೆ
out.
ಹಾಕ್ಬಾರ್ದು ಅಂತ ಸಪ್ಲಿಮೆಂಟರಿ ಹಾಕ್ಬಾರ್ದು ಅಂತ.
They will not file, my lord.
They will direct.
Negligence is found from his part.
That is true.
For a moment, my lord.
No, we will not, disbelieve this further statement altogether. For the reason that he says, I
see-
could not see the vehicle on that day, now I identify it.
Let's kindly see the date of accident, my lord. 1/10/2020 is the date of
ಹೌದು,
accident.
further statement 5/11/20.
Complaint is lodged on 7/10, my lords. After loss of 6 days, us getting it typed in
All
the,
that-
my lord,
All that will be a matter of trial.
in the complaint is clearly stated that one is seen the accident. For a moment, my lord, I'll read
Who
the
has seen
complaint.
the accident, but he is not identified who was driving.
That is, that who was driving is not in dispute, my lord. Which vehicle is involved in the
Which
accident
vehicle
in
is
dispute.
involved, number ಗೊತ್ತಾಗಿಲ್ಲ ಅಂತ.
Number ಗೊತ್ತಾಗಿಲ್ಲ sir. Bike ne, I am produced the IME report, last kindly see the IME report.
Yes, comment.
No,
Same
the
report.
statement, further statements of eyewitnesses.
All entire prosecution's case lies on this further statement. Yes.
All people have said the same thing.
IME report, last kindly see.
Yes, sir.
The vehicle which was involved, original involved in the accident is having damages. Man. My vehicle is not having any damages.
After 7 months
Malad,
investigation.
the police, my lord, last kindly see annexure E, my lord.
Yes, sir.
That is the vehicle, as per the complaint, case 16 EH1034, my lord. Front bumper plate bent, headlight assembly damage, crush guard.
You
damage.
want me to answer all that? I'll answer. Or you file a discharge.
Yes, I will file the discharge, my lord. Let the, my lord, prosecution, my lord, file the charge sheet properly, my lord.
ಅಲ್ಲೇ ಕೇಳಿ. ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಲ್ವಾ? ಹಾಕಿದ್ದಾರೆ.
ಹಾಕಿದ್ದಾರೆ. Only against my vehicle only they file the charge sheet, my lord.
Eyewitness.
Without any.
You impute both the vehicles.
Eyewitness' account is that his vehicle was driven rash and negligent. That is the
No,
eyewitness.
that is what, if they want, you can, charge sheet can be filed then also, sir, you can alter.
They will not file charge sheet, my lord. At least the respondent prosecution.
Now you
directed to
file
file-
discharge, if there is anything, it has to come back to me only, we'll see. The learned counsel for the petitioner, because if I answer on the further statement, all your options will be closed. The petitioner, the learned counsel for the petitioner, after arguing the matter at length, would seek leave of this court to draw the petition and avail of the remedy of filing a discharge against the discharge of seeking, file an application seeking his discharge from the array of accused in CC so and so. A liberty so sought is granted. Petition is disposed with the said liberty. Next.
The petition. 10 days time may be granted, madam.
Huh?
10 days time.
Why, sir?
ಅವ್ರೇನು ಸೆಟಲ್ಮೆಂಟ್ ಸಜೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ಅದಕ್ಕೆ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿದೆ, ಪಾರ್ಟಿ ಸಿಗ್ಲಿಲ್ಲ.
I was the second respondent in this case.
Settlement.
ಏನೋ ಹೇಳಿದೆ ಅವರಿಗೆ.
ಹೇಳಿದ್ದಾರೆ ಓರಲ್ ಆಗಿ, ಅದಕ್ಕೆ ಕೇಳ್ತೀನಿ ಸುಮ್ಮನೆ.
Both the counsel for the petitioner and the respondent in unison would submit that the talks of settlement being explored would resolve the dispute between the two. In that light, lest this matter on 28th, settlement, if any, be reported on the said date, failing which the matter would be considered on its merit. Interim order ಇದೆಯಾ? Interim order subsisting shall continue till the next date.
appearing for respondent number 2, my lords.
No
complaining.
representation on behalf of the petitioner.
Case and counter case.
Huh?
Case and counter case.
ನಿಮ್ಮ ಹಾಕಿದ ಕೇಸ್ ಏನಾಗಿದೆ?
Lords, we have no connection, contact with the parties, my lords. We tried to contact, my lords.
Which is your case? Crime number?
Crime number 3 of 23.
Page?
Page 53, man.
Why not 6, 504?
Yes, ma'am.
ಅದರಲ್ಲಿ 447 ಮತ್ತೆ 448.
448, 460.
The petitioners accused 1 to 3, 1 to 5. 1, 2, 3 and 5 are before this court calling in question registration of a crime registration of a crime in crime number 9 of 2022 registered on 14/1/2022. Heard the learned counsel appearing for the complainant. Counsel for the petitioner accused has been continuously absent. This court on so and so had passed on 28/5/24 had passed the following order. Even today, there is no representation of the in representation of the complainant. One solitary incident that happens on 30/12/2021 leads to registration of 2 crimes. One by the petitioners against the respondent in crime number 3 of 2022, alleging offences punishable under section 448 and 461 of the IPC, and the other against the petitioners registered by the complainant for offences punishable under 506 and 504 and 506 of the IPC. The averment in the petition is that these crimes have sprung on account of a civil dispute pending between the parties, which is due to an agreement of sale being entered into between the petitioner number 2 and the husband of the complainant, husband and the daughter of the complainant, alleging that the petitioners have trespassed into the house property of the complainants. The aforesaid complaint is registered, and the one registered against these petitioners are for the offences under 504 and 506. A perusal at the complaint would indicate that the ingredients of the offence under section 504 and 506 are clearly met, as the incident has triggered 2 crimes. If the crime registered in crime number 3 of 2022 narrates the incident and the crime number 9 of 2022 cannot be said that said incident has not happened. Therefore, the issue being a case and a counter case, it is appropriate that further investigation should be permitted against the petitioners, as further investigation is going on in crime number 3 of 2022 registered against the complainant. In the light of the aforesaid circumstance and for the aforesaid reasons, the petition being devoid of merit stands rejected.
I'm for respondent number 2 minutes. Senior is held up in court on number 14 minutes. There's 1 week time.
1 week held up ಆಗಿರ್ತಾರ?
1 week.
Interim order ಇದೆಯಲ್ಲ?
Yes.
Learned counsel appearing for the respondent seeks a week's time. Less the matter 2 weeks bit on Tuesday date. Interim order subsisting shall continue till the next date of hearing.
Please.
Waiting for respondent to kindly 3 weeks time to
Why?
file the objection, my lord.
Objection ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ ಹಾಕ್ಲಿಲ್ಲ.
This court heard the matter last week, my lords, my learned.
498.
Present.
498.
Yes.
Against us.
Senior. Next date of 3 weeks, sir.
Charge sheet.
3 weeks.
My lords, a matter is set down for trial, my lords. The charge sheet is filed with two witnesses. My wife's brother, my wife, one police constable, and a neighbor telling they were living in the next door.
It is
There is no
happened in the
exhibits.
COVID time, Your Honor. My lord.
Happened in the COVID time.
COVID time. COVID.
So ಬೇರೆ ಯಾರು
I
ಸಿಗ್ಲಿಲ್ಲ
don't know.
ವಿಟ್ನೆಸ್ ಕೋವಿಡ್ ಟೈಮ್ ಅಲ್ಲಿ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ ಅವರು.
I don't know if she's telling otherwise my husband was okay and in COVID.
Then sit down for trial.
It is set down for trial, my lords.
You are the husband.
I am the husband.
Trial should go on.
My lords, 498 is of course only against the husband, my lords. May I, my lords, pass on, my lords,
ಕೊಡಿ
to authorities, my lords.
ಅಚಿನ್ ಗುಪ್ತಾ, ಅಭಿಷೇಕ್.
No, my lords. And the other judgment is in Mahmood Ali, my lords.
Mohammed Ali, well drafted complaint, 2023 SCC online SC page 950.
Yes.
Next, ಆಮೇಲೆ.
Only these two judgments, my lords.
Yes.
May I only read the complaint?
I filed my.
It's a well drafted
objection.
complaint.
No,
So
my
this
lords.
court is expected to read between the lines and see whether the incident has happened at all.
Yes.
That's what Mohammed Ali says.
Lords, may I just read? It is a handwritten complaint, not typed, written by the complainant in her own hand. My lords, what stands out in 4 different places, she says the same thing.
Even if it is against the husband, you should look into the judgment in Abhishek Kumar. You have not seen?
I have, my lords, but
Where is it?
these were the most relevant, my lords.
That is even more relevant.
Yes.
2023 SCC online SC page 1083.
Lords, may I just
That is-
read the complaint once?
That is what. ಪರವಾಗಿಲ್ಲ ಅವ್ರು ಬರ್ಲಿ.
Priyanka Jaiswal.
Priyanka
Jaiswal, 2024.
24. Priyanka Jaiswal, Achin Gupta, all in favoring husbands.
And Priyanka Jaiswal is not in favor.
No, this Achin Gupta is
Yes.
is for that. Abhishek is straight away on the point. Minor indifferences between the two cannot result in offense under 498.
My lords,
But if you are saying 4 places, she narrates the same thing.
my lord, she narrates a statement of fact, my lord. She says, all this happened only in our bedroom where he threatened me and abused me. In front of everybody, he was a very nice person. He never let it show. There is nobody else, my lord.
Presumably so.
Yes, my lord, it's true. The charge sheet is filed now. We
Nobody
know.
need be there. Witnesses ಬೇಕಾಗಿಲ್ಲ ಈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮೇಲೆ ಆಗಲಿ.
ಅದಕ್ಕೆ ಅಷ್ಟೇ
We'll
ನಾನು
see
ಅಷ್ಟೇ
later.
ಓದ್ತೀನಿ ಅಂತ ಹೇಳಿ.
ಆಯ್ತು ಓದಿ. ಯು ಆರ್ ರೆಡಿ ಮೇಡಮ್? ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕ್ತೀರಾ?
Objection
ಹಾಕಿ
ತುಂಬಾ
ಏನಾದ್ರು
ಇದೆ.
ಯಾಕೆ?
Next
Yes. Let us file objection.
2
I'm
weeks
only
time.
requesting for stay of the proceedings until then.
On your account,
Filed for
it will have to be
divorce.
stayed. The repeated adjournments at the behest of the wife will not be entertained. 2022 in the objection ಹಾಕಿಲ್ಲ ಇವತ್ತು ಯಾಕೆ?
ಇಲ್ಲ, next date ಅಲ್ಲಿ
As a last chance, list this matter on Wednesday, the next, in the event.
ಇಲ್ಲ 2 weeks.
No, madam.
ಇಲ್ಲ ಇಲ್ಲ ಸ್ವಾಮಿ. Senior also out of station now.
ಪರವಾಗಿಲ್ಲ. So and so. The the matter is of the year 2022 and there is no interim order operating in favor of the petitioner. The learned counsel, Giridhar, submits that the matter is set down for trial.
Yes.
Set down for trial after charges having been framed against the petitioner husband. ಈ stage ಅಲ್ಲಿ ನಾವೇನ್ interfere ಆಗ್ತದೆ? Anyway, we'll see. So and so. The learned counsel appearing for the complainant would seek time, comma, yet again.
Mediation refer ಮಾಡಿದ್ರೆ it may settle around.
Mediation. You want to go to mediation?
ಇಲ್ಲ ಅದು just matter of 10 to 15 lakhs ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ.
Oh, negotiation ನಡೀತಾ ಇದೆ.
ನೆಗೋಷಿಯೇಷನ್ ಅಲ್ಲಿ ಅದು ಅವ್ರು ಬೇರೆ ಅಡ್ವೊಕೇಟ್ ಇದ್ದಾರೆ ಅದ್ರಲ್ಲಿ MC.
You want to go to mediation? I'll send it.
ಅದು ಸೆಟಲ್
What
ಆಗುತ್ತೆ
difficulties, my
ಡೆಫಿನೆಟ್ಲಿ.
The learned counsel for the
There is a
complainant.
difference, my lords. They want 30 lakhs. My
ಅದು ಗೊತ್ತು.
client has
That
offered
we'll see.
15.
I'm not on that.
I'm only, my lords, taking the court into confidence. That is the
One minute.
difference in terms of.
Mediation refer ಮಾಡಿದ್ರೆ
The learned counsel appearing for the complainant submits that if the matter is referred to mediation, the issue is likely to be settled between the husband and the wife.
It's also a divorce case, my lords.
One minute.
ಡೈವರ್ಸ್ ಕೇಸ್.
Husband and the wife. Therefore, the parties shall appear before the Bangalore Mediation Center on
Any day next week, both are in Bangalore.
on
24th of
24th June,
Yes.
24th June at 3 PM. List this matter on 28th June. In the light of the said circumstance, further trial and so shall remain stayed. Yes.
Grateful.
ಬರ್ತ್ಡೇ ಪಾರ್ಟಿ ಪೋಕ್ಸೋ ಅದೇನಾ ಇದು?
Your lordship heard me on more than one occasion.
22 ಅಲ್ಲಿ.
ಹೌದು. Just to refresh your lordship's memory.
Yes, yes.
I shall make a couple of submissions. But before I take your lordship to the facts of the case, my lord, which according to me looks like an Arabian Night story, which in fact is good for bedtime reading, and this story is not even good for bedtime
Same
reading.
submission. I still remember. Arabian Nights
That is why I said
for bedtime reading.
just to refresh your lordship's memory, that is how I said, my lord. Because I can't deviate from the submissions which I had made earlier.
You will never, I said, this is same submission you had made.
Please, please.
Yes, sir.
My lord, before I take your lordship to the facts of the case in depth, let me give your lordship a bird's eye view.
1 minute, sir. Served, is it?
Served.
Complainant is served.
Not appeared. Let me give your lordship a bird's eye view of the facts of the case.
Synopsis ಹಾಕಿಲ್ವಾ ಇವರು? What, Prithvish, why? Synopsis and list of authorities. Yes, sir. ತಾವು ಹೇಳಿ sir.
Madam, the petitioner before your lordship is a well-known, popular and recognized professor of the Indian Institute of
Science.
Indian Institute of Science with multiple doctorates and all that. And quite recently, he was deputed to a foreign country for as a delegate on behalf of the government of India. Quite recently, just about 10 days back. No, but all those things may not weigh much in your lordship's judicial. I'm just inviting my lord's kind attention only to show to your lordship the character, the conduct that could be imagined of this person. Except in that, nothing else. But on 30th of September 2018, there was a birthday party in the house of petitioner. Birthday of his daughter. But many were invitees to that birthday function. But the case of the prosecution in a nutshell is, on that day, the petitioner would go behind the screen, window screen, stand there. But while the children were playing some game, one after the other would keep moving near that window. And this man would keep touching inappropriately all these young girls, children. That is the case in a nutshell. I can understand one, I can understand two, I can understand three. Not one and all who had come there, unless and until, my lord, he is a maniac. He is a maniac. Well, that in a nutshell is the case of the prosecution. Well, basically, I am on certain important, serious legal issues which I have raised for my lord's kind consideration. Well, may I just first request your lordship to kindly turn to ink page 38. The proceeding sheet of the case, it commences at page 37. Have a look at
I
page
have granted an interim order, right?
Yes, interim order is there.
38.
38.
Cognizance.
Cognizance. But peruse the police report.
Yes.
And documents submitted along with the said report. On being satisfied exercising power under section 191B and 193 of the CRPC, cognizance is taken for the offences punishable under section 7 and 8 of the POCSO. Well, the 7 is the definition of the sexual assault and 8 is the penal class. Office is directed to register the special CC register with due conversion into crime number. Office to attend regarding the compliance of section 35(1) of the POCSO Act, securing statement under section 164, medical report, FSL report, property form, etc. Well, it involves here this order two things.
Yes.
Number one, well, cognizance. This is not certainly not in keeping with the mandate of law as mandated under section 190 of the CRPC.
Yes.
He does not even say that he has taken cognizance. It doesn't matter. Well, probably your lordship may say it implies when once he says that he has perused the records of the case, it may imply that he has taken cognizance. Well, peruse the police report and the documents. kindly read para 3 of this order at page 38. Office to attend regarding compliance under section 35(1) of the POCSO Act, that is securing statement under section 164, medical report, FSL report, property farm. Which document then he has produced?
Everything is pending.
Yes, my lord, not even produced. Secure these documents. What is it that the learned judge has produced then? For him to have taken cognizance, he has produced nothing.
Yes.
It is certainly not in keeping with the mandate of law, as mandated under section 190 of the CRPC would be my first submission. Because he was not having the advantage of the statements of witnesses,
FSL report and other
not
things.
even medical report, no FSL report, no properties, nothing, zero. Therefore, peruse the police report, my lord, does not certainly imply an application of mind on the part of the magistrate, which was required to apply at the stage of taking of cognizance. That would be my first submission. Well, the second submission would be under section 204 now. Well, under section 204, what the learned judge was required to see or find out is existence of sufficient grounds for the purpose of issuance of process to the accused. Well, at the day in and day out, we are canvassing before your lordship. 204, my lord, is not only in relation to a private complaint, but also in relation to a police report. That is the only power which you could exercise for the purpose of securing the presence of the accused by issuing process, be it an ordinary summons or a coercive process or a proclamation, whatever it may be. So what is needed to be seen by the learned judge when he exercises his jurisdiction in 204 is existence of sufficient grounds for the purpose of issuance of process. But there is no order under section 204 at all. May I now request your lordship to kindly, again, my lord, page 38, after he takes cognizance,
process not issued.
Illa. 204 ilve illa, non-compliance.
Basics they forget.
Not ಇದು 1000 ಸತಿ ಹೇಳಾಗಿದೆ, ಅವರು ಟ್ರೈನಿಂಗ್ ಕೊಡುತ್ತೆ, ಎಲ್ಲ ಮಾಡುತ್ತೆ. But this is the latest judgment of the Supreme Court. Your lordship, my lordship, is in the case of Vikas Chandra.
Yes.
Following
Taking of cognizance is not
yes, my lord, they are totally
casual thing.
Yes. My lord, may I just request your lordship to kindly attend to this is the latest judgment, my lord.
Yes, yes.
Paras 13 and 14, if my lord permits me, I shall take your lordship on a small paragraphs. A close scrutiny of the position of law. Well, I am not satisfied with, my lord, if my lord is persuaded to accept my submissions, ultimately your lordship may say, why on account of the mistake or the fault on the part of the court, the party who is aggrieved should be made to suffer. Your lordship may even say, all right, we will set aside this order and remit the matter. No, I am not happy with that. Anyway, I am just inviting my lord's kind attention to several legal issues which have arisen for my lord's kind consideration. Kindly go to paragraph 13 of the judgment in Vikas Chandra's case. This is in 2024, April part. A close scrutiny, my lord gets it.
February 22nd.
Yes, 22nd.
Written on February 22nd.
Oh.
Yes, sir.
Yes, February 22nd, but reported in Supreme today, April 2024.
ಇದು unreported ಕೊಟ್ಟರು.
ಅವ್ರು ಕೊಟ್ಟಿರೋದು ನನ್ನ ಹತ್ರ ಎಸ್ ಇದೆ ಸುಪ್ರೀಂ ಟುಡೇನೇ ಇದು ನನ್ನ ಹತ್ರ ಬುಕ್ಕೆ ಇದೆ ನನ್ನ ಹತ್ರ. It is reported, madam.
2nd February ಅಲ್ವಾ?
Yes. A close scrutiny of the position of law revealed from the aforesaid decisions, which are constantly and consistently being followed by this court, would reveal that issuance of summons in a serious matter is a serious matter, and therefore shall not be done mechanically, and it shall be done only upon satisfaction on the ground for proceeding further in the matter against a person concerned based on the materials collected during the inquiry. Well, here my submissions are two-folded. Number one, there is no order as such passed by the court under section 204 at all. Probably, in that view of the matter, this judgment did not be referred to or adverted to for this reason, that there is no order at all. Proceeding with an assumption for the sake of argument, though not considering for a moment that there is an order. For that, my lord, right from any number of judgments, In the aforesaid circumstances, the next question to be considered is whether a summons issued by the magistrate can be interfered with in exercise of the power under section 482 of the CRPC. In the decisions in Bhushan Kumar and another versus State of NCT, and in crime number so-and-so, Pepsi Food, their lordships would refer to more than one judgment, and then thereafter their lordships, whether the learned magistrate applied his mind to form an opinion as to the existence of sufficient ground for proceeding further, and in that regard, to issue summons to face the trial for the offense concerned. In this context, we think it appropriate to state that one should understand that taking cognizance empowered under section 190 CRPC and issuing process empowered under section 204 CRPC are different and distinct. Well, probably there is one.
Following Sunil Bharti Mitra.
Following, there is a larger bench judgment, a full bench judgment, their lordships would follow. Well, in paragraph.
In 4 SCC 609,
Paragraph
48, 49.
Yes, paragraph
48 and
48,
49.
49. At least, though not in detail, at least in one or two sentences, he has got to say, indicate that he has perused and there exists sufficient grounds for the purpose of issuance of process against the accused. But
And
at this-
GHCL 13.
with 30 years. Pretty difficult. ಸಾಹೇಬ್ರ ಹತ್ರ ಗೊತ್ತು ಬಿಡಿ ಅದೆಲ್ಲ.
GHCL.
ಅಲ್ಲ ಅದು ಕೊಡ್ತೀನಿ ಅಂದ್ರು
It's 13 4 SCC 50.
day in and day out, my lord, these are the points which we would be canvassing before your lordship. Therefore, there has been not only non-compliance with the provisions of section 190, there is non-compliance with the provisions of section 204 also.
No, 204, if there was an order, we could have examined whether, no, if there was an order, we could have examined whether there was application of mind sufficient material.
Whether he has.
When there is no order.
When there is no order at all. Well, kindly see, let me not. Next day's order, Miller, 21 December 1978.
Page?
Same page,
38.
38. Accused is present. Right? Without even summons.
Accused is present.
Yes.
Summons ಯಾವಾಗ issue ಮಾಡಿದ್ರು?
Summons issue ಆಗಿಲ್ಲ.
21 12 18.
ಇದು ಹೋಗ್ತಾರೆ ಪೊಲೀಸರು ನಾಳೆ ಕೇಸ್ ಇದೆ ಬಾಯಿಲಿ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಕರ್ಕೊಂಡ್ ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ ಪ್ರೊಫೆಸರ್ನ ನಿಲ್ಲಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಲ್ಲಿ. ಅಷ್ಟೇ ಆಗಿರೋದು. ಇದೇನು ಪ್ರೊಫೆಸರ್ ಅಂದ್ರೆ ಸ್ವಲ್ಪ ಹೆದರ್ಕೋತಾರಲ್ಲ ಕೋರ್ಟು ಸರಿ ಕಾನೂನಿನ ಹೆದರ್ಕೋತಾರೆ ನರ್ವಸ್. ನೆಕ್ಸ್ಟ್ ನೋಡಿ ಸ್ವಾಮಿ, ಕೈಂಡ್ಲಿ ಹ್ಯಾವ್ ಎ ಲುಕ್ ಅಟ್ ದಿಸ್. Accused is present for hearing before charge. Next day charge framed.
Next day charge framed?
Yes, my lord, 3112. Have a look at 3112.
Page?
Page 39.
Accused is present, counsel for the accused so and so. Post for framing of charge. Accused is present.
Page 68 is the typed copy.
Typed copy ಇದೆಯಾ?
ಇದೆ ಹಾಕಿದೆ.
ಇವರು ಬರೆಯೋದು ಡಾಕ್ಟರ್ಸ್ ಗಿಂತ ಕಷ್ಟ.
ಹೌದು.
Doctor's handwriting is impossible to decipher. In magistrates ಹಂಗೆ ಆಗಿದೆ. Yes. Page
68, man.
68. What date is that? Counsel for the accused present, charge sheet copy furnished under section 207. Accused is present, counsel is submission present upon submission, posted for charge. Charge is read out, explained to him, not guilty.
Lordship may recall to your lordship's memory, in one of the cases which my lord has passed an order saying that where my learned friend has also appeared in that case, that Murugamat's case. Supreme Court has confirmed that order.
Confirmed?
Yes.
Challenge ಮಾಡಿದ್ರಾ?
Yes, my lord. Supreme Court has confirmed in the sense in a subsequent order which came to be passed by the Supreme Court, where the appointment of an administrator.
That was challenged.
That was challenged. In that, their lordships would make a reference. The High Court has already directed the alteration of charges on more than one ground. The trial court shall proceed to frame the charges as directed by the High Court.
By my order.
By your lordship's order. In that judgment, why I am inviting your lordship's attention to that judgment is for this reason. Under section 227 and 228 of the CRPC, well, merely because I give a concession, I am not giving any concession to the court.
So that is a duty cast upon the court.
Well, that is what the
That's what I've written.
a full bench judgment of the Supreme Court in Sanjay's
So
case.
the interplay between 227 and 228 was completely ignored.
That's how your lordship has.
So in that what's that, PG scam matter also I've written one.
Yes. My lord,
ಅದ್ರಲ್ಲೂ ತಾವೇ
my lord,
appear
a
ಆಗಿ-
duty is cast upon the court to examine the record of the case. My concession to the court.
Because 228 springs in only after 227 is satisfied.
So he is satisfied. Here, my lord, I have not given any concession to the court here. The court proceeds to frame a charge against me.
ಯಾವ ಪ್ರೊಫೆಸರ್ ನ ಕರ್ಕೊಂಡು ಎದುರಿಸ್ಬಿಟ್ಟು ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡಿದಿರಲ್ಲ. ವಾಟ್ ಇಸ್ ದಿಸ್?
ಇನ್ನೂ ಹೇಳ್ತೀನಿ ಅಲ್ಲ, ಇಷ್ಟೇ ಸಾಲಲ್ಲ, ಇನ್ನೂ ಇದೆ, ಬೇಕಾದಷ್ಟಿದೆ. ಒಂದು ನಿಮಿಷ ತಡಿ.
ಇಲ್ಲ, ಕೋರ್ಟ್ has terrified this man. He said,
ಅಷ್ಟೇ.
whatever he says, charge frame ಆಯ್ತು.
ನಿಲ್ಲಿಸ್ಬಿಟ್ಟಲ್ಲಿ ಹೇಳುವಂತ.
Represented by counsel.
What counts? What procedure?
ಸರ್ ಇನ್ನೇನ್ ಮಾಡ್ತಾರೆ, ಹಿಡ್ಕೊಂಡ್ ಬಂದ್ರೆ ಕೌನ್ಸಿಲ್ ಇಲ್ಲದೆ ಇದ್ರೆ ಜೈಲ್ಗೆ ಕಳಿಸ್ಬಿಡ್ತಾರಲ್ಲ.
ಯಾಕಂದ್ರೆ you have
ಜೈಲಿಗೆ ಕಳಿಸ್ಬಿಡ್ತೀರಿ.
the dragon in front of you, POCSO. Yes. Yes, sir.
My lord, now, may I just request your lordship to kindly go to the statements of witnesses which the investigator has recorded during the course of investigation of the crime.
It's part of the record here.
Yes, my lord, I have produced. ಇದು ಏನಾದ್ರು we need to put an end to this
Yes,
kind of
this
practice.
is why I'm hearing. Otherwise, I would have passed an order straight away. Because there are judgments which cover the entire issue. This should be stopped.
ಅಲ್ಲ, ಇದು ಮೆಕ್ಯಾನಿಕಲ್ ಆಗಿ ಒಬ್ಬ ಸ್ಟೇಷನ್ ರೈಟ್ ಏನ್ ಮಾಡ್ತಾನೆ, ನಾನು ಮೇಲ್ಕಂಡ ವಿಲಾಸದಲ್ಲಿ ವಾಸ, ಅಲ್ಲಿಂದ ಶುರು ಆಗ್ಬಿಡುತ್ತೆ ಅವಾಗ. In fact, in one of the cases which I had argued about 45 years back, my lord, before a bench of Justice Hanaya and Justice Nesargi,
Yes, sir.
they had said, my lord, Paul, it is a case of bride burning. It was third degree burns. Kerosene came to be poured on the head of that lady. Whole body was burnt. My lord, the only thing she could do is, when the policeman or someone else goes, ಅರೆ ಉರಿ ಕಾಪಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ ವಿನಃ, ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿದ್ದೇನೆ, ನನಗೆ 4 ಎಮ್ಮೆಗಳಿದೆ, 4 ಎಮ್ಮೆಗಳಲ್ಲಿ ಇಷ್ಟು ಹಾಲನ್ನು. Would she be in a position to make such a kind of statement at a point of time, my lord, when she was about to breathe her last? A dying declaration which runs to about 2 to 2.5 pages with third degree burns from top to bottom. This is what they do. But may I just...
No, that is known. You think the charge sheet, the summary of the charge is written by the investigating officer? Illa. Alli police station writer bariyodu. Every 498A case has verbatim similar things written by the writer in the police station.
In fact...
No IO writes it.
In fact, this court, my lord, in the unreported judgment, speaking through Honorable Mr. Justice Venugopal Gowda has written an order, but that is not a reported judgment. Ultimately, what his lordship would say is the trial court, before proceeding to frame charge, shall consider all these things. This court did not lay down any law. May I request your lordship to kindly have a cursory look at section 160 and then 161.
Here.
Kindly go to 160 first before I take your lordship to 161. Then I shall take your lordship to the statements.
No, because we'll elaborately consider this.
Yes.
Yes. 160.
160. Police officers' power to require attendance of witnesses. Well, he can certainly secure when he exercises power under section 160. That is the power of policeman as far as investigation is concerned, which he does under 154. Well, now kindly go to 161 now. Any police officer making an investigation under this chapter,
yes,
or any police officer not below such rank as the state government may by general or special order prescribe in his behalf, acting on the requisition of such officer, may examine orally any person supposed to be acquainted with the facts and circumstances of the case. He can certainly do it. Now let us go to 2. Such person shall be bound to answer truly all questions relating to such case put to him by such officer, other than the questions, the answers to which would have a tendency to expose him to criminal charge or to a penalty or forfeiture. Well, the consequent to the protection that is given to him under the Constitution. Number 3, this would be important. The police officer may reduce into writing any statement made to him in the course of an examination under this section, and if he does so, he shall make a separate and true record of the statement of each such person whose statement he records. That question he has to put. That is under 161(1). Then, my lord, he must truly record it. Now, my lord, let us see how he has recorded. May I just request your lordship to kindly turn to page 13 of the charge sheet which I filed on 17th of March 2022.
Well, happy. Charge sheet.
Along with my memo, I placed it entire.
17.
ಅಲ್ಲ ಅಟ್ಲೀಸ್ಟ್ ಒಂದೊಂದು ಅಕ್ಷರನಾದ್ರೂ ವ್ಯತ್ಯಾಸ ಬೇಡ ಒಂದ್ ಸ್ವಲ್ಪ. ಎಲ್ಲರೂ ಅದೇ ತರ ಹೇಳ್ತಾರ ಮಕ್ಕಳು ಪ್ರತಿಯೊಬ್ಬರು. ನಾನು ಮೇಲ್ಕಂಡು ಅಲ್ಲಿಂದ ಶುರು ಆಗ್ಬಿಡುತ್ತೆ. Doesn't matter. My lord, may I just request your lordship to kindly turn to page 13.
ನಿಮ್ಮ ಹತ್ರ ಇಲ್ವಾ?
13.
ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಪಿ ಇಲ್ವಾ ನಿಮ್ಮ ಹತ್ರ? ವಾಟ್ ಇಸ್ ದಿಸ್? ಕೊಡಿ.
ನಮ್ಮ ಹತ್ರ ಇದೆ. ಕೊಡಿ. ಜಗದೀಶ್
ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಹತ್ರ ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಪಿ ಇಲ್ಲ.
ಅವ್ರಿಗೆ ಯಾತಕ್ಕೆ ಅಂದ್ರೆ ಪ್ರಾಬಲಿ he would have considered ಅದಕ್ಕೋಸ್ಕರ ಇಟ್ಕೊಂಡಿಲ್ಲ ಅಷ್ಟೇ.
ಆ ತರ
ನಾನು
SPP is very fair.
No, he is very fair. I know him.
Definitely he
Very
is.
fair, very fair. My lord, would your lordship kindly turn to page 13, first witness.
1-3.
Yes. First paragraph, ಒಂದೊಂದು ಸೆಂಟೆನ್ಸ್ ಓದ್ಕೊಂಡು ಹೋಗ್ತೀನಿ, ಜಾಸ್ತಿ I will not disturb you lot. ನಾನು ಮೇಲೆ ವಿಳಾಸದಲ್ಲಿ ನನ್ನ ತಂದೆ ಅಚ್ಚಾಯಿ. Second witness, kindly go to page 19.
ಸೈಕ್ಲೋ ಸ್ಟೈಲ್ ಅಲ್ಲ.
ಸೈಕ್ಲೋ ಸ್ಟೈಲ್ ಆಯ್ತಾ? Now my lord, forget about all those things. Let us talk of the incident itself. ಇನ್ಸಿಡೆಂಟ್ಗೆ ಒಂದೊಂದು ಮಗು ಬಾಯಲ್ಲಿ ಒಂದೊಂದು ಸ್ವಲ್ಪನಾದ್ರೂ ವ್ಯತ್ಯಾಸ ಇರುತ್ತಲ್ಲ. ಅಟ್ಲೀಸ್ಟ್ ನಾವು kindly go to the last paragraph at page 13 and onwards. That is the last paragraph. ಸ್ವಲ್ಪ ಸಮಯದ ನಂತರ ಅಂಕಲ್ ನನ್ನ ಹಿಂದಿನಿಂದ ಬಂದು ನನ್ನ ಬಟ್ಟೆ ಮೇಲಿಂದ ಮುಟ್ಟಿದ್ರು. ಆಗ ನಾನು ಯಾರೋ ಮಕ್ಕಳು ನನ್ನ ಹಿಂದಿನಿಂದ ಹೋಗುವಾಗ ಟಚ್ ಆಗಿದೆ ಎಂದು ಸುಮ್ಮನಾದನು. ಅಂಕಲ್ ಮುಟ್ಟಿದ್ರು ಎಕ್ಸೆಟ್. ಬರ್ಡೇ ಪಾರ್ಟಿ. Now the next witness, madam. Same. Verbatim reproduction or carbon copy of the statement of one witness. ಎಲ್ಲದರಲ್ಲೂ ಅದೇನಾ? Is it in keeping with the mandate of law as mandated under 161(1) and 161(3)? Truly record. Otherwise, my lord, what happens? He can prepare for himself because he does not need his the signature of the witness. Plus this statement as evidence, acceptable evidence at this point of time, unless and until it is put to test during trial. My lord, your lordship may recall to your lordship's memory, time and again I would be making the submission. What Justice Chagla had said. Justice Chagla, in one of the judgments which he wrote, my lord, that was a case of dacoity. With the policemen in their armory have two weapons. One is section 161 of the CRPC.
Yes.
And the other is section 27 of the Evidence Act.
Yes.
161 CRPC.
Corroborative material.
No right and anything and everything.
Yes.
Keep
And
it on
take
as
recourse to
acceptable
27.
evidence. Then under section 27 of the Evidence Act, no, record the statement to the accused saying that if I am taken, I will take you to such and such a place where I have hidden the weapon used for the commission of the crime. Well, that would be pressed into service as evidence. Well, if those two, 161 CRPC and section 27 of the Evidence Act, are removed from the statute, the policeman is just like a snake without a teeth. That is what Justice Chagla had said.
True.
Yeah, same mechanical reproduction.
I saw.
But now let us go to. Now kindly go to the POCSO. Well, it is a self-contained code. Investigation is to be done in accordance with the provisions of the POCSO.
Yes.
Quite often your lordship would say, listen until you say POCSO, not as POSCO.
Telugu.
Pronounce it properly, well, and therefore your lordship will continue to hear me.
Generally it is done that way. I keep correcting. No, it's POCSO. ಪೋಸ್ಕೊಳ್ಳೋದಲ್ಲ.
May I request your lordship to kind in good humor, my lord?
Yes. Of course, yes.
Sometimes we need humor in court.
Break the monotony. Yes.
But may I just request your lordship to kindly turn to chapter 6
of POCSO code.
It is a self-contained code. It leaves no doubt. He has got to investigate in accordance with the provisions of this act. It is a special act. It is a central act.
Yes.
Where procedure for investigation is prescribed. Well, chapter 6 prescribes the procedure for investigation.
Yes.
Kindly first go to section 24.
Recording of statement of
Yes,
the child.
The statement of the child shall be recorded at the residence of the child or at the place where he usually resides or at the place of his choice and as far as applicable by a woman police officer not below the rank of a sub-inspector. The police officer while recording the statement of the child shall not be in uniform. The police officer making the investigation shall, while examining the child, ensure that at no point of time the child comes in contact with any of the accused persons. That is the procedure that is prescribed under section 24, 1, 2, and 3 subclauses. Now kindly go to section 26 for a second.
Additional provisions.
Yes. Additional provisions regarding the statement to be recorded.
Yes.
The magistrate or the police officer, as the case may be. But magistrate comes into picture when the child is taken before him.
Yes,
Or the
164.
witness, under 164. But as far as the police officer is concerned, he has got to record the statement as mandated under section 24 of the Act, or my lord, under section
161 of the
161 of
CRPC.
the CRPC. The magistrate or the police officer, as the case may be, shall record the statement as spoken by the child in the presence of the parents of the child or any other person to whom the child has trust or confidence. A plain reading of the statements recorded by the policeman. Well, does it infuse any amount of confidence in your lordship's judicial mind that this statement came to be recorded in the manner spoken to by the child? Well, now kindly go to subclass 4. Wherever possible, the magistrate or the police officer, as the case may be, shall ensure, well, it is mandatory, shall ensure that the statement of the child is also recorded by audio, video, electronic means.
That is crimes against women.
No, my lord.
In this POCSO.
In this POCSO,
So
my lord.
even 161, if you see,
Yes.
exception is
Yes, yes,
carved
yes.
out in
That is under section
354.
300.
Wherever crimes against women, they should be,
Well,
they can
this
be
is the
electronically recorded also.
Why it is so for this reason? Well, it is a protection that is given not only to the child, but also to the accused who is to be prosecuted in the case. Because the child may not be knowing what it has said or not. What did she say? What did he say? Statement of the child is also recorded by audio, video, electronic means. Shall.
What is the medical report?
No, next point is that, Malad. No medical examination at all. Why? No. Internal injuries irbodu. No. Why I should submit to your lordship now? There has been a total non-compliance with the mandatory requirement of law as mandated under section 26 of class 4. Well, audio, video. Where is the audio? Where is the video? Nothing. They have taken away the protection that is given to an accused under the provisions of the POCSO. Had it been there, probably your lordship would have been certainly in a position to know whether the child has said so or not.
Because even the 164 statements are cyclostyle. That is shocking. Even before the magistrate, what the children have said, ella cyclostyle.
The only issue.
Repeat.
Subject to senior counsel.
Muxpurli, that, yes.
But now, I think I need not labor much on this point. When law prescribes, my lord,
a thing to be done. Shall be done or not
otherwise,
at all.
it
Yes.
will have invalidating consequences. Is law that is being laid down by your lordship time and again, and also by the Honorable Supreme Court. I need not lay down. When once it is a shall, it means it is not directory, it is mandatory. It is mandatory. No, my lord posed a question to me. Where is the medical examination report? May I now invite your lordship's kind attention to section 27 of the Act. Violation after violation.
Medical examination of the child.
The medical examination of a child in respect of whom any offense has been committed under this Act. When you are prosecuting me, when the allegation against me is under section 7, which is made penal under section 8 of the Act, any offense, whether there is injury, no injury, let the doctor say no injury. You can't say that I will not subject myself for medical examination. Adan torstini, carbon copy adannuve. Ellaru idaralla 8 jana, 8 janadu carbon copy. But now here kindly see, in respect of whom any offense has been committed under this Act, shall, notwithstanding that a first information report of the complaint has not been registered for the offenses under this Act, be conducted in accordance with section 164 capital A of the Code of Criminal Procedure. Compulsory, madlebeku. Violation. Again, invalidating consequences. But why they don't do it? Your lordship would get from my compilation of the charge sheet. May I just request your lordship to kindly turn to reading page 57 and onwards. My lord, I just now took your lordship to the 161 statements.
Yes.
Adral.
ಇದ್ಯಾರ್ದು ಸ್ಟೇಟ್ಮೆಂಟ್?
ಇದು ಇವ್ರು ಬರ್ಕೊಡೋದು ಎಲ್ರದ್ದು ಅದೇ ಒಂದೇ ಕಾರ್ಬನ್ ಕಾಪಿ. ಮೆಡಿಕಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಬೇಡ ಅಂತ. All would come into existence on 1st of October 2018.
1st of October.
1st of October 2018. ಎಲ್ರದ್ದು ಒಂದೇ ದಿನ. ಏನ್ ಹೇಳ್ತಾರೆ? Reference to your notice dated 1/10/18. ಅವತ್ತೇ. I hereby decline medical examination of my daughters. So and so, so and so. They are aged 9 years. They are not been bruised or injured physically. I do not want to cause mental harassment. Next to other, aged 9 years. She has not been bruised and injured physically. I do not want medical examination. Next to, how does each ಗೊತ್ತಾಗಬೇಕು bruise ಇದೆಯಾ ಬೇರೆ ಇಂಜುರಿ ಇದೆಯಾ ಎಲ್ಲರೂ ಒಂದೇನಾ? Every page. Well, this is again a flagrant violation of the mandate of law as mandated under section 27 of the act. This would be my next legal submission. My lord, subject to what my lord would ultimately say. My lord, no sooner the court takes cognizance of the offense, and within 30 days, that is what the law mandates. The trial court shall record the evidence. May I request your lordship to kindly turn to section 35.
Yes.
The evidence of the child shall be recorded within a period of 30 days of the special court taking cognizance of the offense, and reasons for delay, if any, shall be recorded by the special court.
Yes.
ಏನಿಲ್ಲ. For years together it is getting adjourned.
ಅಲ್ಲ ಇಲ್ಲಿ ಸ್ಟೇ ಮಾಡಿದೀವಲ್ಲ.
ಈಗ ಬಂದಿರೋದು ನಾವು 2022 ನಲ್ಲಿ, ಇದು 2018.
ಅವಾಗಿಂದ ನಡೀತಾನೆ ಇದೆ.
ಅವಾಗಿಂದ ನಡೀತಾನೆ ಇದೆ. This is again violation of section 35.
Yes.
Lord, if my lord is persuaded to accept my submissions, right from the date of taking of cognizance of the offense, that also we do not find. We have to presume that he has taken cognizance of the offense on 17th of December 2018 or 18th of December 2018.
Why, what was the motive behind the
But
complaint?
yes, my lord, it is an apartment where number of flats are there. In one floor, 6 flats are there in one floor. Well, in 2 of the floors, my lord, the informant has been running a PG hostel.
You have objected to it.
I objected to that. And the resultant effect is I am prosecuted. But
Where do you get that pleading is to that effect is there?
Leading illa photos ಇದೆ ಕೊಡ್ತೀನಿ.
Photos?
ಅಲ್ಲ PG ನಡೆಸ್ತಾ ಇರೋದು.
ಅಲ್ಲ ಅದು pleading ಇದೆಯಾ?
ನಾನು ಕೇಳಿದೆ ಅದನ್ನ ಅವತ್ತೇನೆ. ಒಂದು pleading ಬೇಕಾಗಿತ್ತು ಅಂತ ಅವಶ್ಯಕತೆ ಇತ್ತು.
Because finally if you have to answer motive, it seals. Then we will hear the additional SP.
Please.
Yes, sir.
ಅಲ್ಲ ಇದರಲ್ಲಿ
ಇನ್ಯಾವುದಿದೆ ಸರ್?
ಅಲ್ಲ ಒಂದು ನಿಮಿಷ ಕಂಪ್ಲೇಂಟ್ ಓದ್ಬಿಡ್ತೀನಿ ನೋಡೋಣ ಏನು ಎಲ್ರದ್ದು ಅದೇನೆ.
Which?
Yes. Your lordship may kindly turn to page 80 of my petition.
80.
Typed copy, you will not 82. Well, does it not defy elementary logic and common sense, my lord?
ಇಷ್ಟೇನಾ?
ಇಷ್ಟೇ ಏನಿಲ್ಲ. ಒಬ್ಬರಾದ್ಮೇಲೆ ಒಬ್ರು ಬರ್ತಾ ಇದ್ರಂತೆ ಕತ್ಲೆನೆಲ್ಲ ಸಾಲಾಗೆ, ನಾನು ಸ್ಕ್ರೀನ್ ಇಂದ ನಿಂತ್ಕೊಂಡಿದ್ದಂತೆ ಎಲ್ಲರನ್ನು ಮುಟ್ತಾ ಇದ್ದಂತೆ ಇನ್ಅಪ್ರೋಪ್ರಿಯೇಟ್ ಆಗಿ. I can understand one, I can understand two, not all. And next day complaint.
Who is the complainant?
Well, the complainant is the father
of
one of the child.
One of the child.
Yes.
Speaking for every child there.
He speaks for every child.
Hmm. And where is the charge sheet?
I'm sorry, Madam.
Charge sheet?
Yes, your lordship will get the charge sheet.
31.
30?
1.
I have given the full set of the charge
Yes,
sheet along with the
yes.
memo, my lord. This column number 7, it commences at page 31, my lord. 31,
Yes.
column number 7.
And it is continued at 35.
Yes. It continues at page
35.
25 ಮಕ್ಕಳು ತಗೊಂಡಿದ್ದು.
Yes, sir.
The issue of taking cognizance, my lord, the record says perused. With respect to non-furnishing of document, medical report, FSL report, it was not there. So therefore, the court may have sought for it if it is there. Your lordship may see that the charge sheet itself says that medical report is not there. Therefore, FSL report is also, it cannot be a.
Well, medical report ilve illa, examination agilla, what report?
Therefore, though the court said, my lord, probably it mechanically sought for a report in case, since it was absent in the charge sheet, probably mechanically they sought it, my lord, but it has no consequence of present case in hand. Because what is required in this case is only the statements and the 164 statement recorded during the course of
Illa
investigation.
cyclist, right? 164 statement to cyclist.
Your lordship may see the incident. It's not that incident happened at multiple locations. Incident happened at one place
One location.
and one time. So action is that he is touched them inappropriately at wherever this thing.
That is what the complaint says.
The correct, my lord. So that is what 161 statement, I can understand, my lord, 161 statement is verbatim as senior counsel has read out it. 164 statement.
Even that is verbatim. Nodi.
I've seen that.
See.
Yes,
Even that is the same.
but the fact that, my lord, at least
That
there
is precisely why I saw the 164 statement
Lord,
also. Nodi ನೀವು.
English Kannada ಎರಡೂ ಇದೆ.
The English ಅಲ್ಲಿ ಇರೋದೇ ನೋಡಿ.
ಎಲ್ಲರಲ್ಲೂ it's similar.
ಎರಡು ಒಂದೇನೆ.
ಹೌದು. The issue is that he has touched them when they were playing. So if it is in a different location, if it is a different victim, a different time zone, this we could have said it, my lord, it maybe some
What
doubt.
do you say about gross procedural violations?
With respect to that, my lord, there is they are not, ultimately he can take benefit of those things if it is against this thing. The only issue
In a trial.
wherever it is provided.
In a trial.
In a trial, wherever it is provided shall. It is not necessary, of course, it's mandatory, but wherever it is provided.
It's wholly penal. It should be, even if it is may, it should be read as shall only.
Like that language also used, my lord, wherever it is provided. So therefore, it is not that, of course, he can take the benefit if it has not been done during the course of trial. But at this stage, my lord, when evidence has been begun, charges have been framed, of course, there is an issue with.
Is that the way to frame charge? What happens to 227, 228? All those procedures contemplated. How can the court give a go-by completely to that?
The 227, my lord,
Well,
though
application,
it
of
is,
course.
though it is not on record, I'm not sure whether.
ಏನಾರ ಒಂದು ಆಪರ್ಚುನಿಟಿ ಕೊಡ್ಬೇಕಲ್ಲ.
ಇರ್ಬೇಕಾಗಿತ್ತು, but we are not
Straight
sure.
away you post it for charges and you frame the charge and continue the trial.
Because of the 30 days limitation as senior.
ಏನ್ 4 ವರ್ಷದಿಂದ ಏನ್ ಮಾಡಿದ್ದೀರಾ?
ಅಲ್ಲ, but that is the.
30-day limitation for recording of evidence. You have not, 4 years in they have not done anything.
No, that is the why
Petition
time
is
was,
filed in 22.
Correct.
The crime is of the year 2018.
why time was not granted for framing of charges is because from the date of taking.
Sir, if the date of limitation takes away the right of a person, then that limitation cannot be acted upon.
And of course, there are.
That's
series
not
of-
correct, sir.
Series of judgment which said that the time limit which prescribed is not mandatory.
Yes, definitely. That time limit is not mandatory because if that is held to be mandatory, then every court will close the proceedings and proceed to record evidence.
Yes. No,
What happens to the right of the accused? Yeah, equal right of the victim accused should be balanced both.
so therefore, my lord, the maximum, the order of cognizance probably may go, and it has matter has to be, probably have to remand back to the, remand back press trial, especially when we have a 164 statement exists which speaks.
Every child has spoken similar.
Because the incident is similar. I'm saying, my lord, incident is similar. It is
No,
not
even
that-
the narration of the kind of touching also is similar. Even in the,
It's probably that
why medical examination was not done?
Because there
Because
was- there-
request was made not, don't do medical examination.
it is no injuries have been done. It is only touching them.
The whole problem is that we could have taken it on its face, but POCSO has also become a element of misuse in every case. To settle other scores, the children are projected.
But that
The
they are
parents forgetting that they are, defaming their own child.
they are not pleading any malice in this prosecution, or there is any motive to prosecute.
Well, that's what I asked. What is the motive?
There is nothing in the pleadings to show that this is the reason they're prosecuting. Even then, malice and motive, my lord, its matter has to be
No, that is
matter for
tried
trial.
on. That will see whether procedural violation.
That away
was-
will not take away the entire.
No, if the very act of framing the charge in a
That-
hurried manner,
Yes,
if that goes, then everything.
it has to be send it. Clock has to send it back to the
Yeah,
trial
we'll-
court for
We'll see.
fresh consideration. That is what your lordship has done in Murugamat, my lord, that your lordship has set
I
aside
will,
the.
I have asked them to redraw the charges because charges were, hopelessly framed. And sir says Supreme Court confirm agide. I didn't know that.
I also did not.
Yes. You had appeared in that.
No, not in Supreme Court. We have not filed any
No,
appeal.
Ali.
We have not filed any appeal.
No, in the matter you had appeared here.
Correct. Alas.
Yes, sir. Anything else, sir?
One sentence ಅಷ್ಟೇ.
Yes, sir.
Complaint ಅಲ್ಲಿ just like a pro bono publico ಇದ್ದಾಗಿದ್ದು. He files the complaint not only being the aggrieved parent of the child, page 82 minutes. Typed copy, your lordship put at page 82. Paragraph, last but one paragraph, minute, on the bottom.
Yes.
The other parent whose kid has been impacted by this abuse is Mrs. So-and-so ಅಷ್ಟೇ.
I have seen.
ಅಲ್ಲ ಇಲ್ಲಿ 10 ಜನ ಎಲ್ಲಿಂದ ಬಂದ್ಬಿಟ್ರು ಅಂತ.
No, that has been answered next page.
ಏನ್ ಸರ್?
One of the parents reported the incident to other parents.
Oh.
And so
One of the parents.
immediately called so and so. We discussed family and filing.
ಅಷ್ಟೇ.
No, even the reporting of this incident, my lord, the reporting has also been done. It is not that there is a delay in reporting, therefore some doubt can be cast on.
Let's see. Yes, sir.
One more sentence. Your lordship posed a question to me. Have you pleaded malafidis?
Yes.
And kindly turn to page 25, paragraph 5.5 minute. Though not in extenso, we have said, my lord, it is a malafide action. 5.5 para. It is contended that even on the merits of the case, it is apparent that the de facto complaint has lodged a complaint against the petitioner to solely settle some personal score between him and the petitioner.
Yes. What kind of personal score is?
ಅದು ಸ್ವಲ್ಪ ಡೀಟೇಲ್ಸ್ ಇರಬೇಕಾಗಿತ್ತು. ಅದು ಸ್ವಲ್ಪ ಸಪೋರ್ಟಿಂಗ್ ಮೆಟೀರಿಯಲ್ಸ್ ಇರಬೇಕಾಗಿತ್ತು. ಇಲ್ಲ, it is not there. But the fact remains that I have pleaded a case of malafide.
True, malafide. It should have been a little more.
I am inviting my lords. ಸ್ವಲ್ಪ
a little more elaborate.
Elaborate ಆಗಿದ್ದಿದ್ರೆ it would have probably appealed to your lordships more than what is appealing to your lordship now.
And also all other victims who have spoken in 164 statement, why will they lie before the court also? I mean, there is nothing in the record to show that it's, assuming that, my lord, we will take it as a.
It's one step higher than 161 ashte.
Correct.
In fact, my lord, what the Supreme Court has said and is a coordinate bench of dishonorable court speaking.
So it should not be taken as sacrosanct.
Yes, my lord, that is what the Supreme Court has said. And you can't place it in a better pedestal than the statement recorded under 161. At best, my lord, the only thing that could be made use of by the prosecution or by anyone, my lord, who is aggrieved, 164, you can use it for the purpose of prosecuting the witness for perjury, nothing more and nothing less. You can't keep the statement recorded under 161 in a higher pedestal than the statement that is recorded under 161 CRPC. That is the law.
Will answer it. Heard the learned senior counsel, C.V. Nagesh, appearing for the petitioner and the learned additional SPP. List the matter on 22nd for further hearing. I'll dictate on that.
Interim order may kindly be
22nd Saturdays.
Interim order may kindly be
Interim order subsisting shall continue till the next date of hearings. Yes.
Matter your lordship may have it next week, now there is some issue with the file we lost.
A17 and 18 students.
Yes, my lords.
Hmm.
Lords, with respect to this, the accused number 17 and 18, they are just the candidates, my lords. With respect to this, there is no such prima
But if
facie
you are the
matter.
beneficiaries of the fraud,
But my lords, the only thing over here is, I request this honorable court, kindly page number 52, my
no,
lord.
that I have
Page
seen,
number.
let him come up with an answer. A17 and A19 are students who took part in the examination and they are purported beneficiaries of the act. Whether you can haul them, you'll have to convince.
And they are being arrested on the 24th of January. my
Bail
lords.
tagoli.
My lords,
Bail.
bail has been granted, my lords. That is been done.
Then
I'm asking for the quashing of the.
that's all right. Quashing, you need not be in a hurry to quash.
Yes.
You're out on bail?
Yes, my lords.
Yes. When do you want?
Wednesday, my lord.
19th again.
19.
At the request of the learned additional SPP, list the matter on 19th for admission.
We have filed the NOC Vakalat.
ನಿಮ್ಮ ಹೆಸರು ಹಾಕ್ಬೇಕಾ?
Yes, my lords.
You're not Muralidhar?
No, my lords.
Learned counsel so and so submits that he has entered appearance in place of Muralidhara or registry to print the name of so and so as appearing for the petitioner and delete the name of Muralidhar. Next.
Enrollment number.
The person who wrote exam, my lord.
For the petitioner in this matter, my lords. Dispute,
Who-
my lords, arises out of a sale agreement.
I know.
He is the person who wrote the exam.
Huh?
He is the person who wrote the exam.
Road, are they beneficiaries of the,
Allala.
Huh?
He was, he, on behalf of somebody else, he wrote.
oh,
the-
personation, impersonation.
Personation.
Then they will suffer. We'll see. Yes. Next week, yes. Rahul, yes.
Yes, my lords. The dispute arises out of a sale agreement, my lords, dated 29/1/2015. Offences, my lords, are.
Date of the agreement.
29/1/2015.
There is some respondent is here.
Yes, my lords. The respondent is represented by counsel.
There is no representation also awaiting his appearance. Ah, yes, sir. Tell me.
Agreement date is, my lords, 29/1/2015. Offences, my lords,
29?
are section 406,
One
470.
pass over ಕೊಟ್ಬೇಡ. In case they don't come,
Public.
I'll pass orders. It's my interim order. Yes, next. ಇದು impersonation.
He is the person who wrote the exam.
Ah. Same exams. 19th day ತಗೊಂತೀನಿ. List the matter on 19th at the request of the learned additional SP.
Respondent.
You are not present that day. He is not present today. Interim order ನಿಲ್ವಲ್ಲ. What is happening before the court?
But it is, since the matter is pending here, the court is not taking.
There is no interim order granted in the case at hand. The pendency of this petition will not come in the way of the further proceedings before the concerned court. List after 4 weeks. No representation on behalf of the petitioner. Next. What are these matters? For 35, where case and counter case.
Yes.
Mohan Kumar. Yes, sir. Ready na?
Yes.
Headi. Oh, one the investigating officer.
Yes.
The government has to.
Yes.
Here, there are 2 different investigating officers.
No.
Then,
There are 2 different.
ಅದನ್ನೇ ಕೇಳಿದ್ದು.
Yes.
Yes. Why do you do this still in the state? Case and counter case ಅಲ್ಲಿ you deploy 2 different,
Normally same investigation officer.
ಇಲ್ಲಿ different ಇದಾರ same?
Different there is.
Then it goes.
And my lord, there is no reference of each other cases, my lord, while submitting the charge sheet.
ಏನ್ sir?
That's here the investigation is conducted by a subordinate of the.
Whoever it is different investigating officer
No, this
or the
honorable-
same?
If I may rely upon my lords kindly.
Judgment ಬಿಡಿ sir. First same different ಹೇಳಿ.
Page 35.
Different.
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 What judgment come? ಕೊಡಿ.
Circuit bench of this court, my lords, while dealing with.
ಈ ಕೋರ್ಟ್ ಅಂತ ಹೇಳಿ ಸರ್ಕ್ಯೂಟ್ ಬೆಂಚ್ ಏನ್ ಬೇಡ ಕೊಡಿ.
They have produced, my lord, judgment copies.
Page.
Page, my lords.
ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದೀರಾ?
Earlier, sir,
Judgments
earlier,
and-
Lord.
Huh?
I was not there, my lord, earlier.
ಹಾಕಿದ್ದಾರೆ ಇದನ್ನು ಸ್ವಲ್ಪ.
ಇಲ್ಲಿದೆ ಬಿಡಿ.
Kindly see, my lords, page number 83, my lords.
No, this 668 of 2004 ಅದ. Justice Sridhar Rao.
350. Waskeri Ningappa, my lords.
ಒಂದ್ ನಿಮಿಷ. ಹೊಸ್ಕೇರಿ ಮಲ್ಲ.
Waskeri.
Yes, sir.
In that, my lords, page number 84, my lords.
ಹಾ.
Kindly see, my lords, second para, my lords.
ಹಾ.
May I read, my lords?
ಹ್ಮ್.
Reverse of finding or sentence by reason of error, omission or irregularity. Objection of the section L for section 465 of the code is intended to cure any error, omission, irregularity or infraction of procedural law committed by the court of competent jurisdiction unless such irregularity of illegality as in fact occasioned a failure of justice. The object of the section is to secure justice by preventing the invalidation of a trial. held on-
ವಾಪಸ್ ಮತ್ತೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಕಳಿಸ್ಬೇಕು ಅಂತ ನೀವು ಹೇಳ್ತಿರೋದು.
No, that's here. The reason is the counter case where I am the accused, my lords. The
ಅದ್ರಲ್ಲಿ
trial is going on.
ಟ್ರಯಲ್ ಇಸ್ ಗೋಯಿಂಗ್.
And moreover, my lords, the petitioner, my allegation is against the petitioner, my lords. He is the one who was assaulted with the sickle and caused grievous hurt.
ಹ್ಮ್.
Old woman, my lord, 65 years.
ಓಲ್ಡ್ ಮ್ಯಾನ್.
Old woman.
ಓಲ್ಡ್ ವುಮನ್.
65 years. ಅವ್ರಿಗೆ ಮಚ್ಚಲ್ಲಿ ಹೊಡೆದು grievous hurt ಮಾಡಿ, which caused my privation of her ear permanently, my lords. Counter case, my lord, trial is going on where I am the accused.
ಇಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆಯಾ ಇದು?
ಇದು ಒಬ್ಬರದು ಇವ್ರ petitioner ಮೇಲೆ ಸ್ಟೇ ಆಗಿದೆ. Solo petitioner, my lords, accused number 4.
Only one petitioner.
Yes, my lords.
What happened to the others?
Trial is going on, my lord.
1, 2, 3 ಎಲ್ಲ.
ಎಲ್ಲ ಮತ್ತೆ ಕೌಂಟರ್ ಕೇಸಲ್ಲೂ ಟ್ರಯಲ್ is going on.
It is no, my lord, not even charge framed as per my instructions.
Evidence is going on, my lords. I will produce
That
it.
is, my lord,
Hmm.
it is my instructions, my lord, it is at the stage of framing.
What is the allegation against him in the charge?
It is, my lord, he only assaulted me with a.
Your
sickle. That is-
A4.
Yes,
ಕೈಗಳಿಂದ ಆರೋಪಿ.
kindly, my lord, page 34.
ಹೋದಾಗ ಆರೋಪಿ 4 ಮಚ್ಚಿನಿಂದ.
ಅದು ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಬೇರೆ ಇದೆ,
ಪರವಾಗಿಲ್ಲ.
ಇಲ್ಲಿ ಬೇರೆ ಆಗುತ್ತೆ.
Page number 35, my
ಅದೇನ್
lords.
ತೊಂದರೆ?
Page 34, my lord, starts with.
See, by your act, state, by doing these things, these people will get away with this. Why do you do this?
Here, my lord, this issue.
Anyway,
is
it's not incurable illegality. We will cure it.
Like here,
And a person who has done this act cannot escape scot-free.
here in this.
Yes,
case-
sir.
Here in this case, admittedly from the complaint of both sides, there is a civil dispute.
Maybe.
But
That is not a license to
no, my lord, kindly, I'll just, my lord, I'll place. I'll
take a
place the
sickle and
points.
cut.
No, my lord, nobody is cut. It is, my lord, it is.
Charge sheet.
It is stated, my lord, much. in
Where is the
the-
wound certificate?
Wound certificate they have not produced, my lords. As it is against to them, they have not produced.
ಆಯ್ತು, ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ?
ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ಇಲ್ಲ, but they have stated it, page number 34, my lords. Kindly see. Page number 34 in the petition copy, my lords.
I am at 34. That is summary of the charge sheet.
11, my lords, 5th row. ಇವರು ಸಾಕ್ಷಿ 1, 3, 4 ಮತ್ತು 5ರವರೆಗೆ ಚಿಕಿತ್ಸೆ ನೀಡಿ ಗಾಯದ ಪ್ರಮಾಣ ಪತ್ರ ನೀಡಿರುವ ಬಗ್ಗೆ ಮತ್ತು ಸಾಕ್ಷಿ 3 ಮತ್ತು 4ರವರುಗಳ ಗಾಯದ ಬಗ್ಗೆ ಸ್ಪಷ್ಟೀಕರಣ ನೀಡಿರುವ ಬಗ್ಗೆ ನುಡಿಯುತ್ತಾರೆ. They have given, my lords, but they have not produced it.
Kindly, my lord, how this against 4 is concerned, my lord. He only assaulted, that is not directly. Along with others, he was indulged in.
Others are undergoing
is-
trial. Why
my-
should you
my
be
actual
shown
submission
this?
is-
There is special.
Okay, charge is not
Right.
framed. Charge is not at frame. in any
Parvai,
of the
will
cases.
direct charge to be framed immediately against you as well.
Kindly, my lord, my actual submission is only in this. This, my lord, the pick and choose.
We'll
approach,
answer
my lord, they are not. That is my actual submission. Only on this, my lord. I am not.
And
saying-
state, you better issue a circular or something.
Circular. is
Circular
there,
issue ಮಾಡಿ ಅದನ್ನ ಯಾಕೆ different investigating officers ಕೊಡ್ತೀರಾ?
We'll bring it.
That gives scope to all kinds of allegations.
We'll see. Not saying, my lord, the
And this
person-
man who is in 307 ಇಲ್ಲ ಇವ್ರ ಮೇಲೆ
326, my lord.
324 ಮಾತ್ರನಾ?
326.
326.
326
are not
idea.
there,
Yes,
my
my
lord.
lord.
ಎಲ್ಲಿದೆ 326?
326 ಇದೆ.
326 is there, but there is no
326.
ingredients at all.
There is much ingredients.
We'll see.
326 to code.
326 ಇದೆ. I thought 307 ಇರುತ್ತೆ and 326 ಇದೆ.
Cannot. But 326 ingredients are not forthcoming from even the summary. It is, my actual submission is, while submitting the charge, the approach of the investigating officer, two different investigating officer, though he is, my lord, the charge sheet is filed on the same day. But my lord,
ಎರಡರಲ್ಲೂ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
ಎರಡರಲ್ಲೂ charge sheet, but deliberately, my lord.
ಒಂದ್ರಲ್ಲಿ ಬಿ ರಿಪೋರ್ಟ್ ಒಂದ್ರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಆದ್ರೆ it
I am
causes
not, it is not my
prejudice.
case. It is not my case.
Yes, we'll dictate at 2:30.
Yes.
ನೀವು ಸರ್ಕ್ಯುಲರ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದು ವೇಸ್ಟ್, ಏನಕ್ಕೆ ಮಾಡ್ತೀರಾ?
Circular is there probably what they, then they are, there's the two prosecutors, probably the local police probably thought that they should.
And you are enjoying this interim order for the last 2 years.
No, my lord.
Yes, yes.
Not 2 years, not make
I
submission.
can-
my lord.
at least,
No, my lord.
all right.
Not 2 years, my lord. In the
Don't
last
get
week,
agitated.
He, my lord,
From the day of
He-
filing.
ಏನ್ ಎರಡು ತಿಂಗಳು ಕಮ್ಮಿನಾ?
no, my lord. When I have moved, when matter is listed, he only took time, my lord, on several occasions.
ನಾನು ಕೇಳಿದ್ದು ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಯಾವಾಗಿಂದಿದೆ ಅಂತ.
2023, my lord.
23?
Yes,
2 years ತಾನೆ?
not 2 years.
ಅಯ್ಯೋ 23/5/22.
Yes,
We have
1
crossed
year.
May.
1 year.
25 months ಆಯ್ತು. 23 22 ನಾ? 23 ನಾ?
22, my lords.
22.
Yes, sir. We will close it today.
Not in the initial stage, but it's granted.
We'll close it.
after years.
Yes. 2:30.
Appear in 36.1 and 2.
All right, what are these batch of matters? There are 16 cases, 17.
Concerning BDA site allotments.
First of the.
What is
three-
this, Murugesh?
Crux
First
of
of the
allegation.
three petitions is by employee of a PDA. Lord, the allegation is that, Lord, without there being proper verification of the documents, the sites which were allotted and deeds were executed in favor of other third parties.
Are officers in these cases or?
Yes, Lord. First three is an
First three
officer.
matters,
And,
he is an official of the BDA, Lord. He is a case worker and FDA.
All other, Lord, are other is by, they found out that their role in the investigation, and my lord, they are the people of this illegal.
Yes, you're ready in everything?
Please,
No,
in
madam,
1, 2 and 3, my lord,
He
yes.
is ready, madam, with respect to 4 to
Lord, I
Where is,
stand on
where
a
is
com-
Nitin?
He's not well, my lord.
Not well. We'll fix a date. 22nd.
Lord,
please.
List
please
the ma-
plead for delinking of the first three matters,
Please,
Lord,
madam.
because I stand on completely different
Different
footing.
footing, madam.
No, are they not arising out of the same transaction?
Same, all same transactions.
No
all-
dealing, we'll see.
Please,
You file your short synopsis by then.
certainly.
The counsel for the petitioners are directed to file a short synopsis and synopsis of listed dates and events and the authorities that they are seeking to place reliance upon. So will the respondent also do.
Please.
Next,
Interim order.
list on 22nd, interim order, if any subsisting in these cases, shall continue to the next date of hearing.
Great.
Yes, next.
For the petitioner in this case, my lordship.
One and number 2, my lord.
Offenses of 504, 506 IPC, my lordship. Purely civil transactions as given the garb of a criminal case, my lordship.
ಏನ್ ಪರ್ಮಿಷನ್ ಇಲ್ಲ ಅಂತ ಸ್ಟೇ ಕೊಟ್ಟಿರೋದು?
That is the ground on which the stay was
Yes.
granted, my lordship.
Government,
Yes, my lord.
no permission.
No permission.
Permission was granted, it just says permitted, my lordship.
ಅಷ್ಟೇನಾ?
That's a
Seal
point,
has
my
been
lordship.
put,
No
my
speaking
lord.
order.
Permitted other seal.
That is not my primary ground, my lordship.
ಈಗ that's become,
After Vijesh Pillai.
yes.
My lordship may peruse the complaint, my lordship.
Someday the Rejesh Pillai versus state. Our judgment, my lordship, has passed.
Go to
in
Vijesh Pillai, that's what he's saying. We'll have to send it back if that is the ground. If he's saying that it is submitting on merits also, we'll continue at 2:30. Yes.
Oblige, my lordship.
Will ಮಾಡಿ.
Basically, with humility, my lord. My lord, second list, my lord. Serial number 3 and 26, my lord. It's fully compliant, my lord. This urgency, at least tomorrow.
Monday,
Tomorrow, my lord.
Monday, Tuesday, yes.
Cause list 1, my lord,
Yes, what serial number?
serial number 52.
52.
Yeah,
ಏನಾಗ್ಬೇಕು?
52, 2 to
Respondent
3 weeks time maybe.
ರಾಜು ಅವ್ರಿಗೆ ಹೇಳಿದ್ದೀರಾ? No problem? Yes. At the request of the learned counsel R. Nagendra Naik, list this matter. Just 1 week, 2 weeks?
2 weeks.
List after 2 weeks. Interim order subsisting shall continue till the next date of hearing.
My lord, serial number 47, my lord.
VC, please wait. Yes.
Sir, 498A and 304 DPI.
ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಈಗ?
I am for petition in this case, Your Honor.
ಟೈಮ್
The
ಬೇಕಾ?
inlass has been filed, the inlass has filed this petition in this case.
ಟೈಮ್ ಬೇಕಾ?
ಹೌದು, ಟೈಮ್ ಇದು ಡೈವರ್ಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಫಸ್ಟ್ ಅಕ್ಯೂಸ್ಡ್ ಗೆ ಮತ್ತೆ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ. Kindly on 10 days time may be granted in this case. Your negotiation is taking.
38, list after 2 weeks. Interim order granted earlier, stands extended to the next date of hearing.
Serial number 43, my lord.
Madam, page wise ಕರೆದ್ಬಿಡಿ.
My lord, for petitioner, my lord. Each time is it.
22, list on 26th.
Interim order.
Interim order, list on 26th at the request of the petitioner as a last chance. Interim order subsisting shall continue till the next date of hearing.
Number 45, my lord. I
Hmm.
applied for second respondent.
Hmm.
Yeah, for a week's time, my lord. Getting instructions. from him.
At the request of the counsel for the complainant, list the matter on 26th. Interim order subsisting shall continue till the next date of hearing. Yes. Sir. Yes, you're telling me
Ma'am.
again.
Serial number 47, my lord.
47, yes, madam, ಏನದು?
Some personal inconvenience, my lord. Kindly grant 2 weeks.
Respondent, who are you?
Petitioner, my lord.
At same 26th, there's a last chance.
Interim
Interim
order.
shall continue. Yes.
I had filed a memo on Thursday, my lord. The date was given on 10th actually. And the file has been moved to the board branch. It was not listed. Kindly have it tomorrow, my lord. Kindly have the file.
Tomorrow urgency ಏನು?
Petitioner is suffering from cancer. He's been living in New Zealand. A series of matters, 26 cases are there pending.
26 cases.
Please,
ಹೌದು
please.
madam. Number is good.
Please.
Friday ಹಾಕಿ.
Tomorrow. Kind.
No, no.
At least day after tomorrow. Kind.
Friday.
My sincere apology, Lordship. Moving a memo for end of the list, Lordship.
Yeah, then urgency.
SCST atrocity case has been lodged. There is.
Yes. Take it.
Number 2, fully complied.
Comply ಆಗಿದ್ರೆ ಬರುತ್ತೆ ಬಿಡಿ.
ಪೂರ್ತಿ ಆಗಿದೆ.
What is that?
6 and 23.
6 and
23. ನಾಳೆ
what is the urgency?
ನಾಳೆ ಎರಡರಲ್ಲೂ ಪೊಲೀಸ್ ಬರ್ತಾರೆ, ಡೈಲಿ ಬರ್ತಾರೆ.
ಡೈಲಿ ಬರ್ತಾ ಇದೆ.
ಎವ್ರಿ ಡೇ.
ಪ್ಲೀಸ್. ಎಸ್. ಅದನ್ನು ಫ್ರೈಡೆ ಹಾಕಿ.
Madam. 6 and 23. Second list, 6 and 20.
Court officer? Sir.
depositions, my lord, in along with a memo, in which, my lord, the 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 course of examination, my lord,
Yes,
the
sir.
accused himself.
And then signature is admitted
as
per their cross judgment ಪ್ರಕಾರ ಬೇಕಾಗಿಲ್ಲ ಬೇ.
Also, Beatsing judgment matter
Yeah, it-
clearly stated, if the signature is admitted, contents may be filled by the payee or a drawer. On that point. It
Signature is not
Will
admitted.
answer it. 20
Sir, signature
20
is not
seconds for
admitted.
dictating. Next,
My lord,
20 seconds, sir.
interim order may kindly be extended.
ಇದೆಯಾ?
ಇದೆ.
ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. Yes.
ಇಲ್ಲ ಅವರೇನು forensic
Interim order
expertಗೆ
subsisting shall
ಹೋಗೋದಕ್ಕೆ ನಮ್ದೇನು
continue till the
objections
next
ಇಲ್ಲ
date of
ಅಂತ.
hearing. Yes, next.
In the
This is the matter where completely, I mean, criminal was initiated by the second respondent on the ground that his commission was not paid for petitioner having sold his property.
Interim order ಯಾಕೆ ಕೊಟ್ಟಿರೋದು?
Yeah, earlier, Lordship, this is him.
Interim order
Interim order ಇದೆ.
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 ಪ್ರಿಯಾಂಕಾ ಫಾಲೋ ಮಾಡಿಲ್ಲ ಅಂತ ಕೊಟ್ಟಿರೋದು.
Priyanka, the ground I took, my lord, because the affidavit is only one liner.
ಏನ್?
That is the ground I took, my lord. Illi.
So that
based
ground
upon-
goes.
Last time I submitted on.
ಇಲ್ಲ,
this.
that ground goes, so
Very well.
you will face trial.
ಇಲ್ಲ, ಆದ್ರೆ 202 ಇದೆ, otherwise merits ಮೇಲೆ ಇದೆ. Commission ಕೊಟ್ಟಿಲ್ಲ ಅಂತ, and he has filed a civil suit. Your lordships, on the last time accepted.
Where is that civil suit?
I have not produced until after this suit was filed. 2% commission ಬೇಕು ಅಂತ.
2% ಕೇಸ್ ಇದು.
ಬಾಕಿ ಅಲ್ಲ.
Civil suit, ah?
Other side, last time was.
Respondent was here?
No, he had not appeared on the last occasion. Allegation is the petitioner entered an agreement with the second respondent.
ಏನು offense?
417, 418, 420. Primary reference. Four 426, 427.
Heard the learned counsel appearing for the petitioner. There was no representation on behalf of the second respondent complainant on 4/6/2024. Therefore, awaiting his appearance, the matter was directed to be listed today. Even today, there is no representation on behalf of the complainant. List this matter on Friday.
14. 14.
ಪರವಾಗಿಲ್ಲ, ನೀವೇನ್ ಇರೋದ್ ಬೇಕಾಗಿತ್ತು. ನಿಮ್ ಕೊಲೀಗ್ ಇಲ್ವಾ ಯಾರು?
Either colleague.
Yes. No arguments.
Very well.
For dictation ಅಷ್ಟೇ.
Very well.
Admission ಅಂತ ಹಾಕಿ dictation ಅಂತ ತೋರಿಸ್ಬೇಡಿ. ಇದು ಇಟ್ಟಿರಿ ಮೇಡಮ್. ಅದ್ರೊಳಗೆ.
For the petitioner.
Second respondent.
For the petitioner.
Hmm.
498A, 504, 506, 34.
Who are you?
I'm for the father-in-law and mother-in-law.
So Lordship, there is very serious allegation in the entire complaint and as well as
Bani,
charge sheet.
take me to the complaints.
Head number 15.
Interim order ಇದೆಯಾ?
No, my lords.
No interim.
No interim.
Then you tell me. Yes.
My lords, so what has transpired is on 12/3/2020, I filed for a restitution of conjugal rights, my lords. The marriage happened.
I andre?
My son had filed for
son, yes.
restitution of conjugal rights. And without the son's knowledge on 19/8/2020, the respondent number 2 files a restitution of conjugal rights in Bangalore. So my son had filed it in Hosur, my lords. So even if I may take your lordships to their restitution petition, which is now dismissed for non-prosecution, at page 39, if I may just read.
All right, leave
few
that.
lines.
Come to the facts of this.
Filing the divorce petition,
Wait.
that was dismissed.
My lord, so what
Divorce
has
ಆಗಿದೆಯಾ ಏನಿಗೆ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಏನಾಗಿದೆ, they filed a joint memo. The respondent number 2 comes to Hosur, where I have instituted the restitution, files a joint memo on 9/9/2021, stating that she will come and live with the accused number 1. After that, after a period of 3 months, she comes and files this FIR, my lords. Before that, on 14/11/2021, she approaches the police station and NCR is registered. After a month, the FIR is filed on 14/12/2021, my lords.
Complaint.
Page 15.
Against the father-in-law and mother-in-law.
My lords, they are bald allegations, my lords. It's it's just a matter of husband and wife issue, my lords. After the husband's name, the atte mava ibru demand ಮಾಡಿದಾರಂತ. It's
ಅಷ್ಟೇನಾ?
called baseless allegations, my lords.
So Lordship, the accused number one filed the restitution of tangible rights only with an intention to create the ground for divorce. For that reason, he filed the.
That is between husband and the wife. ಇಲ್ಲೇನಿದೆ ಹೇಳಿ
Please,
sir.
my lord. After that, when I received, the respondent number two received the notice from the trial court, she straight away went to the trial court and fairly submitted that I am ready to go with the immediately.
Right.
Hence, the court suggested to file the joint memo. For that reason, she filed the joint memo and went to the immediately to the in the house of the matrimonial. After going to that place, they started harass once again to her. And he returned back, ಅವ್ರನ್ನ ಕರ್ಕೊಂಡ್ಬಂದು again ತಾಯಿಗೆ ಮನೆಗೆ ಬಿಟ್ಟು they demanded dowry harassment. For that reason, she lodged the complaint. Your Lordship kindly, there is the page number 15, last paragraph.
15 last paragraph.
Page 15. ದಿನಾಂಕ 4/7/2021 ನಮ್ಮ ಮಾವಂದಿರಾದ ಯಶವಂತ್ ರಾವ್, ಸುರೇಶ್ ರಾವ್, ನಮ್ಮ ಕುಟುಂಬದ
ಆಯ್ತು, ಅದು ಅಲ್ಲಿಂದ ಅಪಾರ ಎಂಡ್ ಆಗೋವರೆಗೂ ಇದೆ ಎಲ್ಲ.
complete allegation is there against the petitioners only. They have harassed her. ಲಾಸ್ಟ್ ಹೇಳೋದಷ್ಟೇ ಅವ್ರ ಗಂಡ ಮನೆಗೆ ಬಿಟ್ಬಿಟ್ಟು ನಮ್ಮ ತಂದೆ ತಾಯಿ ಹೇಳಿರೋ ಹಾಗೆ ಅರ್ಧ ಆಸ್ತಿ ಮತ್ತೆ
ಆಯ್ತು, where is the summary?
ಚಾರ್ಜ್ ಶೀಟ್ in page number 20, column number 70. Last paragraph, two paragraph. From 10 to ದಿನಾಂಕ 10/12/2021 and from 6th lines on ಸಾಕ್ಷಿ ಒಂದೂರವರು ನಮ್ಮ ಸಂಬಂಧಿಕರು ಮತ್ತು ಹಿತೈಷಿಗಳು ಸೇರಿ ಆರೋಪಿಗಳೊಂದಿಗೆ ರಾಜ್ಯ ಪಂಚಾಯತಿ ಮಾಡಿಸಿ ಒಂದು ಆರೋಪಿ.
ಆಯ್ತು ನೋಡಿದೆ. Who is CW9?
CW9. CW9 is the
9 and 13 ಯಾರು?
9 and 13 are the relatives and neighbors of the petitioners. They are also stated against statement. They are harassing her because they are staying in Hosuru. The matrimonial house is in the Hosuru. But the respondent has, the petitioner has not produced that statement also.
Yes, comment.
My lord, there are various allegations, my lord, as stated by the respondent number 2, my lord. Considering all the material facts, my lord, I pray this honorable court to dismiss, my lord.
What is the age? 6651. Yes, sir.
My lords, it's a simple dispute between husband and wife, my lord. So what has happened is, if I may just take your lordship to page number 39, their restitution, my lords. In that, this is actually what has transpired, my lords. If your lordships may just read 4 lines on page 39.5, it's their restitution of conjugal rights filed in Bangalore by the respondent number 2. Para 5, from the 4th line, if your lordships may read, during this period, the respondent has resigned his job in LM Windpower Technologies Company without informing the petitioner. And on 16 January 2017 evening, respondent has informed the petitioner about rejoining his previous company. On January 19, he rejoined the previous company at Hosur. The respondent assured the petitioner and her parents that he will come back to Bangalore after finding a new job. My lords, they want him to come and settle in Bangalore, and she does not want to come to Hosur to take care of the parents. My lords, they are age-old parents. This is the actual dispute.
Where did the in-laws stay?
Hosur. The in-laws are in Hosur.
Along with the wife.
Please.
Yes.
And even in the FIR at the last paragraph, I mean, even in the complaint in the last paragraph, she says that nan ganda nan vapas tagonta illa anta complaint kodta idini anta. That is also.
That's an independent thing between husband and the wife.
The petitioners are nowhere more baseless allegations, my lord.
Yes.
Along with the charge sheet, the investigation officer produced so many documents, almost 35 documents regarding the dowry. But she has not, the petitioners have not produced entire charge sheet.
Right, yes.
Honorable court.
The petitioner's father-in-law and mother-in-law of the second respondent complainant are before this court, calling in question proceedings in CC 8406 of 2022, pending before so-and-so, registered for offences punishable under Section 498A, 504, 506, 34 of the IPC and 3, 4 and 6 of the Dowry Prohibition Act 1961. Heard so-and-so. Facts in brief, Germain, are as follows. Marriage between the complainant and the accused number 1 happens on 11/2/2015. It transpires that the relationship between the husband and the complainant flounders On floundering of the relationship, there appears to be certain proceedings instituted between the two, i.e. the husband and the wife. The petitioner, the accused number 1 husband, institutes proceedings invoking section 9 of the Hindu Marriage Act, seeking restitution of conjugal rights on the score that the wife had left the matrimonial house and he was wanting her back into the house. Later, the complainant also institutes a petition for restitution of conjugal rights in Bangalore, Bangalore in MC 2526 of 2020. Therefore, there were 2 proceedings instituted, one by the husband before the court at Hosur and by the wife at Bangalore, both for restitution of conjugal rights. It transpires that a joint memo was filed by the complainant and the husband on 9/9/2020, and the petitioner and the complainant returns back to the matrimonial house. After having returned, comes the impugned complaint on 14/12/2021, alleging torture or other harassment by the husband and the in-laws. The husband is not in-laws. The police conduct investigation and file a charge sheet against all the accused in CC 8406 of 2022. Filing of the charge sheet has driven these petitioners to this court in the subject petition. The husband, accused number 1, is not before the court. The learned counsel appearing for the petitioner would submit that there are no allegations of any overt act performed by the father-in-law or the mother-in-law on the ground of demand of dowry, and therefore he would seek quashment of the proceedings against them on the ground that they are omnibus statements which would not touch upon the ingredients of section 498A or 504 or 506 as the case would be. Per contra, the learned counsel for the complainant takes this court through the summary of the charge sheet and the statements so rendered by the witnesses, seeking to demonstrate that the torture was not only known to the members of the family, but even to the outsiders, i.e. the neighbors of the family, neighbors of the petitioner. He would submit that it's a matter of trial for the petitioners to come out clean. The learned HCGP would also toe the lines of the counsel for the complainant in contending that the police have filed the charge sheet and the offences are made out. Therefore, it is a matter of trial for them to come out clean. I have given my swords. The relationship between the husband and the wife getting married is a matter of record. A child born from the wedlock on 10/12/2018 is also a matter of record. The relationship turning sour, resulting in 2 proceedings, are again a matter of record. The proceedings getting closed is on 9/9/2020 on account of filing of a joint memo is a fact that is appended to the petition. It is between 9/9/2020 and 14/12/2021 is what forms the fulcrum of the complaint, though the narration in the complaint is all about that has happened right from 2017 to 2021. Since the happenings are projected in the complaint and the complaint has led to these proceedings, I deem it appropriate to notice the complaint filed by the second respondent wife only insofar as it is germane to the petitioner's hearing. The relevant portion of the complaint reads as follows, Madam, page 15. 15 to marked portion 16 ಅಲ್ಲಿ. The allegations against these petitioners in the complaint are quite vivid, and they are in minute detail, even indicating the dates on which such demand is made, and on such demand some harassment is meted out by the father-in-law and mother-in-law. The police conduct investigation, and during the investigation, the neighbors of the petitioner are also examined as CW9 and CW13. Those statements are also CW13, along with the statements of all others recorded. The recording of the statements results in drawing up of a final report by the investigating officer in the form of a charge sheet. The summary of the charge sheet, again, insofar as it pins down the petitioners, reads as follows. Page 20, mark portion. If the complaint and the summary of the charge sheet are read in tandem, what would unmistakably emerge is the finding of ingredients that are necessary for continuance of the proceedings against these petitioners, as they would, in the considered view of the court, become those ingredients under section 498A of the IPC, as the minute details of what has happened is recorded in the complaint, and the details that of the statement of witnesses form the part of the charge sheet. It is not vague statements, bald statements, or omnibus statements as is contended by the learned counsel for the petitioner. They are detailed statements of harassment on account of demand of dowry. What is before the court is the complaint and the charge sheet. What has happened behind the smoke screen would not be known to this court in exercise of jurisdiction under section 482 of the CRPC. Therefore, finding prima facie material of meeting of the ingredients of section 498A, I deem it appropriate to direct the petitioners to undergo trial. The finding no merit in these petitions, the petition stands rejected.
My lords, it was 9/9/2021, my lords, in the dictation. The joint memo was 9/9/2021.
9/9/21, yes.
20 was told, that's why I just
20
didn't
and
want to interfere. 9/9/2021.
3 months problem aita matte.
3 days.
She did not stay, my lord. She returned.
Come to your synopsis.
Mistake, my lord. 9/9/2021 was.
So it's not my mistake.
My apologies.
Yes. Sorry. No representation on behalf of the petitioner. Idu 498A.
Please, ma'am.
As a last chance awaiting his appearance, list the matter on 19th. In the event he would not appear, the matter would be dismissed for its non-prosecution. Next. Yes, Naveen.
For the petitioners. Complaint is against the unknown persons, your lordship. For FIR registered for 379.
No corroborative material.
Last time note ಹೇಳ್ತೀನಿ.
ಯಾರು? Yes, comment. ನೀವು ಅವರ?
House.
Please, ma'am. My lord, madam, serial number 46. My lord, in this matter, there is a recovery of mobile, my lord, from the petition.
Mobile?
Mobile.
ಏನ್ ನೋಡಿದ್ರಿ ಮೊಬೈಲ್ ಅಲ್ಲಿ?
The mobile which belongs to the complainant, my lord, that
All
is the
right.
second respondent, that was recovered at the instance, my lord, based on his voluntary.
Mere recovery will not, sir. ಅದ್ರಲ್ಲಿ ಏನಿತ್ತು? Corroborative material against the petitioner, quay the offenses.
No, my lord, this is for the offense punishable under 379, my lord.
Theft.
And that the vehicle, my lord, which was also involved, my lord, based on their voluntary statement, my lord, that vehicle is also recovered. This is the.
Recovered from A1 unit.
From all the.
No, A1's voluntary statement has led to you.
Vehicle also recovered from A1.
Vehicle also A1 then. A1 vehicle our statement ಅಲ್ಲಿ recovery ಮಾಡ್ಲೇಬೇಕು ಆಮೇಲೆ.
It was jointly recovered, my lord, at the instance of all the accused. A1 to A4 jointly, that vehicle, the car which was involved in this.
You are A5,
A3.
A3. How does it pin him?
My lord, there is a common allegation against all the accused, my lord.
Where trial ಆಗ್ತಾ ಇದೆಯಾ?
Illa, there is a stay granted by this honorable court with respect to the.
All the
present
accused are
petition.
here?
No, no. Only one A3 is stay kotirodrinda, the trial court is not proceeding with the matter, madam.
Let it
Because
proceed
there is a
against
common
others.
allegation against all the accused.
ಅಲ್ಲಿ ಅಕ್ವಿಟ್ ಆದ್ರೆ ಇವ್ರಿಗೆ ಹೆಲ್ಪ್ ಆಗುತ್ತೆ ಬಿಡಿ. ಸ್ಪ್ಲಿಟ್ ಚಾರ್ಜ್ ಶೀಟ್ ಬೇಕಾಗಲ್ಲ. List after 4 weeks on date ಕೊಡಿ. Interim order subsisting shall continue till the next date of hearing. It is made clear pendency of the subject petition will not come in the way of further proceedings before the concerned court against any other accused.
Please, ma'am.
Yes. 18-7, okay.
Interim order.
Continue.
Five years living relationship.
Respond ಇಲ್ವಾ?
ಇಲ್ಲ ಬರ್ಲಿಲ್ಲ.
ಸರ್ವ್ಡ?
Yes, my lord, it is served.
ವಿ ಮಂಜುನಾಥ ಗೌಡ. ಅಲ್ಲಲ್ಲ, ಯಾವ್ದು ಬಾಲು. ಹೇಳಿ.
Not on 11/7/22 in page 13. The respond number 2.
11/7/22.
The respond number 2 files a complaint against a petitioner, alleging that my lord, she was in a live-in relationship from 2015 as they were colleagues in the company. My lord, according to the complaint, there was physical intimacy, and my lord, she insisted for marriage after that, and he refused to marry. My lord, for the very same period, my lord, she files a complaint at in page 9.
Two boats.
And 2019, my lords, she files a complaint against one Kamlesh Chowdhury, making similar allegation that from 2015 they were colleagues in the office.
You produced that, Allah?
Yes, ma'am. It ended in a charge sheet. Now he is
That is
facing.
annexure C, page 14.
Yes.
ನಿಮ್ದು ಯಾವುದು?
Not mine is in page 13 is a complaint. FIR is at in page 9. It's crime 183 of 2022.
13.
13 is a complaint against me.
You are Sunil Patil.
Yes.
Which company?
One of the ITPL ನಿರುವ ಏಜಿಸ್ ಕಂಪನಿಯಲ್ಲಿ ಮಾಡುವ ಕೆಲಸ. ಏಜಿಸ್ ಕಂಪನಿಯಲ್ಲಿ ಕೆಲಸ ಮಾಡುವಾಗ.
Come to the other complaint.
But
ಅದು ಚಾರ್ಜ್ ಶೀಟ್ ಮಾತ್ರ ಇದೆಯಾ?
ಚಾರ್ಜ್ ಶೀಟ್ ಇದೆ. ಕಂಪ್ಲೇಂಟ್ in page 19, the second complaint, the first complaint in page 19.
No, ಅವ್ರ ಮೇಲೆ.
ಅವ್ರ ಮೇಲೆ ಇದೆ. In page 19 ಅಲ್ಲಿ
ಕಮಲೇಶ್
ಅನ್ನು 5 ವರ್ಷಗಳ ಹಿಂದೆ
5 ವರ್ಷಗಳ ಹಿಂದೆ
ಪರಿಚಯ ಆಯ್ತು. ನಂತರ ಫೇಸ್ಬುಕ್ ನಂತರ ಕೆಫೆ ಅಲ್ಲಿ ಆಗಾಗ ಮೀಟ್ ಮಾಡುತ್ತಿದ್ದೆ.
ನಿಮ್ದು 4 ತಿಂಗಳ ಹಿಂದೆ. ಬರೀ 4 ತಿಂಗಳ?
ಇಲ್ಲ, 5 ವರ್ಷ.
ನಿಮ್ದು 5 ವರ್ಷ ಅಂತ ಎಲ್ಲಿದೆ?
ಇಲ್ಲ, ಅವ್ರದ್ದು 5 ವರ್ಷ ಇದೆ.
ನಿಮ್ದು?
ನಮ್ದು 5 ವರ್ಷ.
ಎಲ್ಲಿದೆ 5 years?
Lordship kindly come to page 13.
I am at 13, sir.
Yes. ಈ 4 ವಿಳಾಸಗಳ ಸ್ವಂತ 4 ತಿಂಗಳ ಜೊತೆಯಲ್ಲಿ ವಾದವಾಗಿರುತ್ತಾನೆ.
2015 ಇಂದ ಪರಿಚಯ.
ನಾನು 2015ರಲ್ಲಿ ITPL ಕಂಪನಿಯಲ್ಲಿ ಏಜಸ್ ಕಂಪನಿ ಮಾಡುವಾಗ ಸ್ವಂತ ಪರಿಚಯವಾಗಿ ನಂತರದ ಸ್ಟಾರ್ಟೆಡ್
ಕೆಫೆಗಳಲ್ಲಿ ಆಗಾಗ ಮೀಟ್ ಮಾಡಿ. ಎಸ್ ಸರ್. Yes, government.
My lord, for the offense 417-376, there are no material, my lord, but with respect to the offense 326, there is a wound certificate, my lord, the grievous in nature ಅಂತ.
ಯಾರು ನೀವು ಹೊಡೆದಿದ್ದೀರಾ?
ಇವರೇ ಹೊಡೆದಿರೋದು.
Multiple bruises of varying sizes. Leg, upper back and the abdomen. ಯಾವತ್ತಿದು? 15/7. What is the date of the complaint?
11/7.
11/7.
Complaint ಅಲ್ಲಿ
She was
ಹೇಳ್ತಾರ?
examined also on 11/7.
No, complaint ಅಲ್ಲಿ ಹೇಳ್ತಾರ ಅದನ್ನ?
ಇಲ್ಲ, ಕಳ್ಳಾಡಿ
ತಿರುಚಿ ಕುತ್ತಿಗೆಗೆ ತಲೆ ಮೇಲೆ ಚಿನ್ನನಿನ ಮೇಲೆ ಹೊಡೆದನು.
ಹೊಡೆದರು. ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಇದೆ ಅಲಿಗೇಷನ್.
ನಾನು ತಡೆದಿರುತ್ತೇನೆ. ನಂತರ ನಾನು ಮನೆಯಿಂದ ಆಚೆಗೆ ಬಂದು ರೋಡ್ ನಲ್ಲೂ But at the most 323, my lord, definitely not the offenses. My lord, she has been there for 5 years with me.
No, no, 376, I am not. So I am with you with that.
My lord, even 326, my lord, it's a grievous injury. Nothing that show that there is 326 attracts, even accepting the medical certificate as it is. There is no grievous injuries.
No, consensual acts is not a license for all this.
No, no, I never said that. My lord's, my humble submission is this. But 326 will not come.
323 ಅಷ್ಟು ಚಿಕ್ಕದಲ್ಲ ಇದು.
But 323 bruises and all, my lord.
324 or 326?
326, it's grievous in nature.
Grievous in nature.
So that cannot attract.
Grievous.
Grievous.
Medical.
So just grievous injuries ಏನಂತ
ನೋಡಿ. And they are grievous injuries because she had another boyfriend. It is not previous injuries.
But considering the overall circumstances, my lord,
ಕೋಪ ಬಂದು ಹೊಡೆದಿರ್ತೀರ ಅಷ್ಟೇ.
but my lord sees the first complaint.
ಯಾಕಂದ್ರೆ you will have got to know the other affair.
Could be. The kind of complaint which she has given at page 19 itself indicates.
All that is fine.
2015 in the going around with both the persons, then both.
ಆಯ್ತು, maybe another two also. That's not.
No, I am not finding fault. It is her choice. The point is, my lords, this injuries and all. ತಳ್ಳಾಟದಲ್ಲಿ ಬಿದ್ದಿರಬಹುದು, but my lords, it's vindictive in nature completely.
Yeah, dangerous weapons in.
That is not seized, my lord, because
Seized ಅಲ್ಲ, ಅವಳೇ ಹೇಳಿಲ್ಲ.
ಇಲ್ಲ, ಅವರೇ ಹೇಳಿಲ್ಲ, ತಲೆಗೆ ಹೊಡೆದಿದ್ದಾರೆ ಅಂತ.
ಕೈಲಿನ ದಬ್ಬಿದಾನೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಡೇಂಜರಸ್ ವೆಪನ್.
stay was granted by this honorable court, my lord, in the initial stage of the investigation could not be proceeded.
That is because of 376.
Does not fall under 320. The definition of grievous.
Grievous hurt, that's what I'm seeing.
Not the.
No,
Emasculations.
Can you restrict it?
Not emasculation, then permanent prohibition of a sight of the eye, permanent prohibition of the hearing of the ear, then any member or a joint, destruction of or permanent impairing of the powers of any members of the joint.
323. Because 323 does not refer to whether it is simple or grievous. It's voluntarily causing hurt. Hurt is defined under section 321. Oh, sorry, 319.
The
323, you face trial.
Overall circumstances.
No.
Definitely there could be some alteration, my lords, in the heat of moment.
Merely because she has affairs with 1, 2 or 3 and with you also. Not a license to unleash
My
anything.
submission need not be mistaken as I am judgmental about somebody. Definitely
No,
not.
I'm not on that. She may have multiple affairs, that's a different. 376 attract agala, you're right. But
323, my lord, comes.
Multiple bruises of varying sizes. Left leg, upper back, left arm, abdomen.
ಅದೇನೋ ಮೂಕಾಡ್ದಾಗ ಬಿದ್ದಿರಬಹುದು, but definitely, my lords, it was not intentional. The kind of 5 years they were together and hooking me for 323, my lords, will be.
No, something should be done. 376 you are getting away with.
Only request is the lords may consider exonerating. I will leave it to the lords.
323 ಆದ್ರು ಅದಕ್ಕೆ discharge ಹಾಕೊಂಬಿಡಿ 323. I will hold 323 is attracted in the case at hand. Rest of the things I will quash. Yes.
Not in that event, the matter has to go back to the magistrate court.
I know, it's not court of session, I will quash everything.
Very well.
Because it's already charge sheet ಆಗಿದೆ ಇಲ್ಲ
ಆಗಿಲ್ಲ, stay ಇದೆ.
ಇನ್ನೂ commit ಆಗ್ಬೇಕು ಅದೆಲ್ಲ. Straight away it will go to the magistrate's court. Committal is only by him.
Yes.
Direct ಆಗಿ ಅಲ್ಲೇನು ಹೋಗಲ್ವಾ?
Yes.
the petitioner, sole accused, calls in question registration of a crime in crime number 183 of 2022, registered for offences punishable under section 376, 417, 323 and 504 of the IPC. Heard the learned counsel Venkatesh Dalwai appearing for the petitioner. The counsel for the respondent complainant has remained absent and as a last chance, the matter was directed to be listed today to hear the complainant's counsel. The counsel remains absent even today. Brief facts germane are as follows. The second respondent is the complainant. The petitioner and the second respondent is said to have are friends and are said to have had relationship, as the petitioner and the complainant were all working in the International Tech Park Limited, Bangalore, where the complainant was at a company by name Wages. The relationship flowers into physical relationship as well and lasts for about 5 years. A complaint comes to be registered against the petitioner on 11/7/2022, which becomes a crime in crime number 183, 183 of 2022. Till hakirodu 323 ne. There is no 326.
326 illa.
Yes.
I made my
So
submission.
and so. 183 of 2022. The registration of the crime has immediately driven the petitioner to this court in the subject petition. This court, on the score that the relationship between the petitioner and the complainant was purely consensual, which lasted for about 5 years, and therefore it would not amount to an offense of rape, granted an interim order of stay of further investigation against the petitioner. The learned counsel appearing for the petitioner submits that the relationship between the two was consensual, and at the same time, the complainant was in another relationship between the same period with one Kamalesh, against whom the complainant on 22/10/2020 has complained that he has also breached the promise of marriage and has committed an offense of rape. The learned counsel would submit that during the same period, the complainant had consensual relationships with 2 men, and therefore the story that is twined cannot be true, and there can be no offense of section 376 of the IPC. The learned HCGP, on the other hand, would accept that the relationship between the petitioner and the complainant was purely consensual, and the acts that are alleged are also consensual, except the fact that, as narrated in the complaint on 11/7/2022, the petitioner has beaten the complainant. The beating has led to injury. The injury is depicted to be grievous in the wound certificate. He would therefore contend that the petitioner in the least should face investigation for the offense under section 323 or 504 of the IPC. The learned counsel for the petitioner would in reply submit that in the fit of anger, beka amale discharge tondre sounds. I have given my sounds. The aforenarrated facts are not in dispute. The petitioner and the complainant befriending each other is a matter of record, as they were both employees in different companies in the International Tech Park Limited. The relationship, according to the complaint, was from 2015 through till the date of registration of the complaint. Therefore, it is not 5 years.
323 is non-cognizable. 323.
Gottu, non-cognizable. Adakku investigation bad antana.
Then
We'll
155.
see.
155 2000.
Permission in Bekagala. I have myself granted now. both 323 and 504 are non-cognizable only.
Right, but they
ಅದನ್ನೇ ಚೆಕ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಈಗ? What is this?
Awakening.
24 and 20, Venkatesh should not check all that. Yes.
They can have liberty of going to the magistrate and take permission under 155 too.
All that, all procedure for a non-cognizable offense will have to be followed. I will do that.
That's
So and so. ಎಲ್ಲಿದೆ madam? It is not 5 years, but close to 7 years. Since the issue has now sprung from the complaint, I deem it appropriate to notice the complaint. The complaint reads as follows. Page 13, Annexure B. The complaint would narrate two circumstances. One, the friendship between the petitioner and the complainant up from 2015 to 8/7/2022 till the date on which the petitioner is said to have assaulted the complainant. The the narration in the complaint would clearly indicate for 7 years whatever relationship, be it sexual or otherwise, that has transpired between the complainant and the petitioner cannot but be termed to be consensual. And on such consensual relationship or a relationship on consensus on the promise of marriage cannot mean that it would become the ingredients of section 396 of, section 376 of the IPC. The apex court in its latest judgment in the case of Nai Muhammad versus so-and-so reported in 2023 SEC Online SC page 89 has held as follows. Madam, adak munche manne hakidinala muru hakbidi. The apex court was following the earlier judgments in the case of Pramod Suryaban Pawar and Shambhu Karwar. The apex court holds that every breach of promise of marriage cannot be termed to be a false promise of marriage for the prosecution to proceed against the accused. The other two judgments quoted supra in the cases of Shambhu Karwar and Pramod Suryaban Pawar were all concerning consensual relationship between the prosecutrix and the accused therein, which go on for a long time, which cannot be termed to be a rape, is what the apex court holds. If the facts obtaining in the case at hand, as narrated in the complaint, is considered on the bedrock of the principles laid down by the apex court, the offense under section 376 can hardly be laid against the petitioner. Therefore, the offense under section 376 of the IPC needs to be obliterated and is accordingly obliterated. What remains is the offense punishable under section 323 and 504 of the IPC, both of which are offenses non-cognizable. The complaint also narrates about certain assault by the petitioner upon the complainant. The assault leads to examination of the complainant on 11/7/2022 and a wound certificate is drawn by the doctor. The wound certificate reads as follows. A perusal at the wound certificate would indicate that there has been bruises on the body of the complainant. The bruises are on account of the alleged assault by the petitioner. Therefore, while the offense under section 376 cannot be made out, the offense under section 323 or 504 are prima facie met. In the light of them being non-cognizable offenses, the nuances of registration of a crime in a non-cognizable offense will have to now be followed by the respondent. And once it is done, it is for the petitioner to seek the appropriate remedy of discharge under the charge sheet hagdevaru paravilla. Discharge in the event charge sheet is filed against the petitioner, leaving open the aforesaid remedy, finding that the offense of section 376 laid against the petitioner being in gross misuse and abuse of the law, I deem it appropriate to pass the following order.
417 also there.
Huh?
Cheating is also there.
Oh, 417. One nimsha. Madam, I'm sorry. The other offense is section 417 of the IPC. For an offense under section 417, what is necessary is the ingredients under section 415. In the light of the acts being consensual throughout and no finding of breach of promise of marriage, the ingredients of section 415 also can hardly be met in the case at hand. Therefore, the offences under section 37, the offences under section 376 and 417 would undoubtedly tumble down. So and so, for the aforesaid reasons. The offences punishable under section 376 and 417 of the IPC are quashed. The offences alleged in the crime for offences punishable under section 323 and 504 are sustained. For it is now for the prosecution to follow all the nuances that are necessary to be followed for registration of a crime for a non-cognizable offense and proceed further. In the event the police would file a charge sheet, it is open for the petitioner to avail the remedy of discharge. If finding kottradrinda il barade alle better. A remedy of discharge before the appropriate court, at which point in time the observations made in the course of the order would not come in the way or influence the concerned court in answering an application for discharge on its merit. Yes. Display board.
Permission, my lords, filing my objections on I and above.
Display board. ಮತ್ತೆ 4 ಅಲ್ಲೇ ಇದೆ ಅವಾಗಿಂದ 4 ಅಲ್ಲೇ ಇದೆ ಅವಾಗಿಂದ
objection. Permission of the court, my lords, filing my objections to I and above.
Objections what?
Objections to my.
For vacating.
For vacating the stay, my lords, not required. Basically, it's
not required.
It's taken up for final hearing anyways.
Copies of all the allegations already made, my lord. So we
Okay, ಇದು 498 ಏನಾ?
498.
That goes hand in hand. Otherwise, crime ಆಗಲ್ಲ.
On the very simple basis that in my legal notice I have said, please come and join me. On that basis, your lordship has granted a stay, my lord, in this matter. The very same legal notice in the last.
Husband ಗೆ stay ಕೊಟ್ಟಿದೀವಾ?
ಹೌದು, my lord. In the very same legal notice, I've said I'm pregnant, and hence I would like to have the support of my husband at that point in time, my lord. Hence, it cannot be said that there is no dowry harassment. They are offering a stay in that regard, and that stay is persisted till date, my lord.
It will not persist from today. Tell me. Yes, sir.
May, my lords.
Come on,
My lords, I will just take just a brief history, my lords. The marriage was solemnized, just not more than 2 minutes, my lords. Because dates are quite important. On 15/12/2019, my lords, the marriage was solemnized. Both of them, my lord, lived till 15/2/2020, 16/2/2020, admittedly. That means to say, my lords, exactly 2 months, my lords. Thereafter, my lords, according to the complaint averments itself, both of them have not resided together. The main allegation, my lords, attributed as against the husband is that he had kicked the respondent number 2 while she was 3 months pregnant. Kindly appreciate this fact, my lords. Both of them never resided together. She herself, my lords, in the complaint alleges that they never resided post 16/2/2020.
COVID time alagidda idu.
COVID time alagittu.
Virtually things were happening.
Virtually, my lords. Thereafter, my lords, so the complaint is that I have kicked her.
Virtually.
Virtually, my lords. Probably, it should be. Thereby, my lords, in fact, the fact is that, my lords, she had a paramour, wherein, my lords, the husband had found out. Immediately thereafter, my lords, she left him.
If you have paramours.
No, only her, my lords. That's what I say. At least, my lords.
All right, 1 minute. I'll get back to you.
So thereby, my lords, on 16/2/2020, my lords, she had left a matrimonial home. Thereafter, my lords, I had sent a legal notice on 1/6/2020. My lords, she again replies to the legal notice on 11/6/2020. Now, kindly appreciate, my lords, if you were to look into the reply notice, there is not even an assertion, my lords, that I have sought for dowry or anything, my lords. In fact, the allegations made as against her is that she was not dutiful. She had a paramour.
Not beautiful.
Dutiful, my lords. Dutiful wife.
Yes.
She had a paramour, as well as, my lords, she was abusing the husband himself. That apart, my lords, she had deserted on 16/2/2000.
You were a victim of the wife's abuse.
My lords, most definitely. I'll come to that, my lords. There is again another complaint which is lodged post the filing of this complaint. Wherein, my lords, an FIR has been registered as against. She calls in, my lords. She tries to stab him. In front of,
Stab.
yes, my lords, in front of the police, when the Hoysola was there.
In front of the police, wife
Police.
tries to stab the husband.
Not wife, my lords, her brother. She was present. Both him as well as his mother, my lords, an FIR has also been registered. Now, my lords, here is a case, my lords, the husband is actually the victim, not the wife, my lords. Now, my lords, going back to the.
Why are you playing the victim card, sir? Go to
No,
the
no.
complaint, yes.
My lords, going ahead, my lords. On 18/6/2020, she lodges a complaint, my lords. Now, that is very important. In that complaint, my lords, she only attributes blame on the husband, only to the extent that he is seeking rupees 5 lakhs as dowry.
5 lakhs.
5 lakhs.
5 lakhs.
5 lakhs, my lords. No allegations whatsoever as against the parents, except a last sentence, my lords. And in fact, another allegation leveled is that, my lords, he receives calls at the night, in late night through her, through his students. He's a lecturer, so through his students or their parents.
Night tuition.
Night.
Online.
My lords, COVID, my lords, again.
Yes, COVID time.
COVID time.
Yes.
My lords, this was the allegation. If you were to look into the reply notice, she says that she has no such allegations whatsoever. Now, my lords, on 18/6, she lodges a complaint where there's no allegations against the in-laws.
You have a child?
My lords, no, my lords. That sir,
Oh, 1 minute.
no, that's
I'll get back to you.
aborted.
I'll get back to you, man. Yes.
So thereafter,
you narrate the story. Yes.
I'll narrate the story. So thereafter, my lords, on 27/8/2020, she registers this particular complaint, wherein, my lord, she makes omnibus statements as against the in-laws.
Now, only the husband is here or in-laws?
My lords, both in-laws as well as the husband. The husband is more so here, my lords, because of the fact they allege that he has actually physically assaulted her while she was 3 months pregnant. Going by their very own complaint, my lords, both of them resided together on 16/2 or 17/2/2020. That means, my lords, 2 months from the date of marriage. How could she be 3 months pregnant, my lords, when she is kicked and both of them not residing under the same roof? In fact, my lords, they further allege that there was a mediation, my lords, or a settlement before the masjid. That is the only time they have met each other. So he could not have kicked in front of others, my lords. So all these things, my lords, read together. If you were to see even the reply notice, not even a mere mention, my lords. All she's done in a reply notice is that she's just tried to figure out a way to come out of the allegations made by the husband. Nowhere she is even mentioned, I could say, not even a single whisper that the husband has hit her, abused her, or physically assaulted her, nothing else. I'll take this honorable quote. In fact, my lords, there is also in observation, my lords. In fact, I had obtained a bail also, my lords. And in there's an observation, my lords, in the bail petition, my lords, which I had criminal petition I had filed for bail, my lords, before this honorable court. When para 6, my lords, this para 6 of that particular
page,
my lords, this is filed along with the charge sheet, my lords. So
charge sheet ಆಗಿದೆಯಾ?
Charge sheet ಆಗಿದೆ. ಅದರಲ್ಲಿ
ಚಾರ್ಜ್ ಶೀಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಿರಲ್ಲ ಇಲ್ಲಿ?
ಇದೆ ಸ್ವಾಮಿ.
ಅದರಲ್ಲಿ ಬೇಲ್ ಪೆಟಿಷನ್ ಇದೆ 5628 5268 of 2020.
Yes,
5790.
ಅದರಲ್ಲಿ ಯಾವ ಪೇಜ್?
My lords, para 6, my lords, page 5.
On point number 1.
It would be 128, my lords, in page 128.
ನೀವು ಸೆಟ್ಲ್ ಆಗಲ್ವಾ ಇದು?
We tried, in fact, out of there are several cases filed by each other, my lord.
All against each other, it will be closed.
Yes, my lord. We've
That demand,
the case to settle if you want to.
tried
Definitely, my lords, we tried, my lords. In fact, there also there was an issue. In fact, a shoe was flung on my colleague because since they both had a dispute, she really flung the slipper, which fell on an advocate, my lords. This is the problem.
What preceded it, my lord. The husband made a statement to my colleague, the advocate, to which I took offense because he's a part of our community, saying "Neev karkond hogi sir manege."
That's all right.
Very, very
Anyway.
abusive statement made about her character, my lord.
No,
She
it's
couldn't.
not going to work. Then we'll answer it on merits.
Kindly, my lord.
Yes, we'll do it. Page.
My lords, this page 128, my lords.
128.
128, my lords. Page 6, my lords. This is the observation main, my lords.
128, yes. It is on
Page
record.
5, my lords, it would be internal page 5, 128, para 6. It's on record that the FIR was registered on 27/8/2020. The petitioner got issued legal notice on 1/6/2020 and the complaint replied to it on 11/6/2020. If really she was subjected to cruelty and ill treatment, as has been narrated in the FIR dated 27/8/2020, the same should have been disclosed in the reply to the notice dated 11/6/2020. In the reply, it is very clearly mentioned that the complaint's husband never received any calls at the midnight and she never questioned it. She also denies the panchayat sought to be conveyed at the masjid, wherein my lord, she again agrees. At the outset, it may be stated that the allegations made in the complaint are totally inconsistent with the contents of the reply notice. Thus viewed, it may be stated that the attempt might be made to falsely implicate the petitioner. The allegations require thorough investigation, but at this stage, I find it a case for granting anticipatory bail to the petitioner. His absence, so and so, my lords. In fact, my lords, an interim order right from the beginning has also been operating in my favor.
Yes, that time. It's my, I have granted.
Thorough-
it.
Yes, my lords. Yes, my lords. In fact, I'll just take this honorable court to the reply notice, my lords. At para 3 of the reply notice, my lords, it would be ink page number 30.
Para?
3 of the reply notice, my lords, ink page number 30.
30.
30.
Yes.
Admittedly, there is no dispute with regard to the relationship of the husband and wife respectively. Further, there is also no dispute with respect to their marriage was solemnized on so-and-so date. It is particularly correct about marriage expenses incurred by a client's
Then
parents.
restitution notice, idu.
Restitution notice, Allah Swami. It's basically, he is called upon, my lords, they wanted to part ways mutually. In fact, my lords, the divorce proceedings, in fact, she was herself the one who actually portrayed that she does not want to live with the petitioner. In fact, that is also narrated in my notice, my lords.
Yes, madam.
My lord, there's an offense under 498A as well as the Dowry Prohibition Act, my lord. In our legal notice, please kindly see the last paragraph, my lord. We're saying though our client is under medical treatment for pregnancy and in such situation, page 38 of the criminal petition.
38.
38, my lord.
Notice.
Notice. Same notice which they have quoted for the interim order to be granted.
No, this is 38 is this one.
The reply notice.
Here,
Notice. The last paragraph, my lord. Though our client is under medical treatment for pregnancy and in such situation, your client's moral support is very important and therefore advise your client to take her back to the matrimonial.
That's all
home.
right, but does that amount to 498?
My lord, just because.
Oh, this is
going
husband.
back
In-laws, there is nothing, leave it. Yes, now
lord-
come on the husband.
My lord, husband definitely has been cruel. We've shown several instances, including in the complaint, the police, the investigation officer has also said Dridavagide in his own statement, and the honorable court has also taken cognizance of the offense, my lord, under 498A. We've shown all facts required to prove cruelty under 498A, both physical as well as mental, my lord. Physical harassment, as we've claimed, there's been several instances, the main one being that he harshly kicked the petitioner when she was pregnant, my
That's
lord.
the only thing that is driving.
That is sufficient to attract the charge under 498A, my lord.
But what have the in-laws done?
The in-laws have also been acting with the
Ah.
husband to do this, my lord. It is a charge under 498A. The husband has been treating her physically as
That
well
we will
as
see.
mentally.
Husband will see. In-laws, I'm not going to permit anything.
As I can see, husband.
Even
we
the
continue
husband, you
proceeding,
will
my
have to
lord.
make out a stronger case now. Yes, tell me. Where is the allegation of ingredients of 498 against the husband also?
Complaint on page number 39 may kindly be seen, my lord. It's a
Yes.
written complaint to the police. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ತಿಳಿಸಿರುವುದೇನೆಂದರೆ ದಿನಾಂಕ 15/12/19 ರಂದು ಜಾಲಹಳ್ಳಿ ಕ್ರಾಸ್ ನಲ್ಲಿರುವ
Charge sheet, come to the charge sheet, madam.
That's your first complaint. What are you reading?
Agency.
page number 81, my lord. 81 last paragraph may kindly be seen, my lord. ಈ ರೀತಿ ಮದುವೆ ಸಂದರ್ಭದಲ್ಲಿ ಸಾಕಷ್ಟು ವರದಕ್ಷಿಣೆ ನೀಡಿ ಅಡ್ಡೂರಿಯಾಗಿ ಮದುವೆ ಮಾಡಿಕೊಟ್ಟಿದ್ದರೂ ಸಹ ಮದುವೆ ನಂತರವೂ ಸಹ ಹೆಚ್ಚಿನ ವರದಕ್ಷಿಣೆಗಾಗಿ ಒತ್ತಾಯಿಸಿ A1 ರಿಂದ A3 ವರೆಗಿನ ಆರೋಪಿತರು ಸಮಾನ ಉದ್ದೇಶದಿಂದ ಸಾಕ್ಷಿ 1 ರವರಿಗೆ ಹೊಡೆದು ಬೈದು ಮಾನಸಿಕ ಮತ್ತು ದೈಹಿಕವಾಗಿ ಹಿಂಸೆ ನೀಡಿ ತವರು ಮನೆಯಿಂದ ಹೆಚ್ಚಿನ ವರದಕ್ಷಿಣೆ ತರುವಂತೆ ಒತ್ತಾಯಿಸುವುದು ಪ್ರಕರಣ ತನಿಖೆಯಿಂದ ದೃಢಪಟ್ಟಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಮೇಲ್ಕಂಡ ಕಲಂಗಳ ರೀತಿಯ
What is the FIR registered by you
My lords,
against the wife?
490.
my lords, I've not produced before the court. I have to.
What crime was that?
In fact, my lords, it was 323, my lords.
323.
323.
323.
In fact, there's an MLC also, my lords. An MLC was also. It's in crime number 64 of 2023.
Yes, parents will absolve.
As against the husband,
my
may
lord,
kindly be proceeded
No,
by.
as
Because
against-
in front of
I-
the
wait.
councils, my lord,
So-
there was,
As against the husband, my lords. The date, my lords. The categorical
They may
statement.
get acquitted. That's a
My
difference.
lords?
Prima facie, yes.
No, my lords, prima facie, even their complaint, my lords, goes against it. I'll just read through the last paragraph, my lords, in page number 72, my lords, of the complaint.
Hmm.
In fact, the previous para also, my lords. ಈ ನಡುವೆ ನಾನು ಗರ್ಭಿಣಿಯಾಗಿದ್ದು ನನ್ನ ಗಂಡ ಪದೇ ಪದೇ ನನಗೆ ತವರು ಮನೆಗೆ ಹೆಚ್ಚಿನ ವರದಕ್ಷಿಣೆ 10 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ತರುವಂತೆ ಒತ್ತಾಯಿಸಿ ಕಾಲಿನಿಂದ ಹೊಟ್ಟೆಗೆ ಹೊಡೆದು ಬಡಿದು ಮಾನಸಿಕ ಮತ್ತು ದೈಹಿಕ ಹಿಂಸೆ ನೀಡುತ್ತಿದ್ದನು. ನಮ್ಮ ಅತ್ತೆ ಆಗಾಗ ನನಗೆ ಚುಚ್ಚು ಮಾತಿನಿಂದ ಪಾಲಿಸಿದರು. ದಿನಾಂಕ, ದಿಸ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಮೈ ಲಾರ್ಡ್ಸ್, ದಿನಾಂಕ 17/2/2020 ರಂದು ನಮ್ಮ ತಂದೆ ತಾಯಿನ ಮನೆಗೆ ಕರೆಯಿಸಿ ನಿಮ್ಮ ಮಗಳನ್ನು ವಾಪಸ್ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಎಂದು ಜಗಳ ಮಾಡಿ ನನ್ನನ್ನು ತವರು ಮನೆಗೆ ವಾಪಸ್ಸು ಕಳಿಸಿದ್ದರು. ಅಂದಿನಿಂದ ನಾನು ತವರು ಮನೆಯಲ್ಲೇ ನೆಲೆಸಿರುತ್ತೇನೆ. This is my lords on 17/2/2020. Now let's go back to the reply notice, my lords.
No, not the reply notice.
No, just the reply notice, my lords, wherein she says that I had permitted her to go for medical checkup.
That's all right. The allegation is, when did you kick her?
My lords, there's no allegations. When did I?
Date.
It is not there. It is very conspicuously missing. In fact, my lords, kindly take the objections filed to the main petition here, my lords. Nowhere they have mentioned when I had kicked her on her stomach. So whatever I have done, my lords, it has to be prior to 17/2. If it is prior to 17/2, my lords, she could not have been 3 months pregnant.
my lord, the fact remains, she was pregnant and he kicked her. They are not disputing
My
that,
lords,
my lord. And
Fact of the matter is that, my lords, her pregnancy was also not within the knowledge at that particular point of time.
that
In
is
fact,
something
it
which
is only on the 16th, my lords, that he gets to know that she is pregnant. It's nothing but, my lords, of frivolous allegations, my lords, which is
My lord,
to
this
harass
is-
the petitioner.
This is a matter of trial, my lord. It cannot be stayed and quashed, my lord.
Stayed and quashed.
My lords, one other para, my lords, which I would just like to emphasize, their reply notice itself, my lords, wherein para 10, my lords, this is the day, my lords, 16.
No, sir.
Para 10, my lords, page 35.
Husband
my
will
lords.
face.
No, my lords, just the para, just once.
That you want to file discharge, you file quay the husband. In-laws, I will quash.
Yes, my lord, just only for my satisfaction,
Yes.
para 10, my lords.
Yes.
Our client would like to reply para 8, my lords, of your notice that she had obtained permission from your client for the purpose of medical checkup with the help of the client's mother and left the home on 16/2/2020, my lord.
All
What a
that-
glaring contradiction, my lords. On one
If
day,
they are caught in contradiction, you'll get acquitted. Don't worry.
no, but that
Yes.
can be looked into, my lords, because why would he have to face the trial for a frivolous complaint, my lords?
Husband,
A plight, my
And
lords,
cruelty, my lord.
husband.
plight that has to be faced.
Yes. The petitioners are before this court calling in question proceedings in CC 28214 of 2021, registered for offences punishable under section 498A, read with 149 of the IPC and section 3 and 4 of the Dowry Prohibition Act 1961. Heard so and so. Before embarking upon the consideration of the issue on its merit, I deem it appropriate to notice the relationship between the parties. The second respondent is the complainant, wife of the first petitioner, accused number 1. Accused number 2 and 3 hyphen petitioners 2 and 3 are 62 and 70 are Phil and Mill and Phil of the second respondent complainant. Marriage between the petitioner number 1 and the complainant takes place on 15/12/2019. 2019. It is the narration in the complaint that the complainant was seen with her paramour on 15/2/2020, which is said to have given rise to certain dispute between the two. And on 16/2/2020, the complainant is said to have left the matrimonial house and and the legal proceedings seeking annulment of marriage begin thereafter by causing legal notices or reply notice as the case would be. The story in this petition would commence from the date on which the complainant is said to have suffered a blow from the hands of the petitioner when she was allegedly pregnant of about 3 months on the said date. This action and the subsequent actions of the petitioners herein result in registration of a crime in crime number 68 of 2020. On 27/8/2020, the police, after investigation, filed a charge sheet against these petitioners for the aforesaid offences. Filing of the charge sheet has driven these petitioners to this court in the subject petition. The learned counsel appearing for the petitioner would make Herculean effort to take this court through the documents appended to the petition, seeking to demonstrate that the case at hand is a classic illustration of misuse or abuse of Section 498A by the complainant against the accused, against all the accused. He would submit that if the petitioner was not even living with the husband, the act of assault or a blow upon the complainant at the time when she was pregnant is a figment of imagination of the complainant as narrated in the complaint. He would further take this court to the order passed in the petition granting bail by the coordinate bench of this court to buttress his submission that it is the petitioner, first the husband even, is falsely implicated in the case. Per contra, the learned counsel appearing for the respondent wife would contend that all the three have meted out torture on account of demand of dowry, and this would clearly meet the ingredients of Section 498A of the IPC. She would make pointed reference to the petitioner number 1, the husband, about his torture upon the wife, and contend that it is a matter of trial for the petitioner to come out clean, for the petitioners to come out clean. The learned HCGP would toe the lines of the learned counsel appearing for the complainant in seeking trial against these petitioners for them to come out clean. I have given my source. Therefore, narrated facts are not in dispute. The relationship between the two floundering is a matter of record. The floundering of the relationship resulting in proceedings other than the one that is impugned in the petition is also a matter of record. The issue in the list has triggered from the registration of the complaint. The complaint so registered by the second respondent complainant against the petitioners reads as follows. That is page 39A-B. The complaint narrates that the first petitioner husband and the in-laws have meted out torture by demanding 5 lakhs from the hands of the complainant's family or the complainant, and the complainant had already, the narration is the complainant's family had already given 15 lakhs as dowry to the petitioners. It is a narration in the complaint, though. The other narration is that the torture meted out by the husband against the wife. While the complaint does not narrate any circumstance that would become the ingredients of the offences under Section 498A against the mother-in-law and father-in-law, it makes a sprinkling reference to the allegations against the husband. The police, after investigation, file a charge sheet. The charge sheet, summary of the charge sheet as obtaining in column number 7 reads as follows. A perusal at the summary of the charge sheet is indicative of the fact that there are certain allegations against the husband, accused number 1, and none that would touch upon the ingredients of Section 498A or 3 and 4 of the Dowry Prohibition Act, the petitioners 2 and 3, the father-in-law and the mother-in-law. The summary of the charge sheet reads as follows. Page 79, marked portion. Adu continue agide. page 81. If the complaint and the summary of the charge sheet are read in tandem, what would unmistakably emerge is that the father-in-law and mother-in-law are without rhyme or reason dragged into the web of crime by the respondent wife, while the allegations of assault or otherwise are all against the husband. Therefore, permitting further trial against the father-in-law and the mother-in-law would run foul of the judgment of the apex court in the case of Kashkan Kaushar versus State of Bihar, 2022 SCC online SC page 162 para 10 to 21 extractment. So and so. In the light of the aforesaid facts, qua the mother-in-law and the father-in-law and the judgment of the apex court, in the considered view of this court, further proceedings against the accused 2 and 3 needs to be quashed. Insofar as the offenses against the husband are concerned, it revolves around a maze of facts. It transpires that the petitioner himself wanted to register certain crime against the wife or the family members of the wife. But the complaint or the narration in the summary of the charge sheet would clearly pin the petitioner, albeit prima facie, to the ingredients of the offense punishable under section 498A. Therefore, it is for the petitioner to avail of such remedy as is available in law before the appropriate fora at the appropriate time. It is not a case where this court would exercise its jurisdiction under section 482 of the CRPC and obliterate the crime against the husband. Though the learned counsel would make strenuous effort to take this court through the judgment of a coordinate bench while granting bail, the finding of the coordinate bench for grant of bail is also a prima facie opinion. Therefore, the petitioner should either come out clean in the trial or avail of a remedy at the available remedy before the appropriate fora. For the aforesaid reasons, the following order. The criminal petition against the first petitioner stands dismissed, reserving liberty to him to avail of such remedy as available in law. The criminal petition insofar as accused 2 and 3, the Phil and Mill, stands quashed.
Much obliged.
Petitioners in this case.
Madam, 4 o'clock settlement kar. 1 niಮಿಷ.
Please.
For respondent number 2, my lord.
Offense.
Petitioner. The matter has been settled before the family court, my lord.
498.
Please.
The parties were also before the family court in MC. Family court. Look at
534 of 22, my lords. It's before the Nagpur court, my lord, not here.
Consent terms for mutual consent divorce. Madam, page 43. Clause 7 and 9 extract. Yes. Counsel for the so-and-so undertakes to enter appearance with the second respondent. Registry to print the name of so-and-so is appearing for the second respondent. Yes.
72.
Yeah, 48. The settlement allay agide. Both the learned counsel appearing for the petitioner and the respondent would submit that the conditions stipulated in the terms of settlement before the concerned court have all been fulfilled. Accordingly, the Tanish Kayar.
Respondent number 2, my lord.
Complainant.
Yeah.
Accordingly, the complainant has filed an affidavit of such compliance. The affidavit is taken on record. Disposed cost. Then court madad bada. Next.
Obligement.
Sign ಮಾಡ್ಬೇಕಿದ್ರೆ.
Petitioner, my lord.
An offense.
Yeah. Offense is under section 406, 331. 406, 331, 120B, 201.
Application. 86 either. Yes, Nischal, settle.
Parties are present. And the petitioners are paying a sum of rupees 30 lakhs to the
Compounding and compromise get civil court, civil suit alla.
compound, I will correct.
I have filed, the petitioners are before this court so and so. During the pendency of the petition, the parties to the list have resolved the dispute among themselves by drawing up certain terms of such resolution, such settlement, and have filed an application seeking compounding of the offense. The said application for compounding also recognizes the closure of the present proceedings, i.e. CC 14176 of 2023. The said application for compounding insofar as it is germane reads as follows, page 3 ಅಲ್ಲಿ on in the light of not being against the state ಅದೆಲ್ಲ ಗೊತ್ತಲ್ಲ. Yes. Yes, next.
Lord,
Offense.
offense 307, my lord.
In same parties.
Injury.
Injury, my lord. Lord, I would like to pass on.
Wound certificate ಕೊಡಿ.
Yes, yes, wound certificate, my lord, which has not been annexed in the petition.
The wound certificate.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ನಿಮ್ಗೆ?
Copy.
ಸ್ಟೇಟ್ಗೆ ಕಾಪಿ ಕೊಡಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್.
5 and 8, my lord, with
For respondent.
swelling and tenderness.
In grieve. 5 and 8 are grievous in nature.
Yes, my lord, swelling and tenderness, my lord, as per the law.
I am not a doctor to assess that.
No, my lord, no.
We go
no.
by the certificate.
Yes, my lord. Lord, if lordship peruse the judgment of Lakshmi Narayan, your lordships are saying, in that, my lord, the court has to ascertain whether on which.
Simple or grievous?
Yes, my lord. Even the court can see, my lord, I would like to pass on, my lord. 15.4.
15.4.
I am permitted to read, my lord. Offenses under section 307 and the Arms Act, etc., would fall in the category of heinous and serious offenses, and therefore are to be treated as crime against society and not against the individual alone.
ಆಯ್ತು, vital and delicate parts of body alla bidi.
Yes, my lord. Here, my lord.
What is the relationship between them?
Lord, in the case of the prosecution, my lord, here, the complainant, my lord, was in love with the first petitioner. First petitioner was already married. So on that, in that pretext, my lord, there was a quarrel took place. In the light of that, my lord, now we have filed an application, my lord, where they are ready to settle by paying an amount of rupees, my lord.
10 lakhs ಏನೋ ಕೊಟ್ಟು ಮಾಡ್ಕೋತೀವಿ ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
That is not permissible, sir. 307 allad ಕಷ್ಟ.
Yes, 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 my lord, but one more judgment, my lord.
All married lady, why should
Even tomorrow they go for trial, my lord, they will end up with
acquitted only? Yes, because they'll turn hostile.
One more judgment, my lord, I would like to pass on of this honorable court.
This I have seen. It's before Lakshmi Narayan.
No, my lord, Lakshmi Narayan was cited in that.
Idralla.
15.4, para 3, second page.
Idu 307 na?
Yes, yes. Court has seen all
the petitioners are before. Who is this? Clara? All are here?
Yes, my lord, all are here.
Who is the complainant?
Complainant
Mahadeva Prasad.
Yes, my lord.
What is the relation of the complainant with, that is what you said?
Yes, that is the case of the prosecution.
The petitioners accused 1 to 9 are before this court seeking quashment of the entire proceedings in SC 708 of 2023 registered for the following offences. While all the other offences, following offences, during the pendency of the petition, the parties to the list appear to have entered into a settlement, monetary, on considerations, monetary or otherwise. The offence, while all the other offences are acceptable to be compounded, or the offence under section 307 of the IPC is what needs a deeper consideration. The allegation in the case at hand is against the first petitioner, who is said to have assault mandrathu. Then offences are grave.
3, 4, 5 and 9, my lord.
Well, offences are so grave.
But in that, the discussion, my lord, the quarrel took place.
Quarrel took place. In the quarrel, offences are very grave. How can you settle it by monetary considerations?
But he has only come forward and he has a, if your lordship tells the FIR complaint was registered after 10 days. Even in the wound certificate, my lord, there was no mentioning of the who has assaulted. That was silent. A complaint came to be registered after 10 days. Initially, he has given a complaint before Birdi station. He has stated that some unknown persons have assaulted. The lordship peruse the complaint for a page 25, my lord, which in type of portion. Last on the 4, 3, 4 lines.
Government.
Because there are other judgments, my lord.
There are judgments.
Because monetary consideration
Monetary
cannot be a-
consideration
not be a ground for
though the settlement on account of monetary consideration in the teeth of the offences alleged would not entail settlement of the dispute to give a quietus to the said issue, I deem it appropriate to notice the judgment of the apex court in the case of Lakshmi Narayan, which was also considering closure of a case under section 307, the closure of a case where offence alleged is section 307 of the IPC. The apex court lays down certain postulates of the compounding of the offences in cases where offences are non-compoundable. Paragraph 15 of the said in judgment reported in 2019 5 SCC 688, State of Madhya Pradesh versus Lakshmi Narayan. The apex court has held as follows: para 15 purti extract, 15 1 2 3 4 5. The apex court at paragraph 15.4 was clearly considering the settlement under section 307 of the IPC. The apex court observes that the court answering the said settlement, answering the claims for such settlement, should necessarily look into the injury sustained, whether the injury has been inflicted on vital or delicate parts of the body, and the nature of weapon used. The wound certificate reads as follows. In the light of though the wound certificate depicts 2 of the wounds are grievous in nature, they are not on the vital parts of the body, as is held by the apex court in the aforesaid paragraph. Therefore, in the peculiar facts of this case, as the parties to the list have projected a settlement between the two, I deem it appropriate to accept the same and close the proceedings. It would further be apposite to notice a subsequent judgment to the judgment in the case of so-and-so Lakshmi Narayan in jail Ganeshwar, state of Karnataka, where the offence alleged was inter alia section 307 of the IPC. The coordinate bench has held as follows: para 3.2. Well, in the light of the aforesaid law and the facts obtaining in the case at hand, I deem it appropriate to pass the following order: disposed, quashed.
Grateful, my lord.
Yes.
Yeah, paper of petitioner. Petitioner is a de facto complainant.
Why are you before the court?
Yeah, the matter has been settled between the petitioner and respondent number 1, 2, 3, my lord.
Where are the others?
Yeah, respondent number 2 and 3 are present, my lord. Respondent number 1 is 354, 504 and 506.
Why did she complain?
Yeah, there's an assault when she had gone to bring her sister-in-law,
Hmm.
then assault between the respondent 1, 2, 3 and the petitioner, my lord. Verbal assault. I'm filing the joint memo.
Yes, government.
Copy code.
Who is identifying the respondents?
No, the respondent.
Counsel yaridare?
No, there's no counsel still.
Somebody should be there.
The brother is also an
Can't
advocate.
be like that. I'll post it tomorrow, get some counsel.
Please.
List tomorrow. To report settlement at 4 PM.
Okay.
ಯಾವ್ದು 4 PM ಮ್ಯಾಟರ್ಗಳಿದೆ ಮೇಡಮ್? 4 PM ಕರೆದ್ಬಿಡಿ.
For the petitioner, my lords, we were directed to file 164 statement of the victim, my lords. My lords, we have not procured it yet, my lords. My lords,
What was the matter?
my lords, this pertains to the POCSO, it's a POCSO matter, my lords, where the victim is a boy, my lords. And
Victim is a boy.
Yes, my lords.
Father is the complainant, my lord.
Fa-
The allegation
father
is
is-
against the mother and the boyfriend of the mother.
Mother.
POCSO against whom?
Against the mother is the accused number 2, my lord, and
Whose
mother's
mother?
boyfriend.
Victim is the son of the accused number 2, my lords. Whereas accused number 1 is the boyfriend of the mother, my lords. Yes, my lords. Victim is a boy, my lords.
The victim is a boy is fine. You're alleging against the mother.
Yeah, as against the mother, it's already stayed, my lords.
Now, who is the petitioner?
My lords, the boyfriend of the mother, my lords.
Oh.
Charge sheet ಆಗಿದೆ. Charge sheet is already filed. Charge sheet.
Various hues and forms of human psyche. Yes. Yen beki, 164 statement.
Yes.
The learned counsel for the petitioner seeks time, comma, yet again to produce the 164 statement of the victim made before the learned magistrate. When do you what? 21st?
My lords,
21st or 22nd?
my lords, before 18th, my lords. because-
Before 18th,
Yes,
all
my
right.
lords.
18th, we'll post it on 18th. Or you want on 17th?
17th, my lords.
17th ರಜಾ ಇದೆ.
2024. List the matter on 17th in the fresh matters. 17th is a holiday matter. 18th, 19th, yes. List on 19th in the fresh matters.
My lords, may I request for 14th, my lords?
14th.
My lords, it's set down for framing of charges on
If
18th.
you
my
get
lords.
this statement, then I will take it up. On
14th.
your record, it is getting adjourned.
14th. my
14th,
lords.
all right, 14th.
Grateful, my lords.
Lord, there was a direction by this honorable court to produce certain, because allegation is saying that there was a 9 lakhs money has been transferred to petitioner's account.
My lords,
The lordship has
colleague
direct-
is appearing in this matter. He's held up in other court, my lords.
Who was directed to produce?
Respondent,
Government or you?
the second respondent, my lords. It's in other court, my lords. Kindly pass it over. my
9,50,000.
Please.
That is what the allegation by lordship, you kindly see that.
Appears that there is a memo which he has prepared, my lords. You'll place it on record.
All right. Pass over, we'll see.
Please,
Yes.
great.
Next, 4:15 yavudu. Yesterday's matter. One more. You're ready?
Yes.
5 minutes. Only.
Only 5.
Where is Neglur Saridan? Anyway, he said you have to submit.
Yes, I just said. Not, I'll just,
3 judgments he has to make.
Ade, those judgments.
yes, I'll clarify that. Lord, before that, only on facts, just one, Lord, 2 important dates. Lord, in the complaint at page 47,
230 other idea, madam. Sorry. Yes.
at page 47, the allegation is in August 2012, the incident occurred, after which her husband, I mean, she's complained to her husband and her husband says,
No,
whatever.
facts are vivid.
Yes.
I'm
No, yes, now, my Lord,
I've not forgotten the facts. Yes.
now the date on which, my Lord, she leaves her husband.
That also is there. Everything is considered. In
If
fact,
it's-
I only want your reply on legal.
Very well,
submissions.
very well. No,
Those
only-
3 judgments he
Yes.
said. What is the latest on delay in reporting rape cases?
Yes.
So this was heard long ago. So
Yes.
if what is the latest,
Yes.
you should give me.
on facts only to point out, my lord, that the complaint itself, my lord, the statement highly improbable, because after she separates from her husband, she says that she informed her husband.
Which is this?
But
Yes.
this Prashant Bharati, my lord, if my lord
That is an old one that I have seen.
No,
You
idrili
have to
para,
come para
Prashant Bharati, my lord, para 6
and 90.
and 90.
All right.
Then, my lord, the other one is 2024. That's at page 19.
Hmm.
Here, my lord, there was a delay of 34 years. Para 12 and 15.
Hmm.
The last one again, my lord, it's on the point that, my lord, solely on the basis of para 5, solely on the basis of, my lord, statement, my lord, of the prosecutrix, my lord, the prosecution, my lord, cannot be sustained.
Vijayan is also old.
This is also old.
Only the 34 year is the latest.
Yes, that is the latest. And not with the reference to the other judgments, but there's a Kerala High Court judgment, not which I had relied upon in the first compilation, which is of 2013, which is at page 108 for the first compilation. But that not judgment not was a case where FIR was quashed. Page 108 not would get it, the first compilation.
One zero
108.
is Prashant Bharati.
There's another one which was not filed on not 8/8/23.
8/8/23. ಯಾವುದು madam 8/8/23? There is nothing on 8/8/23. 8/8/23. I don't think there's any.
7/4/22 it was filed is what not my
7/4/22.
Sorry, 14/7/22.
14/7/22 is here. What is 8/8/23?
I'm sorry, that's a wrong, that's a different date. I'm sorry. 14/7/70. Them not.
ಇದರಲ್ಲಿ 108 is Prashant Bharati.
Actually, Jose Tayatil, Lord, it is 2013 SEC online Kerala judgment. Serial number 8.
Serial number 8 is Sardar Ali Khan. What are you holding, sir?
ಬೇರೆ compilation ಇರಬೇಕು.
ತೊಗೊಳ್ಳಿ, ಯಾವ್ದು ನಿಮ್ಮ ಹತ್ರ ಯಾವ್ದು ಅದ್ರ ಕಾಪಿ ಕೊಡಿ.
ಅದನ್ನ ಕಾಪಿ ಕೊಡಿ. Because in that judgment, not FIR was quashed and that not order was confirmed by the apex
petition paper. Volume 2. Earlier judgments. Yes.
Sorry, the page numbers are wrong. But
this is 140.
Please. Here, Lord, the FIR stage itself, not the proceedings were quashed by the Kerala High Court.
Offense of rape?
Yes, Lord.
Sir,
Lord,
this is promise of marriage.
Yes. Promise of, no, not only promise of marriage, but here she says, Lord, she had an affair with her husband.
Dilip Singh, consent, misconception of fact.
But Lord, the court deals with the fact the allegation is made against an MLA, stating that, Lord, the son of the MLA is going to marry her. It's on that case, not the FIR is registered.
ಈಗ ನಿಮ್ದ್ರಲ್ಲಿ ಏನು ಏನ್ ಪ್ರಾಮಿಸ್ ಆಫ್ ಮ್ಯಾರೇಜ್ ಇದೆ?
ಪ್ರಾಮಿಸ್ ಆಫ್ ಮ್ಯಾರೇಜ್ ಇಲ್ಲ.
ಮತ್ತೆ
ಪ್ರಾಮಿಸ್ ಆಫ್ ಮ್ಯಾರೇಜ್ ಇಲ್ಲ.
ಸ್ವಾಮೀಜಿ ಏನ್ ಪ್ರಾಮಿಸ್ ಆಫ್ ಮ್ಯಾರೇಜ್?
ಇದರಲ್ಲಿ only fact remains that in the complaint that she files under section 125 for maintenance, there is no allegation that husband forced her to undergo this process, nor in the legal notice, nor in the divorce petition. And her statement is contrary to her own statement in the 125 proceedings. And before the CID, when he gives the statement, she does not even whisper about this. She says someone else has not committed 354, but she does not refer to the petitioner.
We'll see. Heard reserved. Yes.
Please.
Ultimately.
Yes.
CGP opposes, sir.
Opposes, sir.
Opposes the petition. And
of course, you will vehemently opposes.
especially in this matter.
Of course, sir. Can I say you have conceded? Yes.
Great.
In what, which case have I said you have conceded?
Yes, ma'am.
Yes. 230.
Madam, this could hearing for the petition. I'm filing a memo for withdrawal, my lord. Kindly liberty maybe.
Thank you, sir. Yeah, next.
Liberty to challenge the
Yes, sir.
charge sheet.
ನಿಮ್ಮ ಮೆಮೊಲಿ ಹೇಳಿದಿರ ತಾನೆ? ಎಷ್ಟು ಮ್ಯಾಟರ್ ಇದೆ ಮೇಡಮ್? 3 ಅದೇನಾ? ಬರೋಲ್ಲ?
Extension. I think.
ಯಾರಿದ್ದಾರೆ? Parole.
Copy could sir.
Extension.
Extension of parole. You are back to the goal. ಅಲ್ಲ ಎಮರ್ಜೆನ್ಸಿ ಪೆರೋಲ್ ಕೊಟ್ಟಿದ್ದ ಏನು?
General parole. In both the cases.
Regular parole.
Regular.
General
45, please.
General parole, 45 days.
45 days your lordships have given. In one case,
Lordship may have it tomorrow.
Why?
ನಾಳೆ ನೋಡ್ತೀನಿ ಫೈಲ್.
Another 45 days.
ಮೂಡ್ ಮ್ಯಾಟ್ರ್ ಇದು.
Mood matter.
ನಾಳೆ ನೋಡಿ ಬೆಳಿಗ್ಗೆ.
ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ? 7 ವರ್ಷ.
Please. And he is a first time parole.
ಅಲ್ಲ, ಫಸ್ಟ್ ಟೈಮರ್.
But he has got 2 children. Wife is also not there.
Right. ತೊಂದ್ರೆ ಇಲ್ಲ. 498. 302 ಆಗಿದ್ರೆ.
ಆಯ್ತು.
Yes.
ಆಯ್ತು.
ವಿಜಯಕ್ಕೆ 45 days. ಅಷ್ಟೇ. No liberty for extension.
I will not say.
Don't cite. Yes. Vehemently opposed. Rahul Karyappa vehemently opposed ಅಂತ ಹಾಕಿ. Yes.
It's also 45 days has been.
ಇದೇನು 302 ನಾ?
It's a 302 where he has obtained two general paroles. No conditions have been violated till now.
I will go by your statement and grant.
Yes.
Then don't
But I
put
will-
him to.
No.
Yes.
I will not take such cases where there is.
That's correct. That I have seen. Yes. Same.
Please.
Vehemently opposed.
Great.
Yes. Next year. Go back to the list.
Bar council matter is.
Why is Prasanna Kumar waiting?
Lordship said and to be taken at after 4 o'clock. Sir.
ಯಾವ್ದು?
Bar council.
ಇವರು ಇದಾರೆ ಅಂದ್ರೆ ಅದು ಬಾರ್ ಕೌನ್ಸಿಲ್ ಇರ್ಬೇಕು.
ಅಲ್ಲ ಬಾರ್ ಕೌನ್ಸಿಲ್ ಎಲ್ಲರೂ ಇಲ್ಲೇ ಇದಾರೆ, ನನಗೆ ಬಿಡ್ತಾ ಇಲ್ಲ ಹೋಗೋದಕ್ಕೆ.
ಅಲ್ಲಿ ನೀವು ಒಂದ್ ಕೆಲಸ ಮಾಡಿ, ಕೂತ್ಕೊಂಡು ಸೆಟಲ್ ಮಾಡಿ
ಆಗಿದೆ.
ಜಾಯಿಂಟ್ ಮೆಮೋ ಹಾಕ್ಬಿಡಿ. ಜಾಯಿಂಟ್ ಮೆಮೋ ಹಾಕಿ.
ಜಾಯಿಂಟ್ ಮೆಮೋ ಹಾಕಿದ್ರೆ somebody else may not revive it. Therefore.
Why? I will answer it on merit. I will record everything and then close it on joint memo. ಮಾಡಬಾರ್ದು ಅಂತೇನಿಲ್ವಲ್ಲ. Whatever it is you Gautam,
Please.
didn't I tell you last time?
Please, Milods, the instructions.
Where is that other matter?
Milods is connected, Milods.
Council
The writ
matter.
petition, Milods. Milods, the service is not complete in the.
76.1. ಬಾರ್ ಕೌನ್ಸಿಲ್ಗೆ ತಗೊಂಡಿಲ್ವಾ?
Milods, the service is not complete, Milods.
When do you complete the service, sir?
Milods, the process was paid on the 4th. It was dispatched on Friday, Milods. And earlier, Milods, the panel council did not have instructions. So
No, true. Sridhar Prabhu did not have instructions, so I deleted his name. You sit across, file of a joint memo, we'll close it. 18th ತಗೊಳ್ಳ?
ಅಲ್ಲ ಇವತ್ತು ಹಾಕ್ಬಿಡ್ತೀವಿ.
ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ? ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆ, ಸ್ಟೇ ಇದೆ, ನಿಮಗೆ ಏನು ತೊಂದರೆ ಆಗ್ತಾ ಇಲ್ಲ, ಅದ್ರಲ್ಲಿ ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ?
ಕೀಪಿಂಗ್ ಇಟ್ ಪೆಂಡಿಂಗ್.
No, I am really surprised about the urgency projected. ಅವತ್ತೇನೋ farewell ಇತ್ತು, ಆಯ್ತು. No problem. I say passed an order. It will not. We close ಮಾಡಕ್ಕೆ ಏನ್ ಅರ್ಜೆನ್ಸಿ? ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್.
23ನೇ ತಾರೀಕಿನ ಬಾರ್ ಕೌನ್ಸಿಲ್ ಎಲೆಕ್ಷನ್ ಬೇರೆ ಇದೆ.
ಎಲೆಕ್ಷನ್ ಇದೆಯಾ? ಯಾವ ಎಲೆಕ್ಷನ್ ಇದೆ? ಯಾವತ್ತು ಎಲೆಕ್ಷನ್?
23rd.
ಎಲೆಕ್ಷನ್ ಆಗ್ಲಿ, ಕಂಟೆಸ್ಟ್ ಮಾಡಿ.
ನಾಡಿದ್ದೇನೋ
ಅದಕ್ಕೇನಂತ? I'll post it on Tuesday. Sit across, settle everything.
Everything is settled, Milord. I think.
Joint memo ಹಾಕಿ.
Please, Milods, we'll file a joint memo, Milods, and the BCI has to come and either withdraw the panel constituted by the BCI. They should.
No, that should also be resolved.
ಅದಕ್ಕೂ ಈಗ ನಾವು ಕಂಪ್ಲೇಂಟ್.
Otherwise, then that will hang on. That's a gag order which I have to quash.
In that, now we're not the complainant.
ಅಲ್ಲ, ಒಂದು ಇದು ಮಾಡಿ, take out hand summons or by way of mail.
Hand summons also.
Electronic mail you can take.
Please, Milods, please.
Tuesday ತಗೊಂಡ್ಬಿಡ್ತೀನಿ, we'll close it, you file a joint memo ಅಷ್ಟೇ. ಅಲ್ಲಿವರೆಗೂ ಏನಾದ್ರು ತೊಂದರೆ ಇದ್ರೆ ಹೇಳಿ, I will permit you to participate anywhere.
ಅಲ್ಲಿವರೆಗೆ ಏನ್ ತೊಂದ್ರೆ ಇದ್ದಂಗೆ, ಏನ್ ತೊಂದ್ರೆ
ಈಗೇನು ಯಾರು ರಿಟೈರ್ಮೆಂಟ್ ಇಲ್ಲ, ಯಾರು ವೆಲ್ಕಮ್ ಮತ್ತೇನ್ ಪ್ರಾಬ್ಲಮ್? ಯಾರ್ದು ಇಲ್ಲ. Interim order ಇದೆ, everything is protected. There is no investigation going on.
ಏನಿಲ್ಲ.
So whatever you have in your hand to close it, sit across with him. No, I only want to give a quietus to this problem. That's all and nothing else. So on 18th, I'll take it. You file it and 2:30 mention ಮಾಡಿ close it. By then, the petitioner in 76.1 is directed to take out service of notice upon the Bar Council of India by way of hand summons or by way of electronic mail. Yes.
Both of us are mentioning that we are going to file joint memo.
Both ಮಾಡ್ಲಾ?
Please.
ಅವ್ರಿಗೂ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಇದೆಯಾ ಇಲ್ಲ?
That would be the right. Joint memo will file minutes. And
Have you instructions for that from?
He has instructions to say no objection for this petition.
Joint memo. The learned counsel appearing for the parties would submit that they would, on the next date of hearing, file a joint memo to give a quietus to the problem. The submission is placed on record. List on 18th.
Please.
18th ಮುನ್ನೂರು ಇರುತ್ತೆ, ಪರವಾಗಿಲ್ಲ, ಬಟ್ ನಂಗೆ ಮೆನ್ಷನ್ ಮಾಡಿ 2:30 ಕ್ಲೋಸ್ ಮಾಡಿ ಅಷ್ಟೇ.
Interim order in both the matters.
Interim order subsisting in any of these cases shall continue till the disposal of the petition. ಆಯ್ತು, ಮತ್ತೇನ್ ತೊಂದ್ರೆ? Yes.
Please.
ಕಂಟಿನ್ಯೂ ಮಾಡಿ. ಅಲ್ಲಿವರೆಗೆ ಬಂದಿದ್ದೀವಾ? ಎಲ್ಲ ಟೈಮ್ ಕೊಟ್ಟು ಎಷ್ಟು continue the list.
For petitioners.
306.
My lord, there is other case, my lord, which has been registered by the petitioner against the respondent. 498 is.
We filed 498.
Which the charge sheet is.
Your
also
husband?
filed.
No, my lord, we are the wife, my lord.
Wife.
The wife family is before this.
So your complaint ಕೊಟ್ಟಿದ್ದಾರೆ 498 ಅಂತ. I went to the station.
Oh, the husband commits suicide.
No, father-in-law commits suicide.
Father-in-law
Father-in-law
commits
commits.
suicide.
Station ಹೋಗಿ ಬಂದು he commits suicide. That is pending, my lord, before the trial court.
What is the other petition?
That they are not filed the petition, my lord. I just received the CC number in which they are not.
306 ಹೆಂಗ್ ಬರುತ್ತೆ?
ಬರಲ್ಲ. ಅವರು ಪಿಟಿಷನ್ ಹಾಕೊಂಡ್ರೆ ಒಟ್ಟಿಗೆ ಎರಡು ಕ್ಲೋಸ್ ಮಾಡ್ಬೋದು, because the accused in that matter, she has lost her husband.
I can't anticipate that they will be filing a petition. In fact, my lord,
You should, you have abetted the death, abet them to file another petition. We'll close both.
my lord, in
You
fact,
have allegedly abetted the death.
we have tried to make a settlement, my lord. They have not come forward. In fact, we are told them that
Through the
petition is filed.
investigating officer, I'll just inform.
Investigating officer?
I'll just inform them, my lord, whether
ಏನಂತ?
ಫೈಲ್ ಮಾಡ್ತಾರೆ ಏನೋ ಕೇಳ್ಬಿಟ್ಟು.
ಫೈಲ್ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ರ?
I was said, my lord, but
ಆಯ್ತು, ಇದನ್ನ ಕ್ಲೋಸ್ ಮಾಡತ್ತೀನಿ. ಅದೇನಾದ್ರು ಇದ್ರೆ ಫೈಲ್ ಮಾಡಿ, ವಿಲ್ ಕ್ಲೋಸ್ ದಟ್ ಆಲ್ಸೋ. ದೆನ್ ಯು ಆರ್ ನಾಟ್ ಗೋಯಿಂಗ್ ಟು ಅಬ್ಜೆಕ್ಟ್ ಟು ಎನಿಥಿಂಗ್ ಆಫ್ ದಟ್.
No, no.
ಇವ್ರಿದಾರೆ ಅದರಲ್ಲಿ.
ಇವ್ರು ಇದಾರೆ ಅದ್ರ ಬರ್ಲೇಬೇಕಲ್ಲ ಸ್ವಾಮಿ.
My lord, they have not filed a.
ಆಮೇಲೆ ಇದನ್ನ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಟ್ರೆ ನೀವು ಬರೋದೇ ಇಲ್ಲ ಈ ಕಡೆ.
No, they have not filed a petition, my lords, before this court challenging.
Ask them to file a petition, we'll close everything. This on merits, I will pass orders.
They're not coming for any settlement at all. In fact, we told that this petition is filed. If they could have filed it, my lords, we could have closed everything.
ಇಲ್ಲೂ served unrepresented.
Served unrepresented.
R2.
ಯಾವತ್ತು ಸರ್ವ್ ಆಗಿದೆ ಮಾಡಿ? 22. ಇಲ್ಲ, ಡೇವಿಡ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ.
No, my lord's judgment is there.
ಡೇವಿಡ್.
Not David, my lords. Kanchan Sharma, my lords. And
Kanchan Sharma is Supreme Court, sir.
in the Rekansh Chopra, my lords had referred to that Kanchan Sharma and asked that there are no ingredients made out.
Now, there is one judgment, David, which I have rendered recently. They're all old. Or don't update yourself. Yes. The petitioners are before this court calling in question the proceedings in Crime number, see, charge sheet agilva?
ಇಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಇಸ್ ನಾಟ್
Huh?
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ಲ.
Crime number 69 of 2022. Investigation ಏನಾಗಿಲ್ವಾ? When was the crime registered?
On 22/5 to 2022 months.
22/5. Date of the interim order?
Interim order was granted, my lord, 8 of August 2020.
4 months ಏನ್ ಮಾಡಿದ್ರಿ? 3 months investigation ಆಗಿಲ್ವಾ?
ಚೆಕ್ ಮಾಡ್ತೀನಿ ಸರ್. Just secure the paper.
Secure the papers. By then they will also come. The learned HCGP is directed to secure the investigation papers conducted between the date of registration of the crime and the grant of an interim order at the hands of this court. There is a reason why I am doing it.
Please.
Yes. So that ಮುಂದೆ ತೊಂದರೆ. Get that David by that time.
It is there. I'll get.
Then
copy.
David ತಾನೆ?
Please, David is for.
Go and die David.
Please.
Go and die David. Yes. The allegation was that.
Please.
ಇದ್ರಲ್ಲಿ ಗೋ ಅಂಡ್ ಡೈ ಇಲ್ಲ, ವಾಲಂಟಿಯರ್.
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಇತ್ತು. I have considered the entire spectrum of
Please,
law.
my lord,
Yes.
consider.
Unable to bear the embarrassment, he has committed his.
All right. ಅದರಲ್ಲಿ ಎಲ್ಲ judgments ಇದೆ ಅದರಲ್ಲಿ.
Please.
Just get it.
I'll do.
Yes.
Interim order.
Don't get 2021. We are in 24.
I'll get there.
Yes.
Latest. Interim order may kindly be extended.
Interim order subsisting shall continue till the next date of hearing. Post it on 22nd. Come and get the papers by then.
My lord, I'll get
We'll
the
close it.
Great.
Offense punishable under section.
Disaster Management Act.
Yes, ma'am.
Yes. Case is a disaster. ಏನಿಲ್ಲ. 353 ಏನಿದೆ?
My lords, the allegations in the charge sheet are at page 48, my lords. If I may read, my lords, column 17.
Yes.
ಈ ದೋಷಾರೋಪಣ ಪಟ್ಟಿ ಕಾಲಮ್ ನಂಬರ್ 12 ರಲ್ಲಿ ನಮೂದಿಸಿರುವ ಆರೋಪಿಯು ಕಬ್ಬನ್ ಪಾರ್ಕ್ ಪೊಲೀಸ್ ಠಾಣಾ ಸರಹದ್ದಿನ MG ರಸ್ತೆಯ ಅನಿಲ್ ಕುಂಬ್ಳೆ ಸರ್ಕಲ್ ಸಮೀಪದ ಬಾರ್ ಸ್ಟಾಕ್ ಎಕ್ಸ್ಚೇಂಜ್ ಮುಂಭಾಗದಲ್ಲಿ ದಿನಾಂಕ 28/1/2020
ಕೋವಿಡ್ ಅಲ್ಲಿ ಓಪನ್ ಮಾಡಿದ್ರಿ ಅಂತನಾ?
I am a patron of the bar, my lords.
Oh,
Post 10 o'clock, in violation of curfew, I am said to have been loitering there. And when they have tried to inquire from me, all I've said is, hey, you bloody police, come here.
You.
I think 353 anta ಸೇರಿಸಿದ್ದಾರೆ.
How can you say that? Were you normal or in an inebriated state?
They claim I was intoxicated, my lords. No
That's
medical.
inebriated state.
They claim, my lords.
Not in normal status.
Not in normal state ಅಲ್ಲಿ ಯಾರು ಹಿಂಗೆ ಹೇಳಕ್ಕಾಗುತ್ತೆ? ಅದು ನಾರ್ಮಲ್ ಸ್ಟೇಟ್ ಅಲ್ಲಿ ಹೇಳಕ್ಕೆ ಸ್ವಲ್ಪ he has to have some water with added minerals.
This is the allegation, my lords, specifically in the charge sheet.
Yes, sir. Whether that would amount to 353, sir.
353 attracts.
ಅಲ್ಲೇ ಇದೆ ನೋಡಿ 353 contents. With criminal intent, criminal force, usage of criminal force to deter a public servant from performing his duty.
Yes, my lord.
ಇಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ? ಅವ್ರು ಸ್ವಲ್ಪ ಅದು ಇದು ಹೇಳಿ ಕಮ್ಮಿ ಹೇರ್ ಅಂದ್ರೆ ಅಷ್ಟೇ. It's hurt your ego.
Please, ma'am.
ನೀವು ಹೆರಾಸ್ ಮಾಡ್ತಿರಲ್ಲ ದಿನ ಹೋಗಿ ಎಲ್ಲಾರ್ಗು. ಅದಕ್ಕೆ ವಾಪಸ್ ಒಂದೊಂದ್ಸರಿ ಬರುತ್ತೆ ಇದು. The petitioner is before this court calling in question. ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ ಇದರಲ್ಲಿ? ಹಾಕ್ಲೇಬೇಕಲ್ಲ ಮತ್ತೆ 353 ಹಾಕ್ದೇನೆ ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕ? Calling in question the proceedings in CC 15733 of 2022 registered for offences punishable under section 353/504 of the IPC and 51B of the National Disaster Management Act. ಯಾವ ವರ್ಷ ಅದು? 2015. Yes. Heard so and so. The issue lies in a narrow compass. The petitioner is said to be freely walking on the street at within the jurisdiction of the Kabban Park Police Station at about 10 p.m. 10:50 p.m. At which point in time the station house officer of the Kabban Park Police Station intercepts the petitioner and asks him why he was moving around at the time at 10:50 p.m. That too when night curfew was clamped in the area at that relevant point in time. The petitioner, who is alleged to have been in an inebriated state, has hurled abuse against the policeman by calling him quote unquote Alida. Come here, so and so. This becomes a crime, this becomes a complaint registered against the petitioner for offences punishable under section 504 and 353 of the IPC, read with 51B of the Disaster Management Act.
Original FIR, they lodged for 332 also alleging that I've hit them.
323?
332 also.
332.
They drop it subsequently.
For offence punishable, including the offence under section 332 of the IPC. The police conduct investigation and file a charge sheet against the petitioner for the offence punishable under section 353, 504 and 51B of the Disaster Management Act 2005. But therefore, while filing the charge sheet, the offence punishable under section 188 and 332 are dropped. The filing of the charge sheet has driven the petitioner to this court in the subject petition. The learned counsel for the petitioner submits that the abuse that is hurled against a public servant, the police in the case at hand, would not amount to the ingredients under section 353 of the IPC for it to become an offense for which a trial should necessarily be conducted. He would seek quashment of the proceedings as it is an abuse of the contending that it is an abuse of the process of the law if further proceedings are permitted to continue. The learned HCGP would vehemently refute the submissions to contend that the petitioner has spoken in the manner that would undoubtedly become section 353 of the IPC and has not permitted the policeman to perform his duty. Therefore, the petitioner is to necessarily come out clean in the trial. The learned counsel in the trial, I have given my so and so. Therefore, narrated facts are not in dispute as observed herein above. It lies in a narrow compass. On the night of
28/1/2022.
On the night of 28/1/2022 at about 10:50 p.m., the petitioner is intercepted by the jurisdictional police of the Kabban Park police station, due to which certain altercation appears to have happened between the police and the petitioner. The petitioner, who was admittedly in an inebriated state, is said to have hurled abuse to the police, which reads so and so. I'll mark in 48. Whether this would amount to an offense under section 353 is necessary to be noticed. For an action to become an offense under section 353 of the IPC, the ingredients that are found in section 353 itself need to be present. Section 353 reads as follows. Section 353 mandates that the public servant must be stopped from performing his duty by use of criminal force. The allegation in the case at hand is hurling of a solitary abuse as quoted herein above. This, in the considered view of the court, would not become an offense under section 353 for further proceedings to be permitted to be continued. The altercations between the two have led to the drawing up of section 504 also as an offense that needs to be tried. In the light of the offense under section 353 not being met in the case at hand, permitting further trial qua section 504 of the IPC would also become an abuse of the process of the law, for it also not meeting the ingredients as available under section 503 of the IPC. What remains is an offense under section 51B of the Disaster Management Act, since the curfew had been clamped on the night of the said day when the petitioner was caught by the police in an inebriated state. The offense under 51B is sought to be invoked. It is, in the considered view of the court, loosely invoked, as section 51B requires prior notice of 15 days to be given to the accused and then registration of the crime. Therefore, on all these counts, permitting further proceedings would run foul of all the provisions of law that are invoked for continuance of a trial. For the aforesaid reasons, allowed quashed.
The name of the petitioner may be corrected. It's always shown wrong in the cause list, my lords. In the order, reflect as is in the petition, not in the cause.
Jennifer, ಅಲ್ಲಲ್ಲ.
ಇಲ್ಲ, Alan Lopez.
Alan Lopez.
Lallan Lopez ಅಂತ ಬರ್ತಿದೆ cause list ಅಲ್ಲಿ.
ಏನ್ ಬಂದಿದೆ ಕಾಸ್ ಲಿಸ್ಟ್?
It's always coming as Lallan Lopez, even in the High Court
Lallan.
website. ಹೌದು.
Lallan.
ಹೌದು.
The registry is directed to correct the name of the petitioner as Alan Lopez in place of Lallan Lopez. ಏನ್ ಸಂಬಂಧನೇ ಇಲ್ಲ. Yes. Next. End of the list ಯಾವುದು? Mohammed Tahir. Tahir is here. What Tahir?
Civil dispute is going on between the parties.
Now why two-third, end of the list ಯಾಕೆ?
End of the list is, yes, the criminal under SCST Act has been registered. And lot of
Atrocities
issues-
Act. Yes.
The issue is
Bail
that lot-
ಸಿಗಲ್ಲ.
438 provision also in the, and kindly see that entire incident is recorded. And the petitioner is actually the victim. The family has beaten.
Recorded where, sir?
In the phone, Lordship. One person was there, he has recorded.
On the phone.
On the phone. And the photos, Lordship, it clearly exhibits that petitioner is the victim. Entire family is targeting. They alienate the property.
Photo
then
ಕೊಡಿ ಪರವಾಗಿಲ್ಲ, pen drive ಕೊಡ್ಬೇಡಿ.
Pen drive is also, entire video is
Madam.
there, Lordship.
Photo I will see.
Photos. I'm just providing photos, Lordship.
Yes.
After alienating the property, they had filed a case before the AC under PTCL Act. And that also stayed in before the DC court, Lordship.
There are allegations against,
Against whom, sir?
against the petitioner, my lord.
We'll see the allegation. Now will ಅದ್ರಲ್ಲಿ bail ಸಿಗಲ್ಲ ಅವ್ರು. Bail reject ಆಗಿದೆಯಾ?
Lordship can't be.
No, the whole problem I tell you is genuine cases never come up concerning the Atrocities Act. It is used as a tool now to threaten someone. That is why I entertain this petition. Just
354B is also.
Entire family.
ಅಲ್ಲ ಆಯ್ತು ಬೇರೆ see assault ಮಾಡಿರ್ಬೋದು, all assault. I will stay Atrocities Act, nothing, not all things.
Leave it on this honorable court because photo is to why even the wife is herself is assaulting.
Whose wife?
The complainant wife. In respect of which the 350.
Complainant wife ಅಂತ ನನಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತೆ?
That is their identity is verified, Lordship, in this entire incident. And the same day photo with petitioner are the victim. They have been targeted. They're heckled.
Yes, comment. You have not registered a crime?
No, Lordship, we have not.
ಮತ್ತೆ
2020 it has been registered, Lordship.
No, ಇದು ಯಾವತ್ತಾಗಿರೋದು ಇನ್ಸಿಡೆಂಟ್?
Recent, 2 days before only.
They have not registered the crime against the lady.
Lordship, before we could do it, this case was filed.
6 case is registered.
Against whom?
This case is registered on 6/6.
On 6th it has been registered.
6/6. True, but if what he says is correct, ನೀವು ಸ್ವಲ್ಪ ನೋಡ್ಬಿಡಿ.
Please, I have seen, man.
ನೋಡಿದ್ದೀರಾ?
No,
Photos I have not seen.
See the photos. They themselves assaulted. In the video, entire video is there. And this person is from Gujarat. He hardly speaks basic Kannada. In spite of that, all these allegations were, and the allegation was made in a nature, even by with
Gujarat, Rajshekar Shivaprasad.
No, Lordship, the petitioners.
Petitioners ಹೇಳ್ತಾ ಇರೋದು ನಾನು.
No, petitioner are Saddam, Sadiq, Lordship.
ಯಾವ್ದು ರಾಜಶೇಖರ್ ಶಿವಪ್ರಸಾದ್ ಅಂತಿದೆ ಇಲ್ಲಿ?
No, Lordship. And it's the wrong petition. Sajjad Hussain, Sajid Hussain.
Sajid Hussain.
ನಿಮ್ದು ಅದು.
Sajid Hussain. See, they are native of Gujarat. Now they are staying in Bangalore. They purchase the property, they alienate the property. After that, they file a case in PTCL, under PTCL. When they gone for cleaning the property, they created themselves a drama. Entire incident is recorded in a video. In spite of that, filed a case.
ಇನ್ನ 506, 323, 324 ಅದಕ್ಕೆಲ್ಲ 354B ಬೇಲ್ ತಗೊಳ್ಳಿ. This Atrocities Act I will stay.
Please.
Yes. ಅದಕ್ಕೆ ಬೇಲ್ ತಗೊಳ್ಳಿ, then we will consider later. The petitioners are before this court calling in question registration of a crime in crime number 160 of 2024, registered on 6/6/2024. Therefore, the petitioners are before this court even before the ink on the complaint could dry. what necessitates entertainment of the petition is what the petitioner has produced before the court as documents which would depict that the wife of the complainant herself assaulting every person on a property dispute between the two. The complainants being the members of scheduled caste or scheduled tribe, belonging to scheduled tribe, has resulted in the complaint so registered. The learned counsel for the petitioner submits that the petitioners are from Gujarat and do not even know that whether the complainant or the family would belong to either SC or ST. The perusal at the complaint would not indicate any intention of deliberate calling of name of the caste for insulting the caste by the petitioners, while all other offences alleged except the SC/ST would not require immediate interference by the hands of this court. Therefore, the offences punishable under the Atrocities Act alone shall remain stayed till the next date of hearing. 1 HCJP 2 emergent notice. ಬೇರೆದಕ್ಕೆ bail ಕೊಡ್ತಾ. Yes. ಇದು ನಿಮ್ದೇನಾ?
Appear for petitioner's counsel.
Shiva Prasad.
Some objection, my lord, regarding maintainability. My lord, what happened is, my lord, section 41A notice has been issued, my lord, without mentioning the crime number, my lord, the
ಏನ್
offences
ETV,
alleged.
ವಿಜಯ ಟಿವಿ, ಸಮಯ ಟಿವಿ ಏನಿದೆಲ್ಲ?
Lord, he was working as a, my lord, editor and he is a senior most journalist, my lord. Kindly see page 13, my lord.
Page?
Page 13, my lord, 1-3, annexure A.
1-3. ಏನ್ ಪ್ರೋಗ್ರಾಮ್ ಏರ್ ಮಾಡಿದ್ರಿ?
It is not regarding airing of a program. Allegation is, my lord, mentioned there. Somebody, my lord, kept a envelope where, my lord, some threatening letter has been written. For in that connection, my lord,
Somebody has kept envelope where?
that in parking area or something in
Parking area.
Yes, my lord. Kindly see, my lord. Page 13.
ಮದನ್ ಕುಮಾರ್ ಎಂಬುವರು ಈ ಎನ್ವಲಪ್ ಕವರ್ಗಳು ಬೈಕ್ ನಿಂದ ತೆಗೆದುಕೊಂಡು ಬಂದು ಫಿರ್ಯಾದಿಗಳಿಗೆ ನೀಡುತ್ತಾರೆ.
ಬೈಕ್ ಅಲ್ಲಿ ಎನ್ವಲಪ್ ಕವರ್ ಇಟ್ಟಿದ್ರು ಯಾರು ಅಂತ ಗೊತ್ತಿಲ್ಲ. ಅದನ್ನು ಮದನ್ ಕುಮಾರ್
ಅಪರಿಚಿತ ವ್ಯಕ್ತಿ ತನಗೆ ನಿಮ್ಮ ಹೆಸರು ಹೆಂಗ್ ಬಂತಿಲ್ಲಿ?
ಹೆಸರು ಇಲ್ಲ ಏನಿಲ್ಲ. ದೇ ಇಶ್ಯೂ 41A notice, my lord.
ಅಲ್ಲ ಹೆಸರು ಹೆಂಗ್ ಬಂತು?
It is very strange thing, my lord. And they are not providing the FIR copy. No crime number is given. My lord, there is a, my lord, judgment of the Delhi High Court which has been upheld by the Supreme Court and referred, where, my lord, directions are issued. How a 41A notice should be there? My lord, it should refer a crime number, the offences alleged. My lord, when we inquired in the court and even in the police station, my lord, they are not disclosing the crime number or they're not giving the.
You're a journalist.
I'm a journalist. But now, my lord, they are sending repeated messages, and now, my lord, one more notice has been issued. 2 notices. ಒಂದರಲ್ಲಿ
41 again.
ಹೌದು ತುರ್ತು ಅರ್ಜೆಂಟ್ ಆಗಿ ಬರಬೇಕು ಅಂತ. ಆಮೇಲೆ ಅದರಲ್ಲಿ
have it and tomorrow, my lord,
Why?
we'll take instructions.
ಅರ್ಜೆಂಟ್ ಆಗಿ ಬರಕ್ ಹೇಳ್ತಿದ್ದೀರಾ? ಟುಮಾರೋ ಅಂತ ಹೆಂಗ್ ಹೇಳ್ತೀರಾ?
And my lord, he
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ
in
ನಿಮ್ಗೆ?
WhatsApp he is insisting. He is
ಕಾಪಿ
also
ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿದ್ದೀವಿ. ಬೆಳಿಗ್ಗೆನೆ ಕಾಪಿ
ಕೊಟ್ಟಿದ್ದಾರೆ. We'll take instructions.
Lord, this is, my lord, it is covered by the judgment where, my lord, it should disclose the.
We'll look into it later. ನಿಮ್ ನಾಳೆ ಬೆಳಗ್ಗೆ ನಾಡಿದ್ದು ಬೆಳಗ್ಗೆ ಯಾವತ್ತು ಬೇಕಾದ್ರೆ ತಗೊಳ್ಳಿ. ನೋ ಪ್ರಾಬ್ಲಮ್. ಬಟ್ ಅರ್ಜೆಂಟ್ ಆಗಿ ಬನ್ನಿ. ಆಲ್ ದಟ್ police station is not a happy place to come, sir. Yes.
Got for interim order.
Where is the 41A notice?
No, that page
number 13.
1-3. Well, one
Page?
more notice issued is, my lord, we are placing it on record because it is served in the morning.
ಯಾವಾಗ ಇವತ್ತಾ?
ಹೌದು.
ಕೊಡಿ ಅದು ಕೊಡಿ.
ಅದರಲ್ಲಿ ಹೆಸರು ತಪ್ಪಾಗಿತ್ತು ಶ್ರೀಧರ್ ಅಂತ. ಐ ಡೋಂಟ್ ನೋ ಹೂ ಇಸ್ ಶ್ರೀಧರ್ ಅಂತ ಹೇಳಿದ್ದಕ್ಕೆ ಮತ್ತೊಂದು ಸರಿ ಮಾಡಿ ಕಳಿಸ್ತಾರೆ ಇನ್ನೊಂದು ನೋಟಿಸ್.
ಐ ಡೋಂಟ್ ನೋ ಹೂ ಇಸ್ ಶ್ರೀಧರ್ ಅಂತ ಯಾರಿಗೆ ಹೇಳಿದ್ರಿ ನೀವು?
ನಮ್ಮವ್ರಿಗೆ ವಾಟ್ಸ್ಆಪ್ ಮೆಸೇಜ್ ಅಲ್ಲಿ ನೋಟಿಸ್.
ನೀವು ಪೊಲೀಸ್ ಜೊತೆ ವಾಟ್ಸ್ಆಪ್ ಕಮ್ಯುನಿಕೇಶನ್ ಇದ್ದೀರಾ?
he is communicating, is asking me to share the live location.
ಲೈವ್ ಲೊಕೇಶನ್.
ಹೌದು. I'll place it on record, my lord, tomorrow. Along with the memo.
So you have copy today.
Copy of the report.
Which police station is this? Amrutahalli.
Amrutahalli police.
Yes, get this man before the court. Why does he want live location of everybody? Where is the crime registered? 41A cannot spring in air unless you register a crime. Where is the crime registered? Does he know basics of law or not? Or misusing his police power here?
Lord, parameters are laid down by the Delhi High Court.
Wait.
How a 41A notice?
1 minute. The petitioner claims to be a renowned senior journalist, is now knocking at the doors of this court, calling in question a notice issued under section 41A of the CRPC. The petition appends the 41A notice issued to the petitioner directing him to appear before the station house officer of the Amrutahalli police station, Bangalore city. The notice does not refer to any crime registered against the petitioner for him to be summoned. A bald summon notice under section 41A of the CRPC is issued to the petitioner. The learned senior counsel Arun Shyam, representing the petitioner, would submit that he has received another notice on the morning of today, directing him to appear immediately before the police, again without indicating any crime being registered against the petitioner. Without registering the crime against the petitioner, as found in section 41A, a summoning cannot kick in. The Apex Court in the case of Youth Bar Association, reported in 2016, 9 SCC 473, has laid down certain guidelines as to how the accused must be summoned. A person who is an accused must be summoned under section 41A of the CRPC. Adine follow matter Delhi High Court.
And FIR should be uploaded in the, that they have not uploaded.
The guidelines are found at paragraph 11. The paragraph 11 reads as follows. Paragraph 11 clearly indicates that the petitioner accused is entitled to the copy of the FIR even if it is not uploaded on the website of the jurisdictional police. The same is followed by the Delhi High Court by laying down certain guidelines as to how the 41A notice would
format is also given.
Would operate. None of these appear to have been none of these, even for their semblance, appear to have been followed in the case at hand. Therefore, the petitioner, there shall be an interim order of stay of the notice dated 6/6/2014 or any other notice issued to the petitioner in the aftermath of the notice dated 6/6/2014. List the matter on 14th at 2:30 p.m. The station house officer or the signatory to the 41A notice shall be present before the court.
Yes.
Illa Tuesday ತಗೊಂಡ್ at Wednesday.
Please.
List on 19th at 2:30 p.m.
19th inconvenience.
ಯಾಕೆ?
Some Dharwad matter date has been given today.
ಧಾರವಾಡ ಮ್ಯಾಟರ್
Yes.
ವಿಸಿಲ್ ಅಪಿಯರ್ ಆಗಿ
ಇಲ್ಲ ಅವರು
ಫಿಸಿಕಲ್ ಆಗಿ ಬರಕ್ಕೆ ಹೇಳಿದಾರ 20th. Yes.
Please.
Huh? 2:30 p.m. Thursday now. 21st ಆಗ್ಬಿಡಿ. Yes. ಕರ್ದ್ಬಿಡಿ ಅಲ್ಲ.
Office objection on maintainability may be overruled.
Huh?
Office objection on maintainability.
Why maintainability ಇರೋದು?
482 ಬರಲ್ಲ ಅಂತ office has raised.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕ್ವೇ ಮೇಂಟೈನಬಿಲಿಟಿ ಸ್ಟ್ಯಾಂಡ್ಸ್ ಓವರ್ರೂಲ್ಡ್ ಅಂತ ಬರೆದು ಆಮೇಲೆ
Great.
ಎಲ್ಲಿ ಸುಯೋಗ್ ಡೆಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಜಡ್ಮೆಂಟ್ ಕೊಡಿ ಅಲ್ಲಿ ಕೊಟ್ಟಿರಿ ಫೈಲ್ ಇರ್ಲಿ
53 ಅಲ್ಲ? I appear for the petition.
ಹಾ ಸರ್ ಎಲ್ಲ ವಿಲ್ when do you want interim order ಇದೆಯಾ?
Yes, my lord.
ಲಿಸ್ಟ್ ಆನ್
ಎರಡಿದೆ.
2nd 22 ಅಲ್ಲ ಇದು 2nd July interim order subsisting shall continue till the next date of hearing. Next matter ಕರಿತಾ ಹೋಗಿ ಮೇಡಮ್. What is this vacating stay? Who has filed government? No, I'll call case by case. Don't worry. Yes.
Government ಅಲ್ಲ sir.
Balakrishnan sir, ನೀವು ಹಾಕಿದ್ದೀರಾ vacating stay?
I heard for vacating stay.
This I heard that day. Ilva?
Not this.
Okay, then again same second interim order ಇದೆಯಾ?
Interim order. Sir.
Continue. 55 interim order ಇದೆಯಾ?
Yes, sir, last. Yes, your lordship.
ಇದೆಯಾ?
Petitioner may kindly be directed to serve me a copy, my lord.
ಕಾಪಿ ಕೊಡಿ.
ಇಲ್ಲ ಸರ್, I'll produce your.
ಎಸ್. ಆರ್ಡರ್ ಮಾಡ್ಬೇಕಾ?
ಇಲ್ಲ, I'll produce.
ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅದೇ ಆದ್ರೆ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ವೇಕೆಟ್ ಮಾಡ್ಬಿಡಿ.
ಇಲ್ಲ, ಈಗಲೇ ಕೊಡ್ತೀನಿ.
Yes. Same day, same order. Yes. Same order.
Petitioner in this.
Entry ಮಾಡಿದೆ ಅಲ್ಲ?
Entry ಮಾಡಲಿ.
ಇಲ್ವಾ?
Date
What-
may be fixed.
ಏನ್ offense?
Four 424, 74, 461.
Forgery,
Forgery.
cheating and forgery.
In the trial court matter is on 22nd and it's first week of July, date may be fixed.
22nd July ಗ ಇರೋದು.
22nd.
ಆಯ್ತು, 2nd July will have it. Yes. List on 2nd July.
57 appear for petition. In this case, matter is called by your lordship.
Madam. 15 matters ಅವತ್ತು ಹಾಕೋಣ. ಮಿಕ್ಕಿದ್ದು 9th ಹಾಕೋಣ. ಹಾ.
Department inquiry was exonerated, my lordship.
ಆಶು, ML ಜಯರಾಮ. Wait, 57. ಗವರ್ಮೆಂಟ್ಗೆ ಎಸ್ ನೋಡಿದ್ದೀರಾ? List the matter on Friday in the fresh matters list. We'll close it if it is covered. Yes, next. Tahir?
153 lordship, no stay is there lordship in this. Suo motu case registered by the police for the country.
List on Tuesday in the fresh matters list. Yes. ಇನ್ನೊಂದು ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ಲ ಅಂದ್ರಲ್ಲ ಇದರಲ್ಲಿ ಫೋರ್ಜರಿ ಕೇಸ್, ಬಟ್ ಎನಿವೇ ಅಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ತುಂಬಾ ಇದೆ. ಎಸ್, ನೆಕ್ಸ್ಟ್.
Entry order is sir.
ಸೆಕೆಂಡ್ IO. ವೆಂಕಟೇಶ್ ಅಲ್ಲ, ವೆಂಕಟೇಶ್ ದಲ್ವಾಯ್.
Compensation, retired government servant, pension settle ಆಗಿಲ್ಲ.
ಹಾ.
Some urgency in this matter.
ಇದು ಇರೋದ್ರಿಂದ ಪೆನ್ಷನ್ ಸೆಟ್ಲ್ ಆಗಿಲ್ವಾ? ಏನ್ ಒಫೆನ್ಸ್?
Malords, 465, 409 is a land acquisition officer, malords, for deputed to National Highway Authorities. Notification shows the name of one lady. Malord, award notice is given to her. Then compensation is paid to her. Thereafter, malords, some respondent number 2 files a complaint saying that no, I am in physical position, therefore I should have been given the compensation. That is the allegation. This malords do not take much time, lordship.
ಅದ್ರ
For
ಸೆಕೆಂಡ್
R2. R2 in this case, R2 is dead, your lordship.
complainant is dead. That doesn't kill the petition.
You have to go on merit.
It has to be decided on merit. State ಇದೆಯಲ್ಲ.
Some early lordships.
ಸೆಕೆಂಡ್ ಯಾವ್ದು ರಿಟೈರ್ ಆಗಿರೋದು ಯಾವಾಗ?
ಹಾಗಾಯ್ತು, 1 ವರ್ಷ ಆಯ್ತು.
ಹಾಗಾದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿ ಮಾಡಿ. ಲೆಟ್ಸ್ ಸಿ ವೆದರ್ he gets pension or not. 22nd ಬರ್ಲಿ. 22nd Saturday.
Yes.
Yes, next.
For the petitioner, my lords, stay this one. 498 father-in-law is before the court.
Stay ಇದೆಯಾ? Then 9th
Deeply.
IO. Yes.
306, your lordship.
ವೆಂಕಟೇಶ್
306, your lordship.
stay ಇದೆಯಾ?
Stay.
9th. Yes. IO will extract. Yes, next. Same 9th.
Stay this one.
9th, madam. 9th.
Appear for the petitioners count.
ಏನಾದ್ರು ತುಂಬಾ ಅರ್ಜೆಂಟ್ ಇದ್ರೆ ಹೇಳಿ, ಅದರ್ವೈಸ್ 9th it will come.
Okay, I'm sorry, it is 66.
65 ವಿನಯ್ ಭಟ್ ನಿಮ್ದು
ಇದೆ entry order ಇದೆ sir.
ಏನಿದು?
376N, that is a school teacher. All the allegation is against the school teacher's son. The entire family was dragged into the proceedings.
Okay, then ಅದು ಸೆಕೆಂಡ್.
Accused is not, accused number 1 is not before this.
HOD na?
Accused number 1 is.
Accused number 1, all right, yes. 65 second SJK, interim order.
66, my lord.
Yes, Murthy sir.
Second complaint, your lordship had quashed the earlier proceedings. After that, they have gone and filed the second complaint directly to the additional superintendent of police.
After quashing the first
Yes,
complaint?
after quashing, your lordship's order.
Interim order
Interim order is there. And the irony, my lord, is they then file a PCR. They approach the additional SP, non-cognizable offense. Your lordship has categorically quashed the earlier NCR on that ground, which was referred under 155(2). Subsequently, they approach the SP and additional SP directly and then file a PCR. The learned magistrate, my lord, first takes cognizance, then refers the complaint under 156(3).
Cognizance and refers?
Yes. That is the irony. Page 63 and page 65, your lordship's order is at.
We'll take it on second then.
Second.
Get ready.
Abatement to commit murder.
Abatement
on the MLA.
Huh?
Yes, my lord.
ಏನ್ ಅಬೇಟ್ಮೆಂಟ್?
Commit murder of
120B.
one MLA. That is the allegation.
We'll see on that.
120B 506 non-cognizable.
We'll see.
Yes, interim order is there.
ಇದ್ರೆ ಕಂಟಿನ್ಯೂ. ಹರ್ಡ್ ದಿ ಲರ್ನಡ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಅಂತ ಹಾಕಿ ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಕಂಟಿನ್ಯೂಸ್ ಸೆಕೆಂಡ್.
Grateful.
67, my lord, the IFF for petitioners. Lord, accused persons are all about aged 70, my lord, 67 years.
ಏನ್ 70 and 67 years.
ಅಲ್ಲ 75, 78 ಏಜ್ ಇದ್ದಾರೆ.
ಸರಿ ಏನಾಗ್ಬೇಕು?
Section 409, my lord, 465, 468, 471.
ಸೊ
ಅದರಲ್ಲಿ there is a connected case.
ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಇಲ್ವಾ?
Interim order ಇಲ್ಲ. Split up ಕೇಸು, my lord, the other is acquitted. Your lordship is covered by your lordship.
Split up charge sheet.
ಅಲ್ಲ split up ಮಾಡಿ ಇನ್ನೊಂದು ಕೇಸ್ ಟ್ರೈ ಮಾಡಿ ಅಲ್ಲಿ complaint has admitted, my lord, that there is nothing in it. Page 230, your lordship judgment covers the issue.
We'll see. Yes. Second.
Any earlier date can I expect? There is no interim.
ಮತ್ತೆ ಇದೇ ಆಗತ್ತೆ. Second. Because second ಯಾವ ಜಾಸ್ತಿ ಇಲ್ಲ. I'm posting all these matters on
Very
second. Yes.
Petitioner, my lord. Offense under significant.
Respondent.
Offense under
304.
4, my.
A.
Yes.
304.
304. Then yes. 9th.
There are allegations.
ನೀವು ರೆಡಿ ಇದ್ದೀರಲ್ಲ?
Yes.
ಅವತ್ತು 9th. Yes.
Petitioner.
Shanti Bhushan.
My lord is, may I request, the lordship is giving second, my lord. Passport renewal, my lord, I
You
mentioned
said
it
there
as-
is some urgency with regard to passport renewal.
He doesn't have time, my lord.
We'll take it on 20th.
20th.
Yes, list on 20th. Interim order ಏನಿಲ್ಲಲ್ಲ?
ಇದೆ.
We'll continue. Yes, next.
Great.
13 person. Malati. ಅದೊಂದು ಡೇಟ್ ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್. 9th ಹಾಕ್ಬಿಡಿ. ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ. ಓ ಇದೇನಾ ಅದು? ಕೊಡಿ. ಡಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ ಬರಲೇಬೇಕು. Quote all the orders and then next.
For the petition in this case, my lord. There
Interim
is
order,
no
yeah.
stay in respect of petition number 1, my lord.
Husband
Husband.
cannot be. So
ಅಲ್ಲ,
don't have to
ಗಮನಕ್ಕೆ
project
ತಂದೆ-
that at all.
ಗಮನಕ್ಕೆ ತಂದೆ kindly have it on 21st.
9th.
Please, my lord,
ಪರವಾಗಿಲ್ಲ
21st.
ಸರ್. ನೋ ಸ್ಟೇ. 2 ವರ್ಷದಿಂದ ಇಲ್ಲ, ಈಗೇನು ಅರ್ಜೆನ್ಸಿ?
21st, my lord.
9th.
Early in the list, my lord, 2 times, 3 times.
ಏನ್
was
ಮಾಡೋದು?
not
What
reached.
can I do? Yes. Next.
Petitioner, my.
Interim order ಇದೆಯಾ?
No, my lord, there's no interim
Can
order.
offense-
Offense is 420, my lords. I've repaid more than 60% of the amount which is.
40% ಕೊಟ್ಬಿಡಿ ಮಿಕ್ಕಿದ್ದು.
They will register, they have certain unpaid checks, my lord. They will, they
ಆಯ್ತು.
have the right to present it.
List on second.
Lords, interim order.
Interim order ಇದು ಇಲ್ಲ ತಾನೆ?
There's no
ಅವತ್ತು
interim.
ನೋಡು.
Lords, they are issuing notice, my lords.
Let them issue. Interim order ಇಲ್ಲ ಅಂದ್ರೆ ಇಶ್ಯೂ ಮಾಡೇ ಮಾಡ್ತಾರೆ. Next, yes.
74, my lord, there is an interim order in this case, 465, 468.
Your lordship, 74.1, I'm for the petitioner, your lordship. In 74.1, I'm the accused 3. In the petitioner, I'm the accused 3. I've not, my interim or my
There's no
interim
interim
application
order.
has not been considered yet, your lordship.
74.1 in the light of the interim order subsisting in the companion petition query the other accused. There
Notice
shall be an
ಆಗಿಲ್ಲ.
interim order in the case at hand.
Notice to
You will
second
dispute, civil
respondent.
suit ಹಾಕಿದ್ದಾರೆ next day.
Notice.
Second respondent ಗೆ notice ಹೋಗಿದೆ.
ನೋಟಿಸ್ ಮಾಡ್ತೀನಿ. ನೋಟಿಸ್ ಕೊಟ್ಬಿಟ್ಟೆ interim order ಕೊಡ್ಬೇಕು ಅಂತ ಇಲ್ಲಿ. Yes. Interim order. There shall be an interim order of stay of further proceedings query the accused in the subject petition. 1 HCGP, 2 emergent notice.
Much
24th ಅದು.
Can I
Yes, next.
expect a date here?
29th. 24 madam ಅದು. We have come to 24, is it?
74.
So listed on 11th.
Much obliged.
Yes, next.
That's for the petitioner, Mr. So Chota my lords is on his legs. My request for tomorrow, my lords, the reason is this.
ಏನ್ tomorrow ಯಾಕೆ?
My lords,
ನೆನ್ನೆನೂ
there is-
tomorrow ಅಂದ್ರೆ.
No, my lords, no, ನಿನ್ನೆ ಅಲ್ಲ, so it was
They've been
last week.
holding the badge of tomorrow every day.
My lords, no, my lords, this was listed last week.
Huh.
There is an undertaking given, my lords, for the respondent not to arrest, my lords, the petitioners. Now what is happening is, my lords, the independent directors who are not even residents of the country, my lords, are being issued 41A notice. The issue is, my lords, there were cases, my lords, which were to be transported from Karnataka, my lords, to Kerala. My lords, I was given half a day's permit, my lords. 30th was the expiry. 30th afternoon, I got the notice. My lords, they came back. I informed, my lords, the respondent saying that the cases are coming back, my lords, and
ಏನ್ ಇರ್ಲಿ ಬಿಡಿ, ನಾಳೆ ಬೇಕಾ?
ನಾಳೆ.
ಇಲ್ಲದ್ರೆ ಈಗಲೇ ಎಲ್ಲ ಮುಗಿಸ್ಬಿಡ್ತೀರಾ?
Sorry.
ನಾಳೆಗೆ ಆಗುತ್ತಾ ಮೇಡಮ್? ನಾಳೆ, ಎಸ್.
Sorry, my lords. That's the undertaking.
Go on and on, yes.
That's the undertaking may be extended till tomorrow, my lords, because they said they'll not arrest me. That's why, my lords.
Yes. Why is the Advocate General coming in? Wrong court ಗೆ ಬಂದ್ರು? ಅದೆರಡು ಇದೆಯಲ್ಲ, ಗೊತ್ತಾಯ್ತು. ಎಸ್. Interim order ಇದೆಯಾ?
There's no interim order. My lord, what
No
had
interim,
happened-
there's no interim order?
No, I'll tell you the court why.
There is
They
no
appeared without notice, that's it. There is no interim order. There is no. They appeared without notice. and
Friday.
Because he appeared as party in person.
Friday.
The fresh matters list in that.
Friday fresh matters.
Correct.
In the fresh matters list, yes.
My lord, seal number 70, my lord. Withdraw the petition.
70?
70, my lord. Withdraw the petition, my lord.
70, yeah.
70, 17.
Yaar, party in person?
ಇಲ್ಲ my lord. ನಾರಂಗೌಡ ಅಂತ ಹೇಳಿ 17.
17. Withdrawal ಆಗಿದೆ ಬಿಡಿ, yes. Next. Venkatesh Arbhat.
Interim order is there, my lord.
ಇದೆಯಾ? 9th interim order, yes. 11th, yes, 24. When are you hearing?
My lords, this matter, there's an interim order, my lords. May I have
ಇದೆಯಾ?
it?
11th. B group ಇದ್ಯಾವ್ದು ಕನೆಕ್ಟ್ ಆಗಿದೆ?
ಅದೇ ಓವರ್ಸೈಟ್ ಆಗಿ 80 ಕನೆಕ್ಟ್ ಆಗ್ಬಿಟ್ಟು ಬೇರೆ ಪಿಟಿಷನ್ ಕನೆಕ್ಟ್ ಮಾಡ್ಬೇಕು.
ಬೇರೆ ಪಿಟಿಷನ್ ಕನೆಕ್ಟ್ ಆಗಿದೆ?
80ಗೆ ಹಾಕ್ಬೇಕಾಯ್ತು. ಅದು ಮ್ಯಾಟರ್ ರಿಲೀಸ್ ಹಾಕೊಂಡಿದ್ದು ಯೂರಿಯಾ ಎಲ್ಲ.
ಆಯ್ತು, ಯಾವ ನಂಬರ್ ಕೊಡಿ ಕರೆಕ್ಟ್ ಆಗಿರೋದು?
ಅಲ್ಲ ಇದೆ ಬೇಗ 80 ಪಿಟಿಷನ್ 81 ಕನೆಕ್ಟ್ ಆಗ್ಬೇಕಾಯ್ತು.
81 required to be connected, my lord.
ಅಷ್ಟು ಹೇಳಿದ್ರೆ ಸಾಕು.
ಅಲ್ಲಿ ಇನ್ನೊಂದು ಕನೆಕ್ಟ್ ಆಗಿದೆ, ಅದು ಡಿಲೀಟ್ ಮಾಡ್ಬೇಕು ಸರ್.
ಆಯ್ತು, ಬೇಡ ಯಾವ ಡಿಲೀಟ್ ಮಾಡೋದು ಬೇಡ. ಎರಡು 22 and 24 ಅಲ್ವಾ? ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಬರಲಿ.
ಯೂರಿಯಾ ಎಲ್ಲ ಇದೆ ಸ್ವಾಮಿ, ಯೂರಿಯಾ.
ವೆಡ್ನೆಸ್ಡೇ
ಅಲ್ಲ ಮೊನ್ನೆ FIR ಇದ್ರು ಸ್ಟೇ ಇದ್ರು.
ವೆಡ್ನೆಸ್ಡೇ. ಎಸ್, ನೆಕ್ಸ್ಟ್
90.
82 ಯಾರಿದ್ದಾರೆ?
There is an interim order, my lord.
So
Any date may be.
further hearing, sir. List on 21st, 22nd. Interim order subsisting shall continue till the next date of hearing.
Please, my lord.
Yes.
Respondents.
This garbage.
My lords, I appear for one of the petitioners in this.
ಏನ್ garbage clearance ಈಗಾಗಲ್ಲ?
ಈಗಾಗಲ್ಲ.
ಅಂದ್ರೆ we will have to take it now, tomorrow or day after.
Then at least 18th, my lord. Or
Because
14th.
this has to get over, it can't lie down like this.
14th then, my lord.
Friday ತಗೊಳ್ಳ?
Friday.
Friday will fix it at 2:30 ಅದರ ಕೊಟ್ಟಿದ್ದೀನ ಮೇಡಮ್. 2:30 on Friday. Yes, all this entire garbage list, in the garbage list in the sense garbage cases list. Yes.
It's the same thing, man.
Yes, 84. ಏನ್ ಮಾಡಿದ್ರಿ? 84 and 85 both are similar.
85 is which one?
Even that
Manoj,
Nagmohan Das, Justice Nagmohan Das committee ಕಳಿಸಿದೀವಿ.
Manoj, 85 also.
85 also ಅದೇನೆ.
Oh, what the?
85, of course, the amount is few crore, hundreds of crores.
Manoj, insofar as.
But they have filed the objection by the Nigama. Almost they are admitted.
If you admitted the liability, Kaveri Niravari Nigam ಕೊಡ್ಬೇಕಾಗಿರೋದು. They have filed the objections admitting the liability. Then you said, I think, somebody else said, HCGP
So, in
said
fact-
Advocate General would appear.
In fact, in so far 84 and 85, Manoj, your lordship are having 2:30 on Friday itself.
Same time. Resolve the issue.
Please.
Otherwise, we'll pass some order for release of money at least.
Manoj, in so far release of money, Manoj. No.
They are admitting the amount, my lord, since
If it is admitted 50% release ಮಾಡಿ, at least let them breathe.
No, I'll get instruction, Manoj. In so far as at least the father.
Despite of the order, my lord, the para 12, they specifically say that committee has already.
No, we are not going on the committee, as I said, Manoj.
Wait, the Advocate General will solve the issue.
No, we are not going on the basis of the committee, Manoj. Now, in fact, I verified the number of bills, Manoj. On seniority, Manoj, all bills have been being.
They ಮಾಡಿ, even this 85 also.
I'll seek
There is an- ಅದು Kaveri Niravari Nigam, but
I'll find out.
some council appeared and said that you would appear.
I didn't, they have not informed me.
Plus, in 84 minutes, my lords directed that if the committee report is not filed, my lords, the payment will have to be ordered to be made.
No.
Ultimately, ನಿಮಗೆ ದುಡ್ಡು ಬರ್ಬೇಕಲ್ವಾ? Wait. See, it is easy for me to pass orders for them to take it in appeal and things like
I
that.
understand.
But if you want to resolve, we'll try to resolve.
Please, I'll vote on.
Please, Manoj, on
Both
14th.
84, see 84 and 85. 85 also the Niravari Nigam advocate, if last time I saw they have admitted, 50% release ಮಾಡಿ.
I'll just verify, I'll get instruction.
I think,
We'll verify.
Pimayana. Who appeared?
But KP channel appeared by panel advocate, my lord.
Who has filed? Somebody appeared.
No, we'll verify that.
Huh?
Prashant here.
Prashant BR. Yes, he said you would appear. I don't
Yes.
know. Yes.
We'll speak to him and call.
Yes. On Friday ತಗೊಂತೀನಿ.
Friday.
That's it, may come
Both
up,
I'll take.
may it come up on the admission list, my lord.
So, no, 2:30.
2:30.
The garbage and this both.
And 81 also, the tender BBMP, the
Aదే
tender.
garbage, that's
Garbage.
Ella 2:30 on Friday.
I'm grateful.
And we'll have to finish that on Friday, we'll finish it.
Please.
You get the senior counsel also be
Please,
ready.
please,
Yes.
please. He's the next court arguing, my lords, I'll tell him. We'll
ಯಾವ್ದು?
be late. Senior counsel is in the next court, my
No,
lords.
no,
He's late.
today not a problem. On Friday, we'll close it.
Please.
Yes.
My lords, in fact, have heard us extensively, my lords.
What?
My lords have heard us, my lords, and on the
In the garbage matter.
No, my lords, I'm
No,
not.
this
in the
I have
garbage
heard.
matter. Yes.
That he is also present.
Lords,
The AG himself is saying.
I'm
he will
only, my
resolve
lords,
it.
on my state, my lords, as somebody who has not gotten my money right now, my lords. Garbage matter, I have nothing to do with
We'll
it.
see.
Please.
See, passing an order is not a problem.
I
I will
understand.
definitely pass. But if there is some resolution to the list, it's happened.
Please.
But committee is doing nothing anyway.
No, that's why, in fact, after your worship, met the committee person, met the chairman also personally, Maros, because there are nearly 1 lakh bills which are pending. No, that is why, Maros, we'll just resolve, I'll just make my submissions on.
Please. Grateful.
Interim order subsisting in any of these cases shall continue till the next date of hearing, including garbage.
Great.
ಅಷ್ಟು ಅವರ ಯಾವ್ದು ಮೇಡಮ್? Why pass over? 22 ಅದು? Wednesday ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್. Interim order ಇದೆಯಲ್ಲ? List on Wednesday. The learned counsel appearing, counsel for the second respondent remains absent both in the forenoon and in the afternoon. List the matter on Wednesday. As a last chance, in the event he would not represent, appropriate orders would be passed on the petition. ನಿಮ್ದು ಅವತ್ತೇ ತಗೊಂತೀನಿ. ಎರಡೇನೋ
Interim order, man, we send it.
this 35 Friday in the fresh matters list, I will dictate. Yes, interim order subsisting will continue till the next date of hearing. 90.
Bring for the respondent number 2.
Oh, this 9,50,000.
9 lakh is the total amount, Swami. 3,06,000 is the bank transfer. Remaining 6 lakh
I
is
think
the
22.
gold ornaments.
Wednesday. List on Wednesday for admission.
Interim order.
Interim order subsisting will, ಏನದು?
It's a bank transaction.
I'll file it in the registry, it will come to the proper channel.
Please.
ಇನ್ಯಾವುದಿದೆ ಮೇಡಮ್?
This case. 498A, both parties are present. Complaint and accused number 2 is present. Memo, joint memo is ready to file. Please. He is accused number 2 and Tangi Gandaswamy.
Offense ಏನು sir?
498A.
Serial number.
Not at this hour, tomorrow. Where are they from?
They are from
Bangalore.
Bangalore.
ನಾಳೆ ಬರಕ್ಕೆ. Tomorrow 2:30. Respondent counsel ಇರ್ಬೇಕು. Complainant should be identified by a counsel. So tomorrow at 2:30. Yes.
Lion ಇಟ್ಕೋಬೇಕು.
Madam, serial number 78. Date and